Thank you, sir.
ಮೇಲೇನೆ ಇಡ್ಲ ಮೇಲೆ ಇಲ್ಲ ಕೆಳಗೆ ಹಾಕ್ಬೇಡ
ಮೇಲೆ ಇಟ್ಟಿದ್ದೀವಿ ನೋಡೋಣ ಫ್ರೆಶ್ ಅಲ್ವ ಏನು ಕೇಳಿದ್ರು ಹೇಗೇನು ಮಾಡ್ಬಿಡಿ ಬಿಡಿ ಅಲ್ಲೊಂದ್ಸರಿ ನೋಡ್ರಿ ನಿಮ್ಮ ಬ್ರಾಂಚಲ್ಲಿ ಇದೆಲ್ಲ ನಂಬರ್ ಹೇಳಿ
83 third list 83
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಇಟ್ಟಿಲ್ಲ ಲಿಸ್ಟ್ ಕೊಡಿ ಇವ್ರೆ ಒಂದು ಲಿಸ್ಟ್ ಕೊಡಮ್ಮ ಬರೀ
ಸಾಹೇಬ್ರೆ
ಎಲ್ಲ ರೀಸನ್ಸ್ ಬರೆದಿದ್ದೀರಿ ತಗೋ ಗೀಸ್ಕೊಂಬಿಡಿ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ
ರೀಸನ್ ಬರಿಬೇಕಾ ಮೇಡಮ್ ರೀಸನ್ ಬರಿಬೇಕಾ
ಅರ್ಜೆನ್ಸಿಗೆ ರೀಸನ್ಸ್ ಬರೀ
ಲಿಸ್ಟ್ ಮಾಡಿ ಪ್ರಿಂಟ್ ಮಾಡಿಬಿಟ್ಟು ಬೋರ್ಡಿನ ಪೇಪರ್ ಬಿಟ್ಟಿನ ಲೀಸ್ಟ್ ಎಲ್ಲ ತಂದು ಫಿಲ್ ಮಾಡ್ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ
ಕೊಡಿ 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 ಅಲಸ್ ಬನ್ನಿ ಕೊಡಮ್ಮ ಇಲ್ಲ ಸಂಜೆ ಬರಬೇಡಿ ಎಲ್ಲ ಉಳ್ಕೊಳ್ಳುತ್ತಿಲ್ಲ ಕೊಡಿ ಅಲ್ಲಿ ರೀಸನ್ಸ್ ಬರ್ದ್ಬಿಟ್ಟು ಕೊಡಿ
ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ ನಾಳೆ ಬೇಕಾದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ
ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಇದೆ
ಅಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಸುಮಾರು ಒಂದು 10 ಸಲ ಬಂದು ಇದಾಗಿದೆ ಅವರಿಗೆ ನೋಡಿ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಎಲ್ಲ ಕಟ್ಬಿಟ್ಟಿದ್ವಿ ಫುಲ್ಲು ಮೇಡಮ್ ಅದು ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ ಅವ್ರು
ಕಂಪ್ಯೂಟರ್ ಅಪ್ಲೋಡ್ ಆಗಿದೆ ನೋಡ್ಕೊಳ್ಳಿ ಸರ್ ಸುಮ್ಮನೆ
ಅದನ್ನು ಬರ್ದ್ಬಿಡ್ಲಿ ಎಷ್ಟು ಸಲ ಪೋಸ್ಟ್ ಆಗಿತ್ತು
ನಿನ್ನೆ ಲಿಸ್ಟ್ ಏನು ಹೇಳಿತ್ತು ನೀವು ಅದೆಲ್ಲ ಇಲ್ಲಿ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ ನೋಡ್ಕೊಳ್ಳಿ ನೀವು ಅಟೆಂಡ್ ಆಗಿಲ್ದಿದ್ರೆ ನೀವು ನಿಮ್ಮ ಜವಾಬ್ದಾರಿ ಯಾವ ಲಿಸ್ಟ್ ಏನು ಅಡ್ವೊಕೇಟ್
ಹೇಳಿ ಮೇಡಮ್.
ಈ ಲಿಸ್ಟ್ ನಂಬರ್ ಹೇಳ್ಬೇಕು ಇವ್ರೆ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ನಿಮ್ಮ ಹೆಸರು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ನೀವು ನಮ್ಗೆ ತೋರಿಸೋದು ಬೇಡ, ಲಿಸ್ಟ್ ನಂಬರ್ ಹೇಳಿ.
ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಪಿಟಿಷನರ್ ಅಡ್ವೊಕೇಟ್ ವಿಶ್ವೇಶ್ವರಯ್ಯ ಅಂತ.
ಇದಂತಿದೆ 2111 ಹೋಗಿದೆ. ಏನಾಗಿದೆ ಏನು ನೋಡ್ರಿ. ಹ್ಮ್ 39 ಇಂದ ಬರ್ತಾರಂತೆ, ಫೈಲ್ ಇದ್ರೆ ಬರ್ಸ್ಕೊಡಿ ಅಂತಿದ್ದಾರೆ. 39 ಅಲ್ಲಿ ಏನೋ ರಜಾ ಅಂತ, 39 ಸಿಟ್ಟಿಂಗ್ ಇದೆ. ಹ್ಮ್ ಎಲ್ರಿಗೂ ಡೈಲಿ ಅಟೆಂಡ್ ಆಗ್ತಾರೆ, ಗೊತ್ತಿದೆ, ಹಂಗೂ ಮಾತಾಡ್ತಾರೆ. ಅಲ್ಲ ಅವರು ಆ ಮೇಡಮ್ ಅಂತ ದಿನ ಹೋಗ್ತಾರೆ, ಅನಿತಾ ಮೇಡಮ್. ಹ್ಮ್
ಸರ್ ಮೆಮೋಸ್ ಬಂದ್ಮೇಲೆ ಕೊಡಲ್ಲ,
ನಿಮ್ಮೆದ
ಅಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್.
ಫ್ರೆಶ್ ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಇದೆ ಸರ್, ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿ.
DRT ಮ್ಯಾಟ್ರ್ ಅದಕ್ಕಿಂತ
ಯಾವ್ದಾದ್ರು ಅಷ್ಟೇ ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಇಟ್ಟಿದ್ದೀವಿ.
ಥ್ಯಾಂಕ್ ಯು.
ಫಸ್ಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು.
ಕಂಪ್ಲೈ ಆಗಿದೆ.
ಬಂತು. ಹೇಳಿ ಸರ್. ಈ ಟೈಮಲ್ಲಿ ಇಷ್ಟು ರಶಲ್ಲಿ ಕೊಡಕ್ಕಾಗತ್ತ ನನ್ನ ಕೈಲಿ ಹೇಳಿ? ನೋಡಿ ಒಂದೇ ನಿಮ್ಗೆ ಒಂದ್ ನಿಮಿಷ, ನಮ್ಗೆ ಇಲ್ಲಿ ತೆಗ್ದು ತಿರ್ಗಾ ಸೇರ್ಸ್ಕೊಬೇಕಲ್ಲ, ಫೈಲ್ ಜೋಡಿಸ್ಬೇಕಲ್ಲ. ಅಶ್ವಥ್, ಅದ್ಯಾವ್ದು ಫೈಲ್ ಆದ್ರೆ ಕೊಡಪ್ಪ ಒಂದ್ ನಿಮಿಷ. ಆ ಕಡೆ ಬನ್ನಿ, ಅವ್ರು ಒಂದೇ ನಿಮಿಷ ಹಂಗೆ ಕೊಡ್ತಾರೆ. ಇಲ್ಲ ಇಲ್ಲ 1 2 3 ಹಂಗೇನೆ. ಕೊಡಿ. ಅವ್ರು ಮೆಮೊ ಕೊಟ್ಬಿಟ್ಟು ಕಳಿಸ್ಬಿಡೋರು. ಮೇಲೆ ಡಿಸೈಡ್ ಮಾಡಿ.
ಏನು ಇವಾಗಲೇ ನೋಡಿ.
Twelve. Surface and 12. 12 ಅಲ್ಲಿ. Fine, you have to go there. ಹೌದು. No, surface is, here they are saying only GM DRT. I mean, that is pertaining to. They are saying that surface under it is here. ಇಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ. ಬಟ್ ಇಲ್ಲಿ ಬರೀ DRT ಅಂತ ಇದೆ. Yes, is good matter. Pending. I'm also saying story. Yesterday it was there. She said surface and See, I see the prayer. I see the prayer. I wanted to mention that here I have second. Here I have one mention. Let's see what we do. I waited for such a 5 o'clock I waited. You mentioned to the prayer.
ಸರ್ಚ್ ಮಾಡಿ ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡಬೇಕು ಯಾವ ಸಬ್ಜೆಕ್ಟ್ ಏನಂತ. ಕೆಲವಿದೆ ಅದು ಯಾವುದು.
I'm just checking the circular. That is what I'm just watching the circular. No, not that circular. Circular. ಇಲ್ಲ, circular ಬಂದಿದೆ. I'm checking that. Section 1417. Okay.
ಸ್ಲಿಪ್ಸ್ ಇಟ್ಕೊಂಡಿರಿ ಯಾರನ್ನ ಮೆಮೋ ಕೇಸ್ ನಂಬರ್ ಎಲ್ಲ ಹೇಳ್ತಾರಲ್ಲ.
Circular. Yeah, right. Directed to henceforth the reputation filed against the proceedings arising out of surface act. Proceeding out of surface act shall be classified as GMDRT and post the same before the respective post. Henceforth. Pending. So 23.
ನಾವು 2:30 ಇರೋದು ಲಿಸ್ಟ್ ಅದು ಇಷ್ಟೇ 2:30 ಇರೋದು 2:30 ಬನ್ನಿ. 2:30 ಬನ್ನಿ ಮೇಡಮ್ ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ. ಅದೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ. 2:30 ಕರೀತು ಬನ್ನಿ. ಫೈಲ್ಸ್ ಬರೀಲಿ. ಫೈಲ್ ಇನ್ನೂ ಬಂದಿಲ್ಲ. 12 ಗಂಟೆ ಹಂಗೆ ಬನ್ನಿ. ನಮ್ಮ ಇವ್ರು ಇದ್ದಾರಲ್ಲ ಅಶ್ವಥ್ ಗೊತ್ತಾ, ಫೋನ್ ಮಾಡ್ತೀನಿ ಬನ್ನಿ. ಫೈಲ್ ಅಲ್ಲಿ ಚೇಂಬರಿಂದ ತರ್ಬೇಕು. ಹೋಗಿ ಬನ್ನಿ. ಇಲ್ಲಿನ ಫೈಲ್ ಬಂದಿಲ್ಲ. ಬಂದ್ಮೇಲೆ ಬರ್ಬೋದು. ಏನು ಫೈಲ್ ಬರೆಯೋದಷ್ಟೇ. ಕೇಸ್ ನಂಬರ್ ನೋಡ್ಕೊಂಡು PCR ಇದ್ರೆ telecast TCR ಅಂತ ಬರೀತಾರೆ. ಗೊತ್ತಲ್ಲ?
ಹೌದು ಸರ್.
ಎಷ್ಟು ನಂಬರ್ ಬರೆಯೋದು? ನಾನು ಇದು ನೋಡೋದು ಏನಾದ್ರು ಬೇರೆ ಏನಾದ್ರು connect ಆಗಿದ್ರೆ connected number.
Hence,
ಸರಿ ಸರ್. ಓಕೆ ಅದೆಲ್ಲ ನೋಡಿ.
now,
Okay.
then we have to take this number.
ಫೈಲ್ ಬರೀತಂತೆ. ಫೈಲ್ ಬಂದ್ಮೇಲೆ ಯಾಕಂದ್ರೆ
Then we have to take same story apply tomorrow. We will take this as fresh income. Maybe she's.
23 metro ಇಲ್ಲ ಅಲ್ಲ GMDRT ಎಲ್ಲ ಇಲ್ಲಿ ಕೊಟ್ಟಾಗ whether old or fresh everything comes ಅಲ್ವಾ?
23 subscription is pending.
May I make one submission?
All motion slips to the court officer. Yes, call the list.
My lord,
Submission
it's
regarding to RPFC
Look into
matter.
it. I'll look into it. Yes.
Because it was a date given matter, but when it was not listed.
Ask the court officer. Ask the court officer why it is not. Yes.
Submission list number.
My lord, it is for 2:30.
No 2:30 matters. No 2:30. Everything can wait till tomorrow. If it is urgent, we'll take up tomorrow. Write the urgency on the paper,
Please.
on the memo. I'll look at it at 1:30 and give the dates.
Please.
Just call the list.
Due to my
Number one,
health reason,
page-wise
I want
adjournments.
adjournment.
Page wise ಕರಿತೀವಿ.
Health reason, I want adjournment.
Please wait, sir.
Call, they will call the list.
List number 1, adjournments if any.
My lords, list 1, serial number 15, my lords, I appear for the petitioner.
Page number 2, number 6, page number 3,
Yes.
7 to 10.
Serial number 9, kindly have it next week.
Serial number
9.
in first list.
Respondent has to file wakalat. So kindly have it.
List time for the,
9 is coming up for the first time.
no, it was listed yesterday. Lord had opined that petition should be allowed because opportunity was already given in the first instance at Mandya court, please, my lord. To examine the doctor, please, my lord.
Oh, are you referring to serial number 9 in first list?
Yes, please.
You are also seeking adjournment in serial number 9.
I am for the,
It was adjourned. Why you are asking time again?
The wakalat has to be filed for respondent.
What we can do if your wakalat
Kindly
is
have it
not,
next week.
why? Yesterday it was heard.
Respondent is not well, so that is not send the wakalat. Kindly-
Because I said I'm going to allow it, now it is adjournment for that. This is matter 9 as part heard on Wednesday.
please.
Yes, yes,
Page number 4, 11 to 15.
yes, you're saying something.
Serial number 15, my lords, I appear for the petitioner.
Hmm.
I have to file some documents, my lords, in respect of the.
Have you informed the other
Yes,
side?
my lords, other side. is-
Yes, when do you want?
Any date, my lords, next week,
List the matter on
13th of,
20th of November.
please, great.
Yes. Next list.
List number 2, page number 1, serial number 2, list number 3,
Yes,
page number 2, 3 to 7, page number 3, 8 to 14, number 4, 15 to 20, page number 5, 21 to 25, page number 6, 26 to 28, page number 7, 29 to 34, page number 8, 35 to 40, page number 9, 41 to 45, page number 10, 46 to 51,
50, my lord. Kindly next week, my lord.
Hmm?
It's not keeping well, my lord. I'm for
50.
appellant.
Why you want adjournment?
Not today is not keeping well, my lord.
This is matter in the month of December. Yes, next.
page number 11, 52 to 57, page number 12, 58 to 63, page 13, 64 to 68, page 14, 69 to 72, page 15, 73 to 78,
73 millers. TCR is awaited millers.
73,
millers.
is it required?
It's because millard, it's a remanded matter. The trial court has not quantified the amount.
Hmm.
I am ready millard. But the court
Which
has
is this,
ordered
which is
the-
this insurance company? Royal Sundaram. Mr. Ravi S. Samprati is directed to take notice on behalf of the respondent. Already somebody is appointed. It's for R1 Ravi Samprati, petitioner and counsel for the appellant. She has the copy of the appeal memo on the council. This is matter on once TCR is already here, no?
DD file, madam, not TCR.
3073. Royal Sundaram R2, Mr. Ravi Samprati, she shall serve the papers. This is matter after the TCR is received. Please. Yes. Next.
Page number 16, 79 to 84. Page 17, 85 to 86.
My lords, for appellant counsel is not getting
85.
85. Kindly.
Yes, at request in the month of December. Inform Mr. Betsu. Yes.
List number 4.
Yes, all orders matters not required. Yes, list number 5.
List number 1, my lord. Not feeling well. List number 5, serial number 1.
List number 5.
5. Not feeling well. 2 weeks. I underwent angioplasty. Needs 2 weeks time.
Have you informed the other side council?
Rajendra is.
They were pressing for.
It is for admission only, my lord. There is no interim order or anything.
List this matter in the month of December. Delete from the caption for dismissal. Yes.
It is 230.
Yes, call the list.
List number 1, for dismissal, serial number 1, Ravi Shankar TP.
And for the respondent for petitioner,
Yes.
as per corrected direction from this court, the doctor has filed his report for evaluation the daughter. On 30th of October, he filed.
He filed.
Yes. Along with speed post and email, through email.
Where is that? Is it in the file?
Yan file,
Doctor's report.
Doctor's report. Not yet, sir.
30th of October. 31st.
Not yet.
District is directed to put up the report sent by the councillor. This is matter on Thursday. Delete from the caption dismissal. Yes, next.
List number 2, Vinita PC.
I appear for petition. Lordship, in this matter, the needful has been done. Needful has been done. Now, the thing is that last occasion also I have submitted. Neither in the trial court nor here, she's not coming forward. And the advocate, she has changed 4 advocates. And last time also I have submitted to the court. And this is a matter where she has.
Petition shall serve the hand summons on the respondent.
I'm unable to, Your Lordship.
Counsel also not there.
Not there. Nobody is there. And in fact, I informed my client just to intimate her, and she, even though he has intimated to her, she.
No. What has happened to the earlier 2 notices that were sent?
She is not. Earlier, there was a counsel who was representing, Your Lordship, and last occasion the counsel came and the previous, he came and told before this honorable court only that they have given NOC. But they have not produced anything, acknowledgement or anything before this honorable court for having stated that they have given NOC. And in fact, Your Lordship, I have submitted on the last occasion also. She entered into an mediation agreement. She took the DD. And in the second round, when the matter called up for entering in the order sheet, she never turned up. And not a single day she will come to the court, Your Lordship. This is what the order sheet, it is.
Argue the matter.
Yes, please, Your Lordship.
Yes.
Lordship, here petitioner has challenged the execution petition. The impugned order, Your Lordship.
Yes.
Annexure K is the impugned order, Your Lordship, at page number 64, the issuance of a warrant that has been challenged, Your Lordship. And as per the interim order, I have deposited the 3 lakhs.
Let me see, 50?
Yes, please. 64 is the execution order sheet. Annexure K. The typed copy is at page number 72, Your Lordship. And in fact,
So where is the order?
order is here, Your Lordship. That is issuance of the issue arrest warrant against the
Where is
judgment debtor. Process fee is page number 70, Your Lordship.
Yes.
Accordingly, I have challenged that before this honorable court. In the meantime, before that, there was a mediation agreement.
No, what we do now?
Please.
What is wrong with this order?
No, because she has entered into a mediation agreement.
Whatever it is.
Yes.
You have to appear before the court.
No, I am appearing, Your Lordship.
As
Then
per the report
subsequently
of the
that,
bailiff, the door of the
subsequently
residence of the JDR is locked.
no, subsequently after this petition is filed and
We are not concerned with after the petition is filed, what happened. We are only concerned with what has happened, why the court has passed this order, whether this was right or not.
that was, Your Lordship, because the matter was before the mediation.
So you will
The
not.
main, the main petition, MC petition, was before the mediation, and the mediation was going on. That time, Your Lordship, she came forward.
Are you aware of the execution that's filed by them or not?
I was aware, Your Lordship. That is where these matters were going together in the order sheet.
Please come to the proceedings.
Yes, please.
Come to 10/2/2021.
Pardon, Your Lordship?
10/2/2021, order sheet. At page number 67.
Yes, please. Yes.
Bottom.
Yes. DHR is present, JDR is absent in spite of giving sufficient opportunity. Objections to main petition is not filed. Therefore, objection to main petition is taken as not filed. Issue arrest notice to the JDR returnable by 12. Yes. This is because, Your Lordship, the mediation was in the main MC petition was on. That is the reason, Your Lordship.
So when the execution petition is filed, you are supposed to go before the court and tell the court. Because something else, some negotiations are going on, you will not keep quiet and say that the order of the court is back.
No.
It's your duty to appear before the court.
I agree with Your Lordship, but the substantial amount was already paid, Your Lordship. A memo of calculation.
That's not the reason. That's not the reason at all. Yes.
The memo of calculation was also, and there were other 2 cases. All the cases were referred to the mediation, GNWC and all these things. Habeas corpus was there, Your Lordship.
That revolves around the same submission.
No, I mean, only the submission is that, Your Lordship. The daughter, I mean, now who's in 11th grade, Your Lordship.
These are all on the merits of the matter. No, wrong. The order that is impugned is issuing of the arrest warrant. The court has no other alternative but to issue it because
subsequently, I have appeared before the court.
You have only questioned that order dated 24/9/2021. So there is nothing wrong with that order. If you don't go to the court, court will issue arrest warrant.
That the only reason was that, Your Lordship, because the matter was before the mediation. I'm sent out for mediation. That is the only reason.
Yes.
I would just leave it to Your Lordship. That is the submission I've just.
Yes.
And he has deposited 3 lakhs also before this honorable court.
What is outstanding?
Absolutely no, that I have filed a memo of calculation because whatever I have given and she has not come forward to give a memo of calculation. Absolutely nothing. She comes and takes the money and goes. And even now, there is what I have deposited before the court. That is also she has not withdrawn. It is there in the court itself.
Please come.
And she is not coming forward to settle the matter also, and she is not attending the matter also before the family court.
You are not entitled for an interim order in this case, to be precise. The present petition is filed. Questioning the order dated 7/8/2021 and 24/9/2021. where the court has issued an arrest warrant. In execution petition number 241 by 19. And also sought a direction to quash the proceedings in execution petition number 241 of 2019 before the third additional principal judge, Family Court. It is a case of the judgment debtor that in view of the differences between the parties, the petition has filed a petition before the divorce petition before the Chitradurga court. Thereafter, it was transferred to the Bangalore Family Court. The wife had filed criminal miscellaneous number 62 of 2014, seeking maintenance before the 5th MMTC Bangalore. As the wife is not permitting the petitioner to meet the child, the petitioner has filed JNWC number 236 of 2014, seeking custody of the child. Then an IA came to be filed by the respondent, IA number 6, under section 24 of the Hindu Marriage Act, seeking maintenance of rupees 1,25,000 towards the monthly maintenance and educational expenses of the minor child in the MC number 3391 of 2014. And the court has allowed the application and directed the petitioner to pay monthly maintenance of rupees 40,000 from 5/12/2015. And that order was challenged by filing WP number 47420 of 2017 before this court. And this court had modified the order and directed the petitioner to pay 25,000 before 5th of every month. The respondent had filed WP number 29694 of 2017, seeking modification of the interim maintenance order. And both the petitions were taken up together and were dismissed on 27/2/2018 and come from the order dated 7/11/2016. Thereafter, the respondent has filed the execution petition number 241 of 2019, claiming arrears of 19,15,000. It is the case that she herself has stated that he has made the payment to the tune of rupees 7,24,000. It is stated that subsequently the MC number 3391 of 2014 was brought before to the mediation on mutual consent. In the mediation, both the petition and the respondents have agreed to the mutual consent. One of the conditions was the petitioner should pay the respondent towards final settlement in amount of rupees 5 lakhs, which he has paid by account transfer, and the other part of 40,000 he has deposited in the court, and also taken a draft of rupees 3 lakhs for the balance amount. She has taken the demand draft of 3 lakhs and she has never turned in the second half when the case was called. It is stated that the respondent has not even come forward to examine the petitioner. When she has filed the execution, as the matter is under the mediation, it is the case of the petitioner that the petitioner has not appeared before the executing court. As such, on 7/8/2021, the court, having observed that both counsel and decree holder are present, advocate for judgment at our pace time. On perusal of the record, the present EP is filed for the recovery of rupees 12,26,000. So far, the judgment debtor has paid only rupees 50,000. No valid reasons made out to grant further time for payment, and accordingly issue the arrest warrant. Again on 24/9/2021, another order is passed wherein it is observed that Counsel for DHR filed IA under Order 21 Rule 37 of CPC. As per the report of the bailiff, the door of the residence of JDR is locked. Issue arrest warrant against JDR with the aid of jurisdiction police, returnable by 12/11/2021. Land Counsel appearing for the petitioner submits that the only reason for the petitioner not to appear before the court that the matter is pending before the mediation. It is submitted that in fact, he had paid the substantial amounts. Further, the paid the substantial amounts. Further, the petitioner had
I
paid the
produced the memo
substantial.
of calculation. I have produced the memo of calculation.
Had paid the substantial amount. Further, the petitioner, it is submitted that the respondent is not appearing before the court. And she has changed several counsels. Even before this also, the counsel who filed wakalat has stated on the earlier occasion that he has given up the wakalat. It is submitted that it is submitted that the respondent who has taken substantial amount and who has entered into a agreement before the mediation. Now she has taken a U-turn and filed the execution petition and also not pursuing the same. It is submitted that the amount that is deposited by the petitioner is still lying in the court and she has not even withdrawn the same.
Lordship, kindly one submission. The daughter to whom that maintenance was ordered, Your Lordship, she is with the father from the day one. And now daughter don't want to go to mother. And all the school fees and everything father is
You
bearing.
filed GNWC and you say that.
No, that is correct, Your Lordship. That is because in terms of mediation agreement, she has agreed. And daughter, even before the habeas corpus matter, the daughter was summoned. I mean, here they interacted with the daughter and she clearly told to the court that she don't want to go to mother.
When is that? That is before GNWC or after GNWC?
After GNWC. I have mentioned that. After
You submitted
GNWC.
that. In fact, the maintenance all that is sought is to the daughter and the daughter from the date of mediation is with the father. Next para.
At present also
For
she
this
is with father.
Earlier, the earlier on, what is the date?
I just.
On what is the date when they said that they have given up wakalat?
Pardon, Your Lordship?
They have given up wakalat. When was that?
That I mean, they have submitted on the previous, I'm sorry, Your Lordship.
On 28/7/2025, the counsel appearing for the respondent submitted that he has given up wakalat. And from that day, the respondent had not taken steps to engage the advocate. Hence, this court is proceeding to.
Respondent, Your Lordship, not.
Respondent is proceeding to pass orders on the merits of it. Considering the fact that the parties before the mediation, they have entered into an agreement. And in the light of the said agreement, the petitioner has parted with the amount. And also, the girl is residing with the father for whom this application is filed, seeking maintenance. This court deems it appropriate to set aside that order. However, there is no illegality with the order that is passed with the court, as a petitioner has failed to appear before the court when the order is passed. Only considering the fact that the parties have entered into the mediation and the fact that the daughter is staying with the petitioner, the order is set aside and the matter is remanded back to the trial court. The petitioner shall appear before the trial court on November 26th.
Lordship, the daughter's exams are going on November 24th to 30th, Your Lordship, maybe in between, because she's in a residential school where he has to go. I mean, far from Bangalore.
He shall appear before the court on December 10th.
Please.
Yes.
The 3, Anand Mutalli.
I appear for the petitioner in this matter.
Where is the
Not for
list?
the respondent, my lord. We undertake to file the
Yes, please.
wakalat.
Yes, what is this? Any interim order?
No, my lords.
Huh?
There's no interim.
Non-filing of legible copy of annexure CD.
My lords.
Office objections.
My lords, office objections are overruled on last date of
This
hearing.
is a fresh office objection.
My lords, that was, a memo was filed on 3/6, my lords. In that, the respondent advocate's name was not mentioned.
Non-filing of legible copies of annexure C and D. What is annexure C and D? Please look at it.
My lords, annexure C is the
Page number?
page number 32, my lords.
What is a legible copy?
My lords, it was overruled on last date. Thereafter, only the hand summons was issued.
Where is that order? It is submitted that the office objection at serial number 1 with regard to furnishing of legible copy of annexure C and D is complied with.
Yes, my lords.
Typed copy of the manuscript portion of annexure D and shall not rely on the same. Therefore, the said office objection is overruled. When did you comply with this annexure C and D?
On the day before that only, my lords.
Then why they have rectification of office objection? Now anyhow she is appearing. The office objections are overruled. The so-and-so submits that. They have instructions to file wakalat on behalf of the respondent. This is matter on November 14th. Yes,
Please, my lords.
next.
The 4, Mahesh Chaudhary.
Appearing for the petitioner,
in this case,
the respondent was to file an affidavit.
Affidavit, Your Lordship, as per the direction.
Where is affidavit?
He's filing it, he's giving it over the counter
Filing
today, your
affidavit.
lordship. And he's not served a copy. This is the conduct of the respondent because I don't have an
Take
interim
it,
order, your
take
lordship.
it. Don't have to complain for everything. If you require, I'll grant you time.
Your lordship, I'm ready to argue the matter on merits, your lordship. The affidavit is to be filed because I had
You don't
placed a-
even know what are the contents of the affidavit. You say I want to ready to argue on merits. Read it. What is the great urgency?
Your
I'll have it
lordship,
tomorrow.
because the counsel for the respondent and the,
I'll have it tomorrow. Read it. The counsel for the respondent, as per the order dated 28/10/2025, has filed the affidavit and served a copy on the petitioner. The request of non-counsel, the petitioner lists this matter tomorrow. Yes, 5.
5, serial number 5, Somnath.
I appear for the petitioner mother, my lord. An office objection regarding the maintainability of a single writ petition challenging 3 IAs have been raised, my lord. But in this matter, the trial court has clubbed 5 IAs together and passed a common order, my lord.
So on all the 5 areas, result is 1? No.
No, my lord.
Then?
But the order is the same, my lord.
It's the same. Here
We
the
have challenged.
Here, it is a difficulty of the court.
Yes.
Now, what is happening is 3 IAs you question, 1 IA in your favor, 1 IA against you.
Yes.
Ultimately, when the order has to be passed, that is what is, now Court wants to pass, allow only one IA.
Yes, ma'am.
So you have to file 3 different writ petitions for the 3 different IAs if you're seeking, if you're assailing 3 orders, 3 IAs, or aggrieved by 3 IAs. Office
Yes,
objection
ma'am.
with regard to the maintainability is upheld. The petition shall comply with the same. Yes. Next 6.
Obliged.
6, Smith voted.
Please. Respond.
Yes.
On the direction, this honorable court.
Petition of 2023, interim order, all these, it's pending till now, and every day some memo or the other will be filed. And what happened to the MC? MC is of which year?
20, MC is 22. Along with this same
When is the impugned
pending,
order?
that is for restitution I had sought for MC. In this case, this is a petition under section 125.
Where is?
Please, Malot, I'm for
Where is the order?
Malot, the order is at page Malot, 50 Malot.
Page?
50 Malot, annexure D, and the operative portion is at Malot, pages 71 Malot.
The respondent husband is directed to pay monthly maintenance of 20,000 each to petitioner 1 and 2. That's 40,000.
Please.
And litigation expenses of 30,000.
30,000. And the IA sought is 3 lakhs maintenance Malot and 1 lakh towards a litigation expense.
Whatever it is, court has granted
20,000 each Malot.
40,000. What
Please.
is your income?
Malots, my income is now, as on today, my income is 72,000 Malots. I'm aged 62 years. And Malots, I've now left with 2 houses, Malots, which the rent is being derived from one of the house. And out
What
of
is
that,
the
Malots,
age of the child?
Malots, she is now studying in PUC,
First
Malots.
PUC.
First PUC. And I am paying regularly, I'm paying her whatever the educational expenses are there, Malots, I'm providing that, and whatever the expenses, they are in good terms, Malots, to be, Malots, the petitioner and respond number 2 are in good terms, and whatever she requests, I'm providing that, Malots.
So this order includes educational expenses or excludes education?
Including.
Malots, but I'm not deducting that, Malots, I'm paying it
So
separately.
how much you're paying towards educational expenses?
Malots, that I'm paid around whatever the fees comes, Malots, it is around 1.5 to 2
Submission,
lakhs.
whatever is.
Malots, 1.5 to 2 lakhs.
Is it correct? He's paying 1.5 to 2 lakhs?
He has paid.
That's not.
Then he would adjust it towards the maintenance. Then every time whenever I had to submit before the court, he has not paid the maintenance, then he will pay. And in fact, when I moved this application.
What are the educational expenses of the child per year?
Per year, my lord. But I have produced about 1.5 lakhs, my lord.
You can tell what is the amount.
Yes, my lord. 1.5 lakhs, my lord, in the petition. 1.5 lakhs. I have produced along with my. No, how to do memo.
So 18,000 itself comes to per month.
For education.
For educational expenses. So the court order remaining is about, it's 40,000.
20,000 each.
40,000.
40 out of 40, 18 is.
He's already paying 18,000. And he should, we will clarify that. He should pay the educational expenses, whatever it is. So now the educational expenses will increase, will not decrease.
Yes,
by the
madam,
time she is
because she is
going
already
to
in
the
college.
higher classes.
Yes.
So another 22,000 we'll ask him to pay, apart from the educational expenses.
That won't be sufficient. For this simple reason, I will tell, my lord, why I need it.
Have you filed any appeal, or have you questioned this order?
That is what I have filed the writ petition. My application also, my petition also is before
Where
this
is
court for enhancement. It is clubbed, my lord. It is coming along with
6.1.
My lord, I have produced. In fact, I may submit. When he says that his income is 72 lakhs, he does not show any, source from which he is coming 72,000. And his affidavit which he has filed before the court, annexure R1 he has filed before this court, his expenditure is 71,000. But he had not produced the bank statements at all before the trial court. But on the last occasion, the previous occasion, I have made a submission with this honorable court. He has not furnished the bank statements. He only said he has got loans. But which loans he has not specified. What is the loan? He says 3 crores is the loan. His income is 72,000, but he says he is incurring a loan of 3 crores. He has not produced. He has not been very fair to this court. Nothing. What is the so why the loan is state? Then he has produced after this honorable court has admonished him that the statement has to be filed. When the statements are filed before the court, he has produced 4 bank statements. 4 bank statements. If I may request your lordship, kindly see the statement which the petitioner has filed.
Yes.
On 29/8/25. My lord, I have made a synopsis. In the last occasion, I have furnished before this honorable court a synopsis. My lord, one is
where is the synopsis?
the last time I have produced some last time.
Date of filing.
Date nodi the last.
Yes.
Lordship got money.
Yes.
One bank statement is of Hosur, Atibugam, that it does not show the entire statements. Then another one, he has produced the Bank of India, Rahmat Nagar, Bangalore, account number transaction is running into lakhs. I will not make it because that is also running into lakhs. The other one, there are 2 certificates are issued in respect of 2 transactions, 2 bank accounts. They are opened in 20 and 24 it is closed. Those statements are not before this court. Those statements are not before court, only the certificate. Now the last one, Axis Bank, he has produced the statement. Now if the bank statement is taken, my lord, for the year 2018, the next page, if your lordship see, I have made for the transactions. For the year 2018 to 19, my lord, 1 crore 39,000, 90,000 is the transaction for 1 year. That is for 2018-19. My lord, from for the year 2019-20, 63 lakhs and odd. From 21 is 2 lakhs, 82 lakhs. 23, 77 lakhs. My lord, this on 24, that is from 24 to 25 March is 2 crores.
No, what is this 24/2023 to?
That is the transaction, my lord. Your lordship, I may request your lordship.
You say 6/2/2026.
The second one, he has furnished 2 things. One is from 2/4/24 to 31/3/25 is 2 crores. From then 1/4/25 to 26/8, that is for 4 months. That itself is 93 lakhs.
All these amounts.
90.
My lords,
1 minute.
My lords, I contested for the election, my lords, for the MP election from Tamil Nadu. I lost the election, my lords. I borrowed several loans, my lords. Towards that, whichever properties I have got a agriculture, this thing, my lords, the factory, the agro factory, that I sold, my lords, because towards the debt which I was having, and I had a property, my lords, in Anekal, that also I sold because I was supposed to debt whatever is there that I have to repay, my lords. I sold it, and that is a transaction that is being reflected in this, my lords. And I made a marriage to my first wife's son, my lords, and that is the expenses. That's all. That's a transaction which has
How
come.
much you have incurred for the marriage?
My lords, because
No, because what is the amount?
my lords, it comes around 70, my lords, 60 to 70 lakhs what the marriage expenses has come towards my son. And apart from that, my lords, I'm providing a 4-floor building where the respondent is residing. That's a duplex house with 2 independent floors, which can fetch more than 1.5 lakh rent if they give it, my lords. And this respondent is running a high-end boutique, and she is earning, my lords, if my lords make.
Let's not go into what is she doing. First, you make it. Why did you not file all these statements before the family court? When, as for the judgment of Rajneesh and Neha, it is incumbent upon the part of the party to file all this. So there was an intention on your part to suppress all these facts and get away with, without paying the maintenance to the wife.
That was
A
not.
person whose account runs into the transactions about crores or rupees, 2 crores, 1 crore, and you say, my income is 70,000, I will pay, still I am paying, and as if you're doing some charity to the wife and daughter.
My lords, as on today, my income is that much, my lords, because
Here,
all the
We are
properties.
looking at
Please.
2/4/2024 to 31/3/2025. 2 crores 85 lakhs 99,250 is what your statement shows.
Yes, my lords, that was towards the marriage, my lords. I performed this marriage in the month of May, my lords, May 2025. Towards that was the expenses, my
Let's
lords.
see.
Please, my lord.
What are your expenses?
I will just finish one more thing, my lord. The last I have produced, these are all the transactions which is reflecting in the bank statement. This is with respect to the rents being derived by the petitioner from New Kadai restaurant, which, my lord, the petitioner has contended before this honorable court saying that I have already gifted that property to my son. But in fact, in the bank statement, my lord, everything is, if your lordship want me to take your lordship,
Don't
with
have to, please
the
come
dates I have mentioned from the New Kadai itself.
Please come
Every
to.
year, every month, 6 lakhs, my lord. Every month, 6 lakhs from only New Kadai.
Please come to
Ah,
your
yes, ma'am.
expenditure.
Yes, my lord. I have said.
And she is not doing anything?
She is not. In fact, I had told my lord, both herself and her children got affected with COVID. Ever since COVID, her immunity has come down so badly that every now and then she is falling sick. She had COVID, then she had thyroid, then she underwent
Let's see the expenditure.
Please, my lord. My lord, I have stated, in fact, I have produced all the document before this
Page
honorable
number.
court. Number court annexes. Number court, ma'am. Vacating her. But I have produced all these documents, and your lordship may kindly see this annexure R's. And he has stated that he has gifted all these properties to.
Please come to that.
Yes,
so that
my lord.
What is
Please,
relevant,
my lord,
I'm asking.
I have said from
Page number.
annexure. Yeah, please, my lord. I request your lordship may kindly see the medical reports I have produced. Annexure R14, my lord, in my application. My application for vacating stay. Page number 56, my lord. Page number 56. Page number 56, medical. Your lordship gets at 56 minute, page number 56, R14, annexure R14. And then they had medical. Where I have filed application along with the vacating stay application, my lord, the heavy document. And then they had medical assistant.
56 is some Dr. Solanki.
Yes, madam. Exactly. This is the medical reports which I am saying.
Asking about what
Yes.
is your expenditure.
Yes. 132, your lordship. Annexure R16.
Page
These
number?
are all the medical, my lord. 132 is the grocery bills, my lord, for the every month. I have said
Have
from
not filed
130.
your statement of SSL liabilities.
I
In
have
that
filed.
there will be
I have filed. I
expenses.
have filed, my lord. I
Where
have
are they?
Yes. Second. Lord, annexure R2 is my. Lord, this was filed along with the petition in 22, my lord.
Yes, that only we'll consider now.
Please, my lord. Please,
Yes.
my lord. Lord, I have said general monthly expense of the petitioner, 30,000 for groceries.
Let's see.
Bill,
Before that, my lord.
page number 14, my lord.
My lords,
Annexure R2.
whatever furnished, I don't have that document. my lords. That grocery bill, that page
I am not looking
13
at the
to
bills.
25, I don't have the document what they furnished, my lords.
That is a statement of assets and liabilities filed before the trial court.
No, that was filed here, my lords, whatever that.
It's a document that's filed before the trial.
Ili,
I don't
Annexure
have that
R2 is, madam is referring to Annexure R2.
That you were not furnished.
I have produced, sir, you also have produced, right?
No, R2, because it is a document which was furnished by my land.
Not necessary. You can listen to the argument.
So that
For that,
is
on that, I will
already
not adjourn the
produced
matter.
before-
Yes.
Minute, then groceries, milk products, Bescom bills about
1
10.
minute. Let me
Please,
look at it.
Please,
Let me look
madam.
at it. Every month, why will you buy book, uniform and shoes every month?
No, that time I had bought, he had only paid the school fees, but he did not buy all these things.
Anyhow, that's not a recurring expenditure of every month.
Not for every month.
Yes.
That is, that day I have produced, I have expenditure, it was this. I mean, I have said 5 lakhs for the house because the house is so dilapidated, I have produced the photographs.
Miscellaneous expenses 50,000 per month.
Please, my lord.
What is miscellaneous?
My lord, see,
You have narrated A to Z everything, and above that, why 50,000 miscellaneous expenses?
Miscellaneous
You have to be
expenses, my lord,
reasonable in giving the expenses.
my lord, from the, my lord, both the husband and wife come from an elite family. They are well, they spend the family. The daughter is used to going out every week for restaurants. And in fact, the petitioner himself is to take the respondent and the child every year to outstations. Not even outstations, Dubai. Every year
I don't think that is the
Umrah.
purport of this.
Please, my lord.
That is not the purport of granting maintenance.
My lord, by petrol expenses alone now, my lord, it is increased for the
Where are
past
you
3
going
years.
for
It is
No,
increased.
the petrol expenses of 20,000, where do you go?
My lord, the child right from day one, he would ask her. He will not send her in the school bus. He would make it a point to send the child only in car. That is how the child is adopted to. Even now, the child has to go to the school only in the car. That is because that is how his status is. He has maintained that status.
Yes.
Car driver, in fact, I don't dispute that he has given me a car. But how does the car run? Petrol has to be poured. The driver was there. His son made him
What is the qualification?
SSLC, my lord.
What medical expenses she'll have every month? 20,000.
My lord, even now, I have produced last time. She
20,000 every month.
My lord, every 3 months she has to undergo physiotherapy. 30,000 every 3 months she has to undergo physiotherapy. And now the new thing is, last time I have produced the medical certificate. Now she has some fissures in the breast. My lord, it is yet to be diagnosed.
Yes, please come.
My lords, before that, my lords may kindly turn to
First
page
of all, I will, whatever 3 lakhs, if you make no, even one submission, whatever is she sought of 20 lakhs or 20, what is that, 3 lakhs?
3
I will
lakhs.
straight away grant 3 lakhs. If you don't say anything, I will grant a reasonable amount. And also I'll ask the trial court to issue perjury proceedings against you. These are the options to you. Whatever you choose, you can choose. Yes, please come. Agreed with the orders passed in criminal miscellaneous number 247 in IA number 2 in criminal miscellaneous number 247 of 2022 dated 6 January 2023, whereby the court had granted maintenance of an amount of rupees 20,000 each to the petitioner and the child, and litigation of 30,000, expenses of 30,000. The husband is before this court by filing on WP 7500 of 2023, and the wife is before this court seeking enhancement of the compensation WP 8896 of 2023. The criminal miscellaneous is filed seeking maintenance of 3 lakhs for the wife and the daughter, and 1 lakh towards education expenses. It is a case that the respondent is educated and did reform a course at Mysore. Later, he became a successful businessman and also a PRO in Ambedkar Medical College and some other educational institutions. He is an active Congress member and contested for elections at his native place in Tamil Nadu during the Lok Sabha elections in the year 2021. Since May 2020, the husband had totally neglected her and also blocked her mobile number. There are so many properties. The petitioner owns several properties. It is her case that in order to meet the expenses, she had taken the overdraft of rupees 4.5 lakhs from ICICI Bank, apart from personal loan of rupees 5 lakh from the same bank, and paying rupees 1,600 and 1,800 per month for the said loans. She underwent surgery to her left eye on 15 to 2021 and spent rupees 2,25,000 and more and undergo physiotherapy for her left leg and undergoing physiotherapy for her left leg. The husband, except paying the tuition fees, has not bothered to meet the other expenditure of the daughter. And she sought maintenance of 3 lakhs. The husband has filed his memo as adopting the objections to the main petition as objections to I number 2. It is a case that after the marriage, he provided the wife with 4 floors house at Tati Nagar, Bangalore. The building is a duplex and with 2 independent floors. The wife is also residing in a portion of the same building. Apart from that, she is running a boutique and earning substantially. She is doing high profile boutique where she is earning huge amount and also engaged several persons. In fact, he had provided all the financial support. And the same is suppressed by the wife. He also provided a car to the wife and paying the EMI. So she is having substantial income to live a decent life. Still, she is coming forward with she came forward with an application seeking maintenance of an amount of rupees 3 lakhs. It is stated that they are not entitled for maintenance. The court, by order impugned, while granting the maintenance of 40,000, that is 20,000 each, has observed that the husband in his disclosure of assets and liabilities had mentioned his monthly income as 72,000 and his general monthly expenses at rupees 71,000. He had also mentioned the school fee of 1,02,420 and also car EMI of rupees 10,382. The court has observed that though the husband had provided an accommodation of a duplex house and also having provided a car, petitioner, the wife needs money to run the house and also to use the car. And the daughter is still pursuing her education. Though he had paid the fee for some of the months, as shown in the affidavit filed by the wife, the responsibility of the husband has to be fixed as the respondent is staying away from the family. The wife had claimed maintenance of rupees 3 lakhs and 1 lakh as medication expenses. Though the husband stated that she's doing a boutique business, nothing has been placed on record. But it is a case of the wife that she's doing tailoring work and earning 10,000 to 15,000 per month. Hence, the court had granted 20,000. When comes for the petitioner submits that when his income itself is 70,000, question of paying the maintenance as per the as directed by the court is on the higher side. Further, it is stated that he's taking care of all the expenses. In the maintenance of 40,000 is on the higher side. When the matter came up on the earlier occasion, this court had directed the petitioner to file his statement of assets and liabilities. The respondent has filed the vacate stay petition and also had placed before the court a synopsis to show from the bank statements that are filed before this court, what is the amount. As per the synopsis, he has placed before the court the State Bank of India account in Hosur Taluk, Tamil Nadu. In that only interest is credited to the said account. Then coming to the Bank of India, Rahmat Nagar, Bangalore branch, transactions are running into lakhs. With regard to the Axis Bank and with regard to the two accounts in the Axis Bank, the account is opened on 2/7/2020 and closed on 17/2/2020. And the other is 5/1/2023 and 4/9/2024. Except the certificates, no bank statement is filed before the court. Then coming to the Axis Bank, Pulakeshi Nagar branch, the transaction from 19/4/2018 to 28/2025 is produced. So as per the Axis Bank account, from 9/4/2018 to 31/3/2019, 1,39,998 is the transaction. From 6/4/2019 to 31/3/2020, 63 lakhs 76,078 is the transaction. From 1/3/2021 to 28/2/2022, the transaction in the for the period is 82 lakhs 45,789. Then from 2/4/2023 to 6/2/2026, it's rupees 77 lakhs 19,776. From 2/4/2024 to 31/3/2025, it's rupees 2 crores 85 lakhs 99,250. From 1/4/2025 to 26/8/2025, it is 93 lakhs 70,737. It is submitted that it is also stated in the synopsis that according to him, the new Kadai restaurant he has gifted to the son. But his account, the transaction shows that every month he is receiving 6 lakhs.
6 lakhs.
6 lakhs from the said restaurant. Land counsel appearing for the respondent submits that the petitioner has come before this court with suppression and misrepresentation of facts. When he has stated that his income is 70 lakhs, where from all these amounts are coming to his account and what is he doing, he has not stated before the court. And in the synopsis, it is stated what are the amounts that are deposited in the account by the new Kadai restaurant. It is submitted that considering the after post Corona, the wife has developed a lot of health issues and she is spending huge amounts towards the medical needs. Further, earlier when the parties were residing together, the husband used to send the girl to the school by car, and the standard of living, the girl got used to it, and it's when the father is capable of providing maintenance to the child, he should maintain the same standards. It is submitted that as per the expenditure of the wife and as claimed, an amount of rupees 3 lakhs ought to have been granted by the court, and she sought for enhancement of the maintenance expert. Having heard the counsels on either side, peruse the material on record. When an application is filed seeking maintenance, basing on the evidence on record, the court would grant maintenance to the parties. Earlier, before the judgment of the Honorable Apex Court in Rashish versus Neha, where the court was doing the guesswork when there is no material on record. But after the judgment of the Apex Court, no such exercise is required, as the judgment lays down what are all the documents to be placed before the court while seeking maintenance. Unfortunately, in this case, the petitioner has not placed any of the documents that are relevant for the purpose of granting maintenance. The judgment makes it very clear that if any of the parties fails to place all the relevant documents before the court, an adverse inference needs to be drawn. A person whose income according to him is 75 lakhs, why all these transactions?
75,000.
75,000. Why the transactions are running into crores of rupees is not known. That itself shows that the figures that are stated, the income that is stated, and the case of the petitioner has to be, cannot be taken into consideration by this court. When this court has specifically asked, what are all these amounts? For one, he says that in the month of May, he has performed the marriage of his first, the son from the first marriage. When he is in a position to pay, when he is in a position to spend lakhs of rupees for the marriage, it cannot be believed that his income is 70,000, considering the bank statements that are placed before the court, and also considering the standard of living of the parties and the social status of the parties. This court deems it appropriate to enhance the maintenance to 1.5 lakh. Apart from the educational expenses, the petitioner the father shall pay the educational expenses apart from this amount. Yes.
From the date of application, Mayor?
Yes, it relates back to the date of application.
My lords, one submission, my lords.
Yes.
Before that, my lords may kindly look into the assets and, my lords, the income tax returns what she has filed. And even our account statement shows one dress, my lords, that cost 48,000, my lords. She is earning to that extent. My lords may kindly see from the documents, my lords, that is at page 193.
Who filed it?
That is before he left me. That is how much, Malad,
And
that's what I'm
today,
saying. He would buy only branded clothes, Malad. He wouldn't allow the wife to wear any other clothes. Branded clothes.
But she was earning substantially, my lords. That is my contention.
And counsel for the petitioner submits that, and counsel for the petitioner husband that the wife is purchasing the dresses worth rupees 50,000.
No, my lords, she is running a high-end boutique and she used to prepare the dress and used to give it to the wedding for that is
before filing of the application or after filing of the
application. That is during the period 2018.
It is submitted that the wife
and even in 22 she was earning to that extent, my lord.
Nothing is there on record.
My lords, that is a statement, my lord.
And counsel for the respondent submits that she was doing before the COVID time, and after that, because of the health issues, the wife is on running a boutique. Yes, please. All the petitions are disposed of. No, the petition filed by the husband, that's WP number 7500 of 2023 is dismissed. WP number 8896 of 2023 is partly allowed by enhancing the maintenance from rupees 20,000 to rupees 1,50,000 apart from the educational expenses. The husband, number 2, the husband has to pay the bear the educational expenses of the child. Number 3, the litigation expenses shall pay the litigation expenses of rupees 1 lakh.
Some
Yes.
reasonable consideration must shown, my lords,
He
because
doesn't, I'm telling you, I'll ask them to initiate perjury proceedings. This is a fit case. Yes, please.
7, Nagesh Vinay.
Yes.
May I please, my lord? On the last date of hearing, your lordships have directed the Nimans to get a report, my lord, as to the
Yes.
parties has to be admitted from the hospital. As that report we received. Bandide sir report.
Please come. The Registrar Judicial is directed to give a copy of this report to both to the counsel for the petitioner and also to the party in person. This is matter on 13th of November.
Grateful.
Look at the report.
Please, please.
Yes.
For 8, Manjunath SN.
Yes.
The petitioner and respondent are the husband and wife, my lord. The petitioner.
What is the amount granted?
Not as. Year number 2, my lord. 26 of the Hindu Marriage Act, my lord. Can you see the page number 28, my lord?
Petitioner shall have the visitation rights in respect of the minor child on every first and third Saturday of every month between 10 a.m. to 2 p.m. in the parental house of the respondent in Medicare without affecting the well-being of the child. Please take out the notice on the counsel for the respondent. The petition is permitted to take out hand summons on the counsel for the respondent and shall file a memo to that effect. Once a memo is filed, list this matter. Next 9.
9 urgent. 9
Yes,
urgent.
10.
10. Deepak.
Yes. Where is the order?
Order is on page 38.
Yes, what's wrong with this order?
Leadership, the petition was filed in November 21.
All these allegations which which you are making against the council, against the party, delaying tactics and all, for that kind of applications cannot be considered. If you feel that any misrepresentation is made before the court, you file an application for the perjury proceedings. And the court had rightly dismissed. Now, already court are burdened with unnecessary applications. Please don't add one more and let your MC be disposed of.
Leadership, that is the whole problem. My prayer has not been for any complaint and what has been mentioned here as adjournments. That is not my prayer. My prayer is on page number 7, Leadership, in which clearly I have mentioned the prayer is for reinstating the just order of 8823 that was dismissed by the fraudulent IA34. And point number 3, returning the money misappropriated. So I have not
Money misappropriated.
the interim maintenance granted earlier that was pleaded on false grounds.
Hmm.
So all that money which has been taken by pleading on false grounds, that I had requested to be returned. These are my 2 prayers. In my prayer, I have not mentioned any.
Where is that? Let's see your application. She has only extracted from your application whatever you have stated. Let's see, where is that application?
Application is on page number 567. And the prayer is on page number 7. I have not prayed for misconduct and adjournments and all that. My prayer is very simple points.
What is the order dated 8/8/2023 to be recalled?
Order date,
Why an order of 8/8/23 to be recalled now?
not now. That was in my I number 12. In my I number 12, I had prayed
What
that.
is 8/8/2023 order?
Yeah, so that is on the page number 17. Yeah, page number 19 at the bottom. That's the order of 88. On perusal of the order sheet, it makes out so far applicant respondent had not filed affidavit for disclosure of assets and liabilities either in connection of IA number 3 or 4. Hence scheduled for petitioner evidence by 22/9. That was the order. Because the respondent, even after 1 year of filing the IA for maintenance, never filed the asset and liability forms. They were reminded 8 times to file it, but they chose not to file that at all. And in fact, in their submission also, they have mentioned that the respondent is staying with me and all the expenses are being paid by me. So after that, not filing asset and liability for 1 year, then the family court passed the.
Filed it or not?
They filed it after 1 year.
Yes, please come. We don't have time for these kind of applications, please understand. And you are unnecessarily, it is nothing but wasting the court's time by filing these kind of applications. The present writ petition is filed. Agreed by the order passed in I number 2 in MC number 5860 of 2021. The party in person is before this court. The relief that is sought in this IA is reinstating the just order of 8/8/2023 that had dismissed the fraudulent IA3, IA4, subjecting the respondent, that is wife's team, to a deterrence cost to caution them against future misadventures, returning the money misappropriated till date by fraud, fast tracking this 2021 case for threat of life and limb to petitioner and his children by brutally violent respondent of a mafioso family of convicted murderers and narcotics peddlers. It is stated in support of the IA that where is that 88 order? That on 8/8/2023, the court has passed an order, both the parties and both counsels present. Objections to I number 4 filed on behalf of the petitioner. Affidavit for disclosure of assets and liabilities on behalf of the petitioner already prepared. Filed on perusal of the order sheet, it makes out so. For applicant respondent had not filed affidavit for disclosure of assets and liabilities either in connection to I number 3 or 4, hence scheduled for petitioner's evidence by 22/9/2023. The later, the statement of assets and liabilities are filed by the respondent. It is a case of the party in person that the respondent, wife and her advocate are making false submissions before the court, and they are continuously they are dragging on the matter, playing the delaying tactics and playing fraud before the court. And they have made a mockery of the judicial process, undermining the dignity of the court and the rule of law. The abuse of process of court to disrupt the orderly administration of justice, push the authority and reputation of law into disrespect, disregard, and also undermine the just rights of the petitioner husband.
Ladyship, that I had mentioned because in their sole pleading in their IA 5 and 6 presented after 8/8/23, they had given the sole ground that this trial court never asked us to file asset and liability form.
This is all because you're a party in person. If a person, you don't know what happens in the court. So all small things you look it from a magnifying lens. Because of this tactics and this misrepresentations that are made by the respondent, which made the petitioner to come before the court, made the party in person to come up with this application. The family court had dismissed the application. While dismissing the application, this application is filed under Order 6, Rule 10, Order 6, Rule 16, A, B, and C, Order 6, Rule 17, Section 51, Section 24 of the Section 24 and Section 25 and 27 of the Hindu Marriage Act. The court has observed that the petitioner party in person has filed this application under all the provisions of law. On going through the application filed by the petitioner, the court is confused about what he intends to convey to the court. He has made several allegations against the respondent regarding the contents of the applications, objections, affidavit, especially about the adjournment sought by the respondent and her counsel. It also appears that petitioner has also made allegations against the counsel for the respondent and specifically alleged about the misconduct of the counsel of the respondent as highly suspicious, unprofessional, deserving to be deprecated, as it slights the noble legal profession into disrepute, eroding the trust of the courts and the public in the practicing professionals. The court has observed that if at all he finds fault with the advocate, he has a forum to make his complaint. And they have got the order dated 8/8/2023 recalled by misleading the court. The court has observed that the court has already passed appropriate order concerning the facts and circumstances of the case in accordance with law by keeping in mind justice and equity. The court will be having thousands of cases, and if the court goes by word in letter and spirit, and if the court gives importance to such minor mistakes of the parties and counsels, it would not be possible to give relief and justice to the parties in time. If at all the counsel of the respondent has taken several adjournments, as mentioned in the application, the said act cannot be held as playing fraud on the court. These aspects cannot be held as grave mistakes of the parties and their counsels, which happens in every case before all the courts. At the same time, counsels and parties should not take unnecessary adjournments which would cause harassment to the other side. If the court finds any unprofessional and misconduct of the counsels and parties, the court will definitely take appropriate action in accordance with law. The main allegation of the petitioner in this case is regarding taking multiple adjournments, recall of the order dated 8/8/2023, submission by the respondent regarding non-filing of assets and liabilities could not be held as playing fraud on the court. At the same time, it is important to note that it is also observed by the court that the High Court had directed to dispose of the matter expeditiously by providing reasonable opportunity to both the parties to put forth their case. And in case any unnecessary adjournment sought for by the parties, the family court is at liberty to impose exemplary costs. If the petition is having any life threat he can seek police protection and even order from the court. Hence, the petition is dismissed. The petition that is filed by the party in person deserves no consideration from this court. If at all the petitioner wants, the party in person wants a speedy disposal from the court, he shouldn't come up with these kind of applications. And the petitions that are filed and seeking recall of an order dated 8/8/2023, when that order is already recalled and that order is not questioned, and filing these kind of frivolous petitions before the court is a pure abuse of process of law. And the family court had rightly dismissed the petition, and this court finds no reasons to interfere. Dismissed. Next.
11, Siddhamallappa.
Yes, next.
For the petitioner, my lords, her husband has filed a MC petition seeking for a restoration of conjugal rights, my lords. In that petition, I filed an application under section 10 of CPC seeking for the stay of proceedings, my lords. In the first instance, my lords, wife had already filed a
Come to
MC
the impugned order.
page number 46, my lords. In the year 2021, wife had already filed a.
Read the order, very short order.
Yes, my lords.
The current application has been filed.
Yes, my lords. Section 10 of CPC 1908 articulates the doctrine of sub judice, which serve to prevent the initiation of multiple lawsuits.
No, read from the beginning of paragraph number 1.
Please, Manoj. The current application has been filed by the respondent under section 10 of CPC seeking to stay the present case until the final disposal of MC number 282 and MFA 297 of 2025.
What is this MC number 282 of 2021?
It has already been disposed. It is filed by the wife, my lords, seeking for dissolution of marriage, my lords, which came to be dismissed, my lords. Aggrieved by the same, the wife has preferred a MFA, my lords, which is pending for consideration, my lords. After dismissal of the petition filed by the wife, my lords, the husband has filed a petition seeking for restitution of conjugal rights, my lords. In the MC petition, which was filed by the wife, my lords, the husband has never expressed his intention for joining the wife, my lords. Just to harass the wife, after dismissal of the said petition, the husband has filed one more petition, my lords, seeking for restitution of conjugal rights, my lords. Even though he has a knowledge about the appeal, he has filed a petition, my lords, just for harassment of the wife, my lords. Therefore, I have filed an IA under section 10 of CPC seeking for the stay of the proceedings before the.
Please come. Land Council for the petitioner submits that the wife had filed a petition for divorce, and that came to be dismissed by order dated on 8th January 2025. Against that, the wife has preferred MFA number 7 of 2025. At any point of time during the pendency of the case, the petitioner, the respondent husband has not shown any interest to join the wife. Now, when the MFA is pending before this court, the respondent husband, only with an intention to harass the wife, had filed a petition seeking restitution of conjugal rights. It is submitted that pending, then the wife has filed this application under section 10 of the CPC seeking to stay the present case. It is submitted that it is, if the pending MFA, if the matter is, if the respondent proceeds with this, it would cause a lot of hardship to the appellant petitioner. Considering the same, there shall be stay of all further proceedings in MC number 37 of 2025 till the next date of hearing. The petition is permitted to take out hand summons on the council appearing for the respondent and shall file a memo to that effect by 26th of November. If the memo is not filed, the stay granted by this court stands vacated. Next.
Much obliged.
K. Shetty.
Yes.
Kindly pass over the matter. My senior is arguing the matter.
Yes, next.
13. Anshuman.
I appear for petitioner.
What is the urgency for
Correspondence.
this matter to, a 2025 matter for moving a memo?
My lord, this is, wife has filed an application for custody of the child, my lord, which has been rejected. Here, my lord, I'll point out two things, my lord. The petitioner,
There are so many matters of, much
my lord,
prior
there
to
is
your
no
matter.
interim order also, my lord.
Huh?
The children custody is with the husband, my lord. I'm seeking for custody of the children, my lord.
In this matter?
Yes, my lord, because I have filed an application seeking custody of
What
the
is
child.
where is the impugned order?
Impugned order starts at page 16, my lord. The operative part is at page
29.
How long
21.
they are staying with the father?
My lord, they're staying.
My lords, if I may just interrupt, my lords, I apologize. I have also filed a writ petition challenging the same order. That is at 29886 of 2025.
Give the number. List
My
along
lord,
with
only
that.
1 point, my lord. Just I'll point out 1 point. They're staying in the same house. After
We'll
rejection
hear
of
it,
this,
we'll
I
hear
am,
it
my lord.
finally. This is
Even my
matter
visitation order,
along with so and so on 13th of November.
my lord, one submission. At least visitation rights may be given to me, my lord, till next date, my lord. Because after
There
rejection
is
of the
no
order,
urgency for that. What is not happening? I am disposing
the
it.
trial court has given me visitation rights by the impugned
Then
order,
if
my
that
lord.
is not complied with, you please file the contempt.
My lord, it is not an executable order because, my lord, they are staying together in the same house.
They are not, my lords.
Why not it is executable?
After
She's filed a domestic
Any
violence
order of
petition.
the court is
Yes,
executable.
my lord. After rejection of the interim order, he has he has left the custody
Both
of.
the matters will hear on that day and will dispose of next matter. Yes,
Lords, if I may request for a date on 18th, please, my lords. 13th, 18th.
No, 18th it can't be. Family matters will not come on 18th. It comes on 13th and 14th. It's 13th.
Maybe,
Yes,
maybe
next.
take on 14th, please, my lords. A request, my lords, sincerely.
13th. 14th again, Friday, it will be a busy day. Yes.
14th, Sayyad Pir.
For the petitioner, Your Lordship. Approved correspondent, Your Honor. Arpit had filed in
Your Lordship,
Wakalat on 2011-2021, Your Honor. Which has been also on online. 2011-2021, Wakalat has been filed from behalf of respondent number 1, Your Honor. Your Lordship, in the year 2017, the marriage of petitioner and respondent had
What
taken
is the
place.
impugned order?
The child is 3.5 years old, though the child was 6 years
Come
old.
to the come to the order impugned. Page
Yes, Your
number.
Lordship. Page number 27.
Yes.
26, Your Lordship.
26. Read.
Therefore, looking into the age of the child, which is 3.5 years old,
No, read
depending
from the
upon
beginning. Since the respondent.
Since the respondent, though appeared through his counsel, not filed any objection, therefore, looking into the age of the child, which is 3.5 years old, and depending upon the mother's milk, the care and custody of the said child is very much required, and it should be in the custody of the mother. Therefore, in order to protect the child from malnourishment, passing of an interim order pending disposal of this petition is very much necessary. Therefore, in view of the facts, the respondent father who is depriving the mother from taking care of the child has to be directed to hand over the custody of the child to the mother. Petitioner forthwith failing with the petitioner.
Yes, I've seen.
Your Lordship, the child was 6 years old at the time of passing of this order, not 3.5 year old. And the child was suffering from cancer. His right eye was removed at the age of 2. The child was determined that he is having cancer, and a surgery had taken place. From the age of 2 till even today, the child is taking rehab, and even he's been placed under right eye prosthetic, which every 6 months need replacement or polishing as per the necessity of the treatment. Now, that being the case,
With whom the boy is now?
with the father. From, so, Your Lordship, in the year
No, please give the dates. What is the date of birth of the child?
2018, Your Lordship, 4th January 2018. Your Lordship, kindly, I have filed a memo dated 29/11. Kindly that, Your Lordship. In the year 2020,
let me look at the memo.
Yes, Your Lordship, I produced certain documents.
Which is dated?
29/11/2023 memo.
29/11/2023. What documents you have filed?
Your Lordship, page number 4, I filed an NCR. In the year 2020, the mother had eloped with one Sheikh Sultan. which I filed complaint in the police station that she has eloped, though being married to the petitioner, she have eloped with Sheikh Sultan.
Those documents are not here.
It is filed, Your Lordship. On 1st December, it was taken on record. Memo dated is 29/11, but on 1st of December, it was taken on record.
Page number?
Page number 4, Your Lordship. The complaint was filed in form of NCR.
That is page number 6. Yes.
Page number
What happened
6.
to that?
Your Lordship, after which in the police station.
Complaint is given when?
In the year 17/4/2020.
17/4/2020.
2020.
So at that time, the boy was 2 years old.
Yes, Your Lordship. Now,
then when is this application filed, GNWC?
After she remarried, she had a child. That is in the year 2020. She files the application. 2020.
That is immediately.
Yes, but Your Lordship, the order is passed in the year after COVID. Due to COVID and everything, the order did not take place. But in the meantime, she was pregnant with the second husband's child, which she has not disclosed in the petition or application. She had given birth to the second child on 25/4/2021, daughter from one Sheikh Sultan. There is also a settlement deed where she has mentioned that she only wants to marry Sheikh Sultan. She doesn't want to take care of the child, and I'm handing over the custody of the child to the father. Kindly, Your Lordship, page number.
For whom?
Between husband and wife. Your Lordship, page number.
So right
12.
from 2020
Till
till the
today.
impugned order is dated?
Impugned order dated 25/9. 25/9/2023.
So for 3 years, the boy is with the father.
Yes, Your Lordship.
So by 23, the age of the boy is
5 years, 11 months to be precise. But the
Then
order
what
is-
happened to this order?
Stay is granted by this honorable
So
court.
from there on, he is with the father.
Father only. Visitation right is granted, Your Lordship, on couple of occasion. That is on 22/1/2024. The child was brought before the trial court. Respondent did not appear. Again on 23/1/2024, before this honorable court, the child was brought. Respondent was not present on that day as well. It was referred to mediation. In mediation, the child was brought. Petitioner and respondent were present. The child had completely denied to acknowledge the person or even to go with her. The mediator itself, your mother was in abroad, please kindly speak to your mother. She said, she's not my mother, I don't want to have any kind of contact. So the child had cancer, which is why we do not pressurize the child. He may relapse into the cancer thing because that is cured now, and only the thing is he needs rehab. If we pressure or any kind of mental stress is put on the child at this point of time, he may relapse into cancer.
At
His
the peak
right
of-
eye is completely removed.
At the peak of COVID-19, one NCR was being filed by the present petitioner stating that my wife is been missing along with the child. That petition was been filed, the NCR was been filed before Banaswadi police station. And later on, the allegation started making that prior to the marriage, the petitioner marriage was been fixed with one Sheikh Sultan. Due to that reason, might be she had ran away with that person. Later on, the Banaswadi police station had made all the efforts during the peak of COVID time. Both the respondent and the child was been brought to Banaswadi police station. Later on, the respondent itself clearly said that since the petitioner's sister, Mehreen, she's been married to one Asif, and there is no child. There is no child brought out of the marriage.
When she got remarried.
No, the remarriage thing is not been, the only allegation is from the date of the marriage.
I'm asking you, when was she remarried?
It was the first marriage, Your Honor. The child was not.
She is not married. There was no second marriage.
The second marriage was been done after the period of 4 years, Your Honor. Petition was been filed after getting the child and the respondent to the police station. At that time, the petitioner clearly denied to take the respondent back, stating that my wife had left the house without informing me, and he demanded that I need the khula immediately. And in the police station, there was a settlement done. I am not going to take back the wife as my wife because she had left the house. And the only allegation from the day one is that they wanted to give the child to the sister who is not having the child from since 12 years. Out of the 12 years marriage, the child, she is childless, and they wanted to give the said child to the petitioner's sister
Anyhow, the child is with the father from the last 5 years.
Your Honor, there is one order which is not been furnished before this court. After the order of custody, Your Honor, there was one order passed by the family court stating that the respondent had claimed that petitioner is not capable of taking the child custody. And they demanded that the petitioner should have sum of rupees 10 lakhs in her bank account so that the custody of the child to be handed over to the petitioner. And within 3 days, the petitioner had got sum of rupees 10 lakhs before the court and also furnished those amount to the court stating that I am capable to take the custody of the child.
Your Lordship, kindly page 28 of
That,
the
Your
memo.
Honor, IA number 6 was being filed stating that at that time, in the year 2023, it was revealed that after this order was being passed, the one medical report was being stated, not medical report, Your Honor, state that he is been infected with cancer. Since the petition was being filed on the year 2020, past 3 years, they have never been to court. The court had ordered that the custody should be granted to the mother. When the mother had been to the respondent house,
So when there is a stay from this court, how will the trial court grant custody to you?
earlier, Your Honor, after getting the
No,
custody,
what we'll do is,
Your Honor, even petitioner is married, having 3 kids. Now the only thing, he is also married, Your Honor. They are hiding the fact he is married. Long back he married. The moment he got khula from the wife, within 2 months he got married, Your Honor. He is having a daughter. Those things they are not hiding, Your Honor.
Your Lordship,
Only
kindly
thing is
page
that they are
28 of the memo.
depriving the mother, Your Honor.
What we do is,
The birth certificate of the child, within 9 months, the second child was born to her.
Monday to Friday, let the custody with the father. On the weekends, let the mother have the custody.
Yes, Your Honor.
And then let the court decide the application.
Your Lordship, the child
Your
was
Honor,
taken
there
with
might
her
be the time and the place may be fixed. Your Honor, earlier also court had ordered the child should be given to the custody of the mother. Father will never come before
has
the
not
court. Father
exercised.
will never come.
Your Lordship, 15/9/2023 till today, multiple times the child have been brought.
5
She
years
have
had
not
been passed, Your
exercised.
Honor.
She have not
seen the
exercised
glance of the
visitation
child, Your Honor.
rights.
Every time the petitioner's sister accompany, they mishandle with the girl and they take her mobile and they go back.
Your
Your
Lordship,
Honor.
let it be in the
5
mediation
years,
center
Your
of the
Honor.
family court. Let her meet with the child. We are not denying the visitation right.
5 years had been, she had not seen the glance, Your Honor.
For some time, you
Yes, sir.
please meet the child in the mediation center. Let the child be acquainted with you. Then after that, we'll grant weekend custody. And also direct the family court to dispose of this matter.
Much obliged.
So first, this coming, what is the age of the, what is he doing now?
Presently 8 years, Your Lordship, the child. This January, he's
What is he doing?
schooling, Your Lordship. He's in second standard, Your Lordship.
Saturday is a working day or not?
A working, yes. School working on Saturdays as well. Half day.
Half day. So for 4 weeks, before in the mediation center, from 2 o'clock, 3 o'clock to 5 o'clock, let there be visitation. After 4 weeks, we'll again hear this matter.
Yes, sir.
Basing on how it works out, we'll see.
After 4 weeks, we'll keep the child present before this court also, Your Lordship. After 4 weeks on the next hearing.
We'll see. If
Your
required,
Honor,
we'll see.
one request before this
The
court.
child
that
may not
let
be
the
forced,
child-
Your Lordship, because he is having cancer. And if any kind of stress or
Don't tell all
anything,
this.
There is,
And what
he may
is that-
relapse.
what is that- what is that now, if you tell all these things, court has to presume that, you're creating all these differences between the mother and the child. So please don't
that
tell
is
all
the reason we're telling we'll
Yes.
keep the child.
Your Honor,
present.
one request is that in the mediation, let the petitioner sister do not accompany, Your Honor. It is
Let the father accompany.
And none of them while she
Yes,
exercises
yes,
visitation.
yes,
So all
Your
of you
Lordship.
stay outside.
Yes, Your Lordship.
It is submitted by the counsel for the petitioner that the court had granted directed the custody to be given to the mother, which is stated by this court. And according to the petitioner, though they are ready for the visitation as granted by the court, but the mother is not coming forward. According to the mother, though she is ready, they are not. They are coming. The father's sister is not letting the mother exercise her visitation. In these circumstances, this court deems it appropriate to pass the following order. Number 1, on all Saturdays, that is 8th, 15th, 22nd, 29th. On all the Saturdays, the father, the mother can exercise the visitation in mediation center between
Mediation center.
Bangalore, mediation center Bangalore.
Your Lordship, 8th, there
Second
is
Friday.
holiday, second Saturday holiday.
Then it's 15th, 22nd, 29th, and 6th.
Yes, sir.
And 15th, 22nd, 29th, and 6th, the mother can exercise the visitation in the mediation center. Number one. Number two, at the time when the mother is exercising exercising the visitation in the mediation center, along with the child, only the father should come to the mediation center, and at the time of exercising the mediation, none of the father also shall not be present. Yes, list this matter on 9th of December. Yes, next.
List number 2, serial number 1. Then Jagdish Baliga.
Why the memo is moved?
No, I have not moved because it was moved earlier. Your lordship directed to list it on 4th. I think that is what I think. That is moved earlier.
No.
In between, it came.
It is list on 411.
411.
You have moved this memo on 2710.
27. It came before your lordship on.
No, date
20.
itself is given on 4th November.
Yes, but it automatically it came. It listed before your lordship.
So my request to the advocates would be, don't give the memos for these 20-25 matters. Now all MFI advocates also, this much of bunch they are giving every day. And what is happening is in the chamber, I have to spend 45 minutes on this. And when the matters are auto listing and all the matters
No,
are
you will-
listing
I'm
for the
sorry,
fresh matters, there cannot be any urgency.
No.
I am telling the section to list all the matters. Now unnecessarily by giving these memos, my time is wasted.
No, your lordship may kindly see. Here,
Can you please come to the, please, what is required now? Where is
no,
the
nothing is required. Your lordship already stated the matter, then I have to deposit.
list this matter after service of notice? S2?
Serial number 2.
Yes.
Was an order passed by Honorable Court
Here
on
for
2nd
petitioner, Your
September.
Honor. Kindly urgent tomorrow, Your Honor. Scenery is inconvenient.
No payment has been made as per the direction of this Honorable. On 2nd September, that
You have
is,
given MFA.
Kindly urgent tomorrow.
1 minute, let me see what it is. RPFC 24 of 2025. And all these MFAs, please don't accept any memos of 2025 fresh matters. And above that, Mr. Ravi Sampati, every advocate gives Mr. Guru Prasad, he gives 20, a bunch of 20. Somebody gives a bunch of 20. Please don't do that. I will direct I have already directed, all the matters will be listed. Yes.
on 2nd September, my lord, there was an order.
Yes, let me look at it. The coordinate bench of this court has passed an interim order directing the petitioner to pay an amount of ₹5,000, but there is no order pertaining to the arrears. The order dated 4/2/2025 is modified and the petition paid the arrears also at ₹5,000. First half of the arrears shall be paid within 6 weeks and remaining part of the arrears in another 6 weeks from the date of the receipt of the copy of the order. I think that 6 weeks is elapsed.
It's already elapsed, my lord, therefore that matter is listed today.
They have not
But
paid.
they have not paid, but it is already ordered that it is to be paid to the account because I have already furnished the account of my client also. But they have not furnished according to my information.
Kindly, I will
This matter tomorrow by the time, the petitioner shall get instructions with regard to the compliance of the order dated 2/9/2025, or else the petition will be dismissed on that ground. Yes,
Hold.
next.
Number 3, serial number 1. Nayak Krishna.
Yes.
Claimant appeal for enhancement case of injury Millard.
It was coming to 7,14,676.
Yes.
It is not acceptable to you.
My humble submission before this honorable court is, the court below has already awarded 6 months later period. Reason being, the
No,
doctor.
that I have not questioned, that I have not altered. As it is, no, if you,
That is
please open your file.
Yes,
So pain and suffering, 70,000.
Yes, your lordship.
Medical expenses as it is. Loss of income during the later period, 15,500 into 6,
Yes, your lordship.
93,000.
Yes.
Then incidental expenses, 5,000.
Yes, your lordship.
Loss of amenities, 40,000.
Yes, your lordship.
Then loss of future income, 15,500. According to you, the
10%.
later period has to be reduced.
Later period has not at all been ordered by the court below, your lordship. The reason
How
being,
many days he was in hospital?
5 days.
12 days.
5 days.
12 days. 12 days.
What is, what are the injuries?
He has sustained head injury, your lordship. He recovered well and he has appeared before the court below for cross examination also. And the reason for our assessing the disability to the extent of 10% was impaired memory was the reason. During cross
So
examination.
from now onwards, that the witness shouldn't answer properly, then only you will accept this.
No, no.
Doctor has given the evidence saying that there is 10% disability.
I
So
leave
that
it
doesn't mean that only, it is not that, like in responding only he'll have the problem, he'll have some other issues. So who are we to say? It is an expert opinion.
I leave it. I leave it.
Yes. So for the later period, we will make it 4 months then. It's a head injury. It comes to 62,000. 31,000 we need to minus from this.
Yes.
It comes to 6,83,676. What was the amount granted by the tribunal?
4,12,676.
4,12,000?
4,12,000.
12,000. Please come. Agreed with the award passed and MBC number 5175 of 2022, dated 24 September 2024. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 50 lakhs for the injuries sustained with the claimant. The tribunal has awarded the compensation as per the table given below. It is this table. Here, this is the table. When counsel appearing for the claimant submits that the court has not granted a just and reasonable compensation. Under the head of pain and suffering, the amount that is awarded by the court is not reasonable. It is submitted that the court has not, the loss of earning during the later period, court had only considered, which year is the accident?
2022, 15/8/2022, my lord.
The court had considered only for 2 months. It is submitted that no amount was granted towards loss of future income. On all these counts, the amount of compensation needs to be enhanced. And counsel appearing for the respondent submits that already court has granted enough compensation. And further, as though the doctor has deposed that he has suffered disability, as he is able to depose before the court has not considered the future loss of income and there are no grounds to interfere. Further, it is submitted that under incidental expenses, court had granted 90,000 when he was in the hospital for 5 days.
90,000 towards loss of income during treatment period, your lordship. That is for 6 months. Sir.
Well, 12 days in inpatient.
Loss of earning during the later period is 30,000.
No. 90,000.
No, 90,000.
That has been wrongly stated in the table, your lordship.
Yes, my lord. 90,000 loss of earning later period.
That is 30,000
It
towards
is submitted that already the loss of earning during the later. Then what incidental expenses?
30,000, your
30,000.
lordship.
When he was there in the hospital for how many days?
12 days, my
12
lord.
days.
12 days. 12 means 12,000. That is another 7,000 to be added. Then it becomes 90,000. The court had granted 30,000, which is on the higher side. Why are you not correctly stating in the synopsis at least?
By mistake.
it is submitted that already the amount that is awarded is on the higher side and no compensation. That there is no, then there cannot be any enhancement. Next, having heard the counsels on either side, there is the material. Considering the head injury that is sustained and the head of pain and suffering, this court is granting 70,000. As far as the medical expenses, loss of amenities are concerned, no interference is called for. Coming to the incidental expenses, considering the 12 days of hospitalization, this court is granting 12,000. Then coming to the loss of future income,
15,500 into 12 into 10%, 2,79,000.
loss of future income. Though when the doctor has reported he has suffered 10% disability, court ought to have taken that into consideration on the ground that he is able to depose before the court. That cannot be a reason for the court not to consider. Hence, on the head of loss of future income, 15,500 into 12 into 15 into 10 by 100 is 2,79,000. In the light of the law laid down on Mekhala, 10,000. Coming to the loss of income during the later period, this court is inclined to grant 4 months. That is 15,500 plus 4 is 62,000. Let me calculate. There is some kind of 1,87,676. It comes to 6,60,676. It comes to 6,60,676. Accordingly, the appeal of the claimant is partly allowed. Enhancing the compensation from 4,12,676 to 6,60,676. The enhanced amount shall carry 6% interest. Yes, next.
But Amit Anand?
Yes.
This case,
For the
appellant,
This
case, 2.1 Melad. P. Suresh is appear, Melad. I represent P. Suresh.
File this for being spoken to. Yes.
My lord, 10/9/25 judgment ಅಲ್ಲಿ respondent number 3 ನೇಮ್ ಮುನಿರಾಜಪ್ಪ ಬದಲಾಗಿ ಮಿನಿ ರಾಜಪ್ಪ ಅಂತ ಮೆನ್ಷನ್ ಆಗಿದೆ. ಮತ್ತೆ ಪೇಜ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಲೋವರ್ ಕೋರ್ಟ್ ಕೇಸ್ ನಂಬರ್ 392819 ಬದಲಾಗಿ 3938
one at a time. Which page?
Page number 2, respondent
Page number 2. Yes. What is wrong here?
ಮುನಿರಾಜಪ್ಪ ಬದಲಾಗಿ ಮಿನಿ ರಾಜಪ್ಪ ಅಂತ ಆಗಿದೆ.
Where is that? Which line? Oh, it is in page number 2. It is Muni Rajappa.
Muni Rajappa.
What is there in the cause title of this case?
Muni Rajappa.
Let's see. Muni Rajappa. Yes.
ಆಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 3 ಅಲ್ಲಿ
One minute. So this is Muni Rajappa. Then
ಪೇಜ್ ನಂಬರ್ 3 ಪ್ಯಾರಾ ನಂಬರ್ 1 ಲೋವರ್ ಕೋರ್ಟ್ ಕೇಸ್ ನಂಬರ್ 3928 of 19 ಅಂತ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಇದರಲ್ಲಿ 3938 of 18 ಅಂತ ಹಾಕಿದ್ದಾರೆ.
Should be
3928 of 19.
3928 of
19. Judgment dated 2921.
29/2021. Who is this? BN. Not even looking at the dates. Yes.
In this case,
Same is repeated in
9/2021.
Same is repeated in page number 7, para number 8.
1 minute. Page number 7.
Para number 8.
29 and the number has to be changed. That is MBC 3928.
8 of 19. ಅಷ್ಟೇ ಸರ್.
Only that?
In this case, Melad, 2.1 claimant's appeal, Melad. This is listed for dismissal, Melad.
Being spoken to. Already disposed of.
2.1. Last occasion, P. Suresh is not appeared, Melad. This is enhancement, Melad. Grievous injury, Melad. Sustained. 2.1 dismissal.
Other matter is also before the court. Yes. Anyway, that will be dealing. It's as far as 2.2 is concerned.
That is enhancement, Melad. 2.1, Melad. The same.
It's a different case.
No. This case one.
Arising out of the same accident.
Maybe it's a different claimant.
No,
Same claimant, Melody.
Same claimant.
He is appearing for the
Claimant's Melad.
And who is he?
My lord, since he was not appearing since several times,
With the award so
my
and
lord,
so.
that was the claim petition was, his appeal was dismissed.
Not dismissal ಅಂತ ಇದೆ.
Pass the
Is listed for
amendment one
dismissal, my lord.
who's respondent number 2 and also pass an order of pay and require. Claim petition seeking compensation of an amount of so and so.
My lord, since he was absent, my lord, for several hearings, my lord, your lordship dismissed the appeal of filed.
Then we will not, with no application for that. Please come, the matter is posted for being spoken to. It is submitted that in the cost title, the third respondent's name is shown as Mini Rajappa instead of Muni Rajappa. And in the order, in the first paragraph, MVC number is shown as 3938 instead of 3928 of 2019. And the date of order is 22/9/2021 instead of 2/9/2021. And at paragraph number 8 also, the same correction needs to be made accordingly. The petition, the corrected copy shall be uploaded. Yes. Next.
Number 3. Appellant in this matter, my lord. Place of injury, 3 and 3.1, my lord. Delay interest may be waived.
Are you ready?
Yes, madam.
Yes.
3, my lord, 3.1.
Yes. Take those two. In this 3, I number 1 of 25 to condone the delay of 296 days, condoned on condition. 3.1 memo is filed seeking dispensation of notice to R1, dispensed with. I 1 of 25 to condone the delay of 296 days. Now let's take MFA 5635 of 2025.
The amount claimed is 20 lakh, my lord. The compensation award 7 lakh
Let's go to
13,000.
the table 1.
Para 59.
59.
59. My lordship, only interference is, my lord, loss of future earnings. I have written in that one synopsis.
Yes.
15% MSCT has considered whole body disability. 18% we both are agreed, and 18% has to be considered.
What was the doctor's?
58%. to the
58%.
member. But other heads, my lord, the compensation awarded little more, my lord. That's what, my lord, 18% we have considered. We both
Only,
have
only this point now needs
only
to
this,
be.
only that point.
Agreed with the award passed in MVC number 4542 of 2021 dated 29/9/2021. The claimant is before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below at page 58. Then counsel for the petitioner submits that when the whole body disability is 58%, the court ought to have taken 18% as disability, but the court had taken 15%. Even and the other heads also, the compensation that is awarded by the tribunal is not just and reasonable and needs to be enhanced. Then counsel appearing for the respondent insurance company submits that the court has granted a reasonable compensation. Next, having heard so and so. Under the head of the incidental expenses, pain and suffering, loss of amenities, medical expenses, and the loss of income during the leader period, future medical expenses. Court has granted a reasonable amount and no enhancement is called for. When it comes to the loss of future earning, when the doctor has given the evidence that the disability is 58%, the court ought to have taken 18% as disability. Hence, this court is taking the disability at 18%.
15%. MSCT consider 15%.
That's what. And this court is taking 18%. So 15,000 into 12 into 16 into 18 by 100 is 5,18,400. 400. And the litigation in the light of the law laid down in so and so litigation expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 8,09,400. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 7,13,000 to 8,09,400. Appeal is accordingly, appeal is partly allowed. The enhanced amount shall carry 6% interest. Next. What about this 5648?
This is an amputation, my lord. My synopsis mechanism.
Yes, yes.
41 years, my lord, 14 multiplier adapted, 20 lakhs here also, my lord, same compensation as claimed. 85% right lower limb, the doctor assessed. MSCT consider 85% to the limb. The MSCT consider 40%, my lord. As for the schedule, my lord, 70% is there. Amputation of knee is concerned. I have mentioned matter in the synopsis in serial number 2, item number 2.
Yes, acceptable.
Yeah,
to
accepted.
Agreed with award passed in MSc number 4542/2021, date 29/9/2021. The claimant is before this court seeking enhancement of the compensation. The tribunal has awarded the compensation. Where is the table?
Table Millard, I have mentioned in synopsis only, madam. MSCT award and here
not
in the
there?
judgment.
Ah.
Judgment there.
It's easy for them.
Please.
Is it page 58?
46, my lord.
46.
46.
Para.
Para 46 only, my lord. 32 page number.
At para 46, extract the table. The land counsel appearing for the claimant submits that when the limb disability according to the doctor is 85%, the court had taken 40%. The court ought to have taken the disability at 85%. Future prospects were considered.
Yes, my lord. That's what my lord synopsis.
That's what I've seen it. It is submitted that the court has failed to grant a just and reasonable compensation. Then counsel appearing for the respondent insurance company submits that the court has granted a just and reasonable compensation. It is the amputation of leg.
Amputation of right leg, my lord.
In this case, the claimant has sustained the amputation of the right leg. Considering that this court is inclined to take the disability at 70% and 15%. The salary is taken at 15. The notional income is taken at 15,000. The future prospects at
25%.
40%. What?
25%. 41 years.
What 41 years? At 25%. Tribunal has taken 40%.
40% disability, whole body disability.
Whole body.
The taking 25% of future prospects, it comes to 10,800. 10,000.
No, my lord, that's MSCT award. Right side column.
No, 15,000 plus.
That's MSCT award.
No, that I saw. 15,000.
Right side column, my lord.
No, that I have seen. 25%. It comes to 3,750.
6,000.
3,750 into plus 15,000.
15,000.
That is 18,750. So his income becomes 18,750 into 12 into what is the multiplier? 14. 14.
70%.
14 into 25 by 100 is 22 lakhs 5,000. As far as other heads are concerned, court has granted reasonable
No, my
compensation.
lord, pain and suffering 80,000 to 1,50,000.
1 minute.
Yes.
As far as the pain and suffering is concerned, considering the amputation, this court is enhancing it to 1,50,000. Coming to the loss of amenities, that is also enhanced from 80,000 to 1 lakh. Medical expenses as it is. And coming to the loss of income in the later period is also reasonably granted. Future medical expenses, considering the amputation 70,000, this court is granting 1 lakh altogether. And in the light of the law laid down in Mekla, so 10,000 litigation expenses. Altogether, the claimant is entitled for an amount of rupees 27 lakhs 36,000. Accordingly, the appeal is partly allowed, enhancing the compensation from 14 lakh 9,000 to 27 lakh 36,000. And the enhanced amount shall carry 6%.
So far as delay is concerned, the interest may be.
It's already in both the
The
cases.
judgment.
Delayed period, they are not entitled. Come here, Professor. These two in the other, look at it. In the other file also you keep it. Yes, next.
Please.
Yes, 4.
Separate one. 4.
Krishna Swami.
Krishna Swami.
Yes, no representation. This is matter next week. Yes, 5.
Krishna Swami.
This also. 6.
6.
Yes, which is the respondent?
Insurance company also filed an appeal, my lord. Can they
What is
post
the
along
number?
with number 7654 of
This
2025.
along with so and so. Who is the counsel?
PC Shivanya Goda.
Mr. PC Shivanagar is directed to take notice on behalf of the respondent insurance company. Who are the other respondents?
Other respond, my lord, notice may be dispensed with respond number
Who
1.
is filed seeking dispensation of notice to so and so? Take that. Dispensed with.
Day after tomorrow.
This along with so and so.
Only challenging the quantum, my lord.
Yes, day after tomorrow.
Please.
Day after tomorrow is yes, Thursday. Yes, 7.
7.
Yes, sir, my lord, R1 notice may be dispensed.
So R1 notice dispensed with. R2 is which company?
IFCO Tokyo, my lord.
IFCO?
IFCO Tokyo.
Mr. B.C. Shivanagoda is directed to take notice on behalf of the respondent insurance company, I number 1025, to condone the delay of 249 days, condoned on condition. Yes, next 8.
Right. Pavana Chandra Shetty.
The appellant, my lord.
Yes.
My lord, it's a claimant appeal for enhancement, my lord.
Yes, yes.
R2 is New India.
New India.
New India. Mr. A.M. Venkatesh is directed to take notice on behalf of the respondent insurance company. What about the other respondent?
My lord, I'll give a dispensation memo.
To
my
whom?
lord. R1, respondent
A
number
memo
one.
is for seeking dispensation notice to R1 in all these matters, papers to be served. I number 1025 to condone the delay of 60 days condoned without condition. Yes, next. What about this?
In this, my lord, R2 is IFCO Tokyo.
IFCO Tokyo.
And I'm filing a dispensation for R1, my lord.
R1 dispensed with IFCO Tokyo. Mr. H.S. Lingaraj is directed to take notice on behalf of the insurance company. IFCO Tokyo, you don't appear. Then your name is here.
Yes, that has to be.
Mr. Sri Saila S. is directed to take notice on behalf of the insurance company. I number 1025 is filed to condone the delay of 56 days condoned. Next.
Obliged, my lord.
10. Prakash KV.
Notice. Next 11.
11. Ramesh.
And also. Respondent number 2 is the Bajaj insurance.
This matter, my lord, the insurance company has also filed an appeal, my lord, MFN number.
List along with so and so. Who
For R2, I'll take notice, my lord.
R2 is?
Bajaj Alliance. PSD.
No, name.
PSD.
This PS Jagdish is directed to take notice on behalf of the respondent. Any dispensation in this?
I have to find out. I am proxy.
Notice list along with so and so. Yes, 12.
Number 12. Pavana Chandra Shetty.
I am for the appellant, my lord. My lord, R2 is an United India Insurance Company. R1, I am filing the dispensation, my lord.
United India.
Please, my lord.
Mr. M. Punacha is directed to take notice on behalf of the respondent. Yes, the council shall serve the copy on the, in this also dispensation?
Yes, my lord, I am.
A dispensation. I number 1025 to condone the delay of 47 days, condone admit final hearing TCR in all the matters. Yes, 13.
Obliged, my lord.
Sanjay D.
There is a delay of 6 days, my lord. You are filing memo for dispensation to R1.
R1 dispensed with, then which is the insurance company?
United
India Insurance Company. Mr. A. Ravi Shankar is directed to take notice, serve the copies on him. Delay of 6 days, condone, admit final hearing TCR. Yes, 14.
Admission 14. Shivanagoda.
Yes.
Insurance company is challenging the liability as well as the quantum of compensation.
On what ground?
On the ground, my lord, the driver is not having a driving license. Charge sheet was filed under section 3(1)81.
Pay and record will apply or it's after?
My lord, it is not stated anything regarding that. My lord, the other fact, my lord, the court has taken 40% disability.
We'll go to it that later. Pay and recover will apply.
Please.
Yes. So come to the, where is the table?
Please. My lord, in this case, the injured person, has sustained it. According to them, he has sustained a injury. Court has taken 40% disability. Our contention, my lord,
No, his appeal is also there. That's
please
why.
seeking an answer.
What are the injuries?
Please.
How many fractures?
He has sustained head injury as well as
Yes.
head injury and right hand, there is a fracture of forearm fracture.
So another 20,000. Next, medical expenses.
As it is.
Yes, you have anything on medical expenses?
No. They have produced the
22,800. Then
remaining amount.
loss of, then we are coming to loss of earning.
Please. In this.
Stayed up period. Where how many days he was in hospital?
Initially 30 days, subsequently another 10 days. Sir.
40 days he was in hospital. Which year is the accident?
22.
So 18.
18.
2018.
12,500.
18. Court had taken how much?
Court has taken at 12,500 only.
So we'll take for 5 months, we'll grant. Into 5, comes to 62,500. How much the court had granted? Loss of income?
37,000.
Then he was there in hospital for 30 plus?
40 days.
40 days.
Initially
Incidental-
first 30 days,
Ah.
subsequently in different.
Incidental expenses, 40,000. Then,
But
but actually the court had granted transport, food and nourishment
On
put
the-
together 50,000. Now we are making it 40,000.
that has to be reduced.
That is reduced. Then loss of amenities. What is the evidence of the doctor with regards to disability?
Doctor says she has permanent disability of 43% of the head injury because of the neurological and psychological disability.
Court has taken?
The court has
14.
taken
But-
one third, they have taken one
How
third.
can it be 1/3 head injury?
It is a major.
That's the point, man.
Ah.
Yes, the petitioner, she has given the evidence before the court. No abnormality was noted by the doctor.
So doctor's evidence, how you are
Correct, my lord.
finding fault with
no, no.
it?
When
What
the
is the
petitioner has
cross-examination?
given the evidence before the court, if such a disability, can they give the evidence? That is the reason that the disability assessed by the doctor, it's something.
No, for example, if person has some problem, is
Yes.
able to talk normally. Does it mean that he'll be all right at all times?
No, what the doctor said, the cognitive disability, what the doctor depot, it is against to the appears before the court. He has given the evidence.
What
He has
is-
answered the question to all the question which was posed by the opposite party.
What is the evidence of the doctor?
He said that there is a cognitive disability of 55%. That's all, nothing else. He says.
Have you cross-examined him?
We have cross-examined the witness, my lord.
Please read the cross-examination.
And further, the petitioner has given the evidence. He said that I have continued in this studying as a student in the BCom. May cross-examination portion I am studying in second year BCom. I have no document to show that.
Read.
I am pursuing my second year BCom at Kirti College. I came to Shivamogga yesterday to give evidence this case. I do not know whether FSI lodged 2 days after the first FIR accident. FSI was lodged by my father. He was a LIC development officer and got retired so and so. On the date of accident, I was coming so and so. It is true suggest that spot of sketch mark exhibit P7 as correctly prepared by the jurisdiction police. It is true to suggest after the existing college gate, we have turned towards left side to came towards Shivamogga. I do not know whether any vehicle were moving on this side.
Please read the cross-examination of the doctor.
Please. Ide. Only cross-examination of the evidence. It is in Kannada, my lord, I will translate. ನಾನು ರೋಗಿಗೆ ತಲೆಗೆ ಪಟ್ಟಂತೆ ಮಾತ್ರ ಚಿಕಿತ್ಸೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ, ರೋಗಿಯು ಕೋಮಾದಲ್ಲಿ ಇದ್ದರಿಂದ ಉಸಿರಾಟಕ್ಕೆ ಸುಲಭವಾಗಲಿ ಎಂದು ಟಾರ್ಸೆಕ್ಟಮಿ ಮಾಡಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ, ನಂತರ ಸ್ವತಃ ಉಸಿರಾಟದ ಸರಿಯಾದ ಮೇಲೆ ಅವಶ್ಯಕತೆ ಇಲ್ಲದ್ದರಿಂದ ಟಾಕ್ಸಿಕ್ ರಂಧ್ರವನ್ನು ಮುಚ್ಚಿರುತ್ತೇನೆ. ನಾನು ಅರ್ಜಿದಾರರಿಗೆ ತಲೆಗೆ ಆದಂತ ಗಾಯಗಳಿಗೆ ಶಸ್ತ್ರಚಿಕಿತ್ಸೆ ಮಾಡಿಲ್ಲ. ನೋ ಆಪರೇಷನ್ ವಾಸ್ ಕಂಡಕ್ಟೆಡ್. ಅರ್ಜಿದಾರರು ಡಿಸ್ಚಾರ್ಜ್ ಆದ ಮೇಲೆ ದಿನಾಂಕ 26/2018 ಬಿಡುಗಡೆ ಆದ ನಂತರ ನಮ್ಮ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಒಳರೋಗಿ ದಾಖಲಾಗಿರುವುದಿಲ್ಲ. Once he says that he has admitted in, but he says that there is no admission in the hospital. ನನ್ನ ಬಳಿ 12/8/21 ಮಧ್ಯೆ ಚಿಕಿತ್ಸೆಗೆ ನನ್ನ ಬಳಿ ಬಂದಿರುವುದಿಲ್ಲ. He has not come turn towards to take a further treatment. ನ್ಯೂನತೆ ಪ್ರಮಾಣಕ್ಕಾಗಿ ಪತ್ರಕ್ಕೆ ಬಂದಿರುತ್ತಾರೆ. ನಂತರ ನಾನು ಯಾವುದೇ ಚಿಕಿತ್ಸೆ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. 21 ಅಂಗನ್ಯೂನತೆ ಪ್ರಮಾಣ ಪತ್ರ ಮುಂಚಿತವಾಗಿ MRI ಸ್ಕ್ಯಾನ್ ಮಾಡಲು ತಿಳಿಸಿರುತ್ತೇನೆ. ಆದರೆ MRI ಸ್ಕ್ಯಾನ್ ನನ್ನ ಬಳಿ ಇರುವುದಿಲ್ಲ. He has suggested to get the MRI, but they have not turned up to undergo that test, my lord. Exhibit P14, ನಾನು ಕ್ಲಿನಿಕಲ್ ಸೈಕ್ಯಾಟ್ರಿಕ್ ಅವರು ಏನು ಪರೀಕ್ಷೆ ಮಾಡಿ ಎಂದು ಅರ್ಜಿದಾರರು ಏನು ಉತ್ತರ ಎಂಬುದರ ಬಗ್ಗೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನೋ ರಿಹಾಬಿಲಿಟೇಷನ್ ಕೋರ್ಸ್ ವಾಸ್ ಕಂಡಕ್ಟೆಡ್ ಬಿಫೋರ್ ಇಶ್ಯೂಯಿಂಗ್ ದಿ ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್. ನಿಶಾನಿಲ ಅಂಗನ್ಯೂನತೆ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಸೈಕ್ಯಾಟ್ರಿಕ್ ಕೊಟ್ಟ ನ್ಯೂನತೆ ಮಾಡಿರುತ್ತದೆ. ಅರ್ಜಿದಾರ ನಾನು ಹೇಳಿದಂತೆ ಯಾವುದೇ ನ್ಯೂನತೆ ಇಲ್ಲ ಎಂದರೆ he says that not the what he has given the disability, he has denied that the suggestion which was posed. But
In the chief examination, what is the basis for that assessment? You must have stated so. Chief affidavit.
May I will read. According to this, Malad, he has not assessed any disability what they are deposed. What he has said, I will read. ನಾನು ಮ್ಯಾಕ್ಸ್ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಮಾರ್ಚ್ 2016ರಿಂದ ನ್ಯೂರೋ ಸರ್ಜನ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ಮಾಸ್ಟರ್ ಫರಾನ್ ಮಹಮ್ಮದ್ ಅವರು ಹುಡುಗ ವಿಭಾಗದಲ್ಲಿ ಅವರನ್ನು ಕರೆದುಕೊಂಡು ಬಂದಂತ ಸ್ನೇಹಿತರಾದ ದಾಮೋದರ ಎಂಬುವರ ಹೇಳಿಕೆ ಮೇರೆಗೆ ಟಾಟಾ ಎಸ್ ಬೈಕಿನ ಮಧ್ಯೆ ಅಪಘಾತವಾಗಿದ್ದು ರಾತ್ರಿ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಬಾಪೂಜಿ ಕಾಲೇಜಿನ ರಸ್ತೆ ಅಪಘಾತವಾಯಿತು. ತಕ್ಷಣವೇ ಮ್ಯಾಕ್ಸ್ ಆಸ್ಪತ್ರೆ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದು ತಪಾಸಣೆಯಾಗಿ ಪ್ರಜ್ಞಾಸ್ಥಿತಿಯಲ್ಲಿದ್ದು he was conscious. ಎರಡು both the height there was some both the hair melad there was some blood this thing. He had some breathing problem. Therefore he has suggested to get the scan, the brain scan. There was some blood clot in the brain melad. Therefore he has brain flow. Therefore there was some scratches on the tear on the head melad. Therefore he has stitched that tear. Stacectomy was done due to he had some breathing problem. That's all he says that in the evidence. ಜ್ಞಾಪಕ ತೊಂದರೆ ಇರುವುದಿಲ್ಲ. ವಾಟ್ he says that ಮಾಡ ನರಮಂಡ ತಪಾಸಣೆ ಮಾಡಿ ಅವರಿಗೆ ತೊಂದರೆ ಇರುವುದರಿಂದ he says that may have some problem in his study. According to this, there is no disability assessment.
No disability certificate.
No, kindly
In
see
this-
exhibit P17 lordship. P17 lordship. It is in English only.
Behavioral assessment certificate.
That is not a
Major is a psychological disability lordship. Psychiatric, he has taken treatment at Manasa Nursing Home at Shimoga. The doctor asked me exam to him. He gave the
The
certificate.
same doctor?
No. He's
No.
a Narayan Punji, he's a neurological. He is a psychiatric.
Another doctor is
Another doctor
examined.
lordship.
That
Exhibit
doctor-
P17 lordship.
He has not examined before the court.
Dr.
Given
Narayan
certificate.
Panaji.
Correct, my lord. He has not examined before the court, and he is not authorized person to assess the disability. The consequence he can assess. Rehabilitation, based on the rehabilitation course, he can assess the consequences,
What is the
not the
quali-
disability.
What is the qualification of the doctor?
Who, my lord?
The one who has given the exhibit P17.
Psychiatric.
He is a psychiatrist.
Psychiatric doctor.
He is not the
that
doctor.
Manasa Nursing Home, it is the famous hospital.
He cannot, he has no
On the basis
authority to assess the disability.
And do
He
one-
can give only the report.
Sorry. On the basis of this
No,
report only.
please understand. I'll remand this matter if you want.
Let him.
You examine the doctor.
Allah.
How can a psychiatrist give the?
No. Psychiatrist, on the basis of the psychiatric report only,
And
sir, lordship, on the basis of the psychiatric report only, the doctor has doctor has to assess the disability. Not he is not assess the disability. On the basis of
has
this
to
report,
assess the disability on his own.
on the basis of the, he is taken supporting of the assess because he is a psychiatric
Only
department.
2 ways, either to remand this matter or I have to consider their submissions. If you want, on all the counts, go before, I'll leave everything open.
Because in fact, we are.
Pay and recovery order, both the appeals can be dismissed.
In fact,
Considering that.
Kindly.
As far as the insurance companies are-
Lordship, one more lordship. In fact, at the time of the accident, he was working as he was studying the Bapuji Ayurvedic Medical College, Shimoga. Then because of this accident, he left the course itself, lordship. And he joined the subsequently in the,
If really some injury or some disability to your client, if this
Remanded.
matter is remanded, you will get because head injury, not necessarily that there has to be taken 14%. If really has sustained 40% disability, then you can adduce evidence and your client will get a good amount.
it is true.
Instead of
Actually.
compromising with
In
this.
fact, it's
Only now the
initially,
only limited issue is examining the doctor by a disability certificate. We'll fix a time bound manner. We'll ask them to dispose of.
in fact, Lordship, out of record. In fact, this matter has been mutually settled before the Lok Adalat. We taken the 30% disability for us. And anyway,
It is true, it is true.
Then what is
We
the
have
difference?
discussed.
30% disability.
No, I will submit. We have discussed the matter for settlement. Thereafter, our higher management was refused to accept that since the evidence is against to the medical record, therefore
Sir, higher management wants now
the head office not agree for settlement.
for everything. Not even no percentage, completely like he's not entitled.
No. Certain
They're
amounts.
saying.
Your lordship can take up to 20 or 20% and dispose of.
in fact, initially we had discussed 30%. I leave it to
Correct.
Lordship.
It is.
Yeah,
They have not
yeah,
agreed.
because,
They have not agreed.
one more, one more ready.
So what we do is for loss of amenities, if you're taking the disability at
20%.
20%,
25.
Loss of
Future they have not agreed, my lord. We have given the proposal to the company. Company has not agreed.
loss of amenities. What was granted by the court? 25,000.
Please.
It has to be increased.
Which one, man?
Loss of amenities.
Please.
50,000.
He lost the course education because
No document for players.
because medical, sir, Ayurvedic medical, it is difficult to get the
BCom
seat.
student. Then
No, Ayurvedic, sir. No.
No.
Bapu
BCom
Medical
student.
College.
Sorry, sir. Second year BCom student.
What is the evidence he read?
I have read the evidence.
No, last year, initially he has joined the Ayurvedic Bapuji Medical. At the time only back he has met in accident.
Sir.
Then he leave the course and join the BCom. It's true.
Multiplier is 18.
Please. BCom andre 18, 17.
17.
I will.
Multiplier is what?
I will look into my lord once.
What is his age?
That's why.
Age is
18
years.
They have applied 18 only.
18 only.
20 years only.
21. Sorry.
Yella one
No, 7,56,000.
No, under the head of loss of.
Future prospects you are not
No,
seeing.
they are not entered.
Why not?
20. It is only less than 20%, my lord. There cannot be any future prospect. No, that is the reason. Up to 20%, there is no future loss of the only.
Anyhow,
If
you
it
are
is
not-
20 or 25, my lord.
You are not agreeing on.
We have we have agreed for that only, my lord. I am before your lordship. Appeal is for that.
Then I'll do one thing. I will take 21%.
Then definitely they are entitled to get that. My lord, considering the nature of injury and what he has given the evidence before the court, he is not having any disability. But apart from that also, now they have admitted the fact.
When you read the evidence, you said, no, he is continuing with his studies. Now, from what he submits,
Exhibit
he was
P15.
doing BHMS.
Assuming that
He joined in BCom because he's not able to continue.
no, my lord, assuming that each person is taken into consideration.
Will take 1%.
I paid
But
2 lakhs rupees towards my receipt is there, Lordship.
17,500 into 12 into 18 into 21 by 100. It's coming to 7,93,000.
ಬನ್ನಿ ಸರ್ ಬನ್ನಿ ಹಿಂದೆ ಮಾತಾಡ್ತಾ
It comes to 10,49,100. Yes, please come. Agreed with the award passed in MVC number 132 of 2019, dated 28th March 2024. Both the insurance company as well as the claimant are before this court. Insurance company's appeal is MFA number 4090 of 2024 and claimant's appeal is MFA number 5718 of 2024. Then counsel appearing for the claimant submits, insurance company submits that the offense are registered under section 181.
Please.
181 of the Motor Vehicles Act.
No, your lordship can see that.
Where?
Para 21 of the judgment.
21.
This is a tempo traveler.
20?
Para 21 of the judgment. No, 29, my lord, sorry.
Para 29. That.
It is discussed.
That the respondent number one is not having a valid and valid driving license to drive the particular category of goods vehicles involved in the accident. As such, he has violated the terms and conditions of the said policy. So transport, non-transport.
Please, that's the reason I'm
So they
submitting. That's what.
Should evaluate the terms and conditions of the policy issued by it. As such, the respondent number two is not liable to pay the compensation. The court has held that the insurance company is liable to pay the compensation, and counsel submits that the principle of pay and recover will apply. In the light of the law laid down in Mukund Devgan's case, Mukund Devgan's case, still the insurance company is liable to pay the compensation. Next para, coming to the enhancement of the compensation. The tribunal has granted the compensation as per the table given below. At page, at paragraph number 28, learned counsel appearing for the petitioner, for the claimant submits that the court, he had sustained a head injury and also a fracture. The court, under the head of pain and suffering, loss of amenities, has not granted a reasonable amount. Further, it is submitted that when it is a doctor's evidence that he had sustained 43% disability, court had considered 14%. 14%. Court has considered 14%. It is submitted that he was studying BHM in a homeopathy medicine, and because
BAMS.
of
BAMS.
BAMS.
MS.
Means what? Ayurvedic medicine.
Ayurvedic medicine.
He was studying BAMS, and because of the injuries sustained and the disability that he sustained, now he has joined in BCom. It is submitted that the court ought to have taken 43% as disability. Next parallel, and counsel appearing for the insurance company submits that while he was deposing before the court, he could depose before the court, and there cannot be any disability as assessed by the doctor, and the doctor had rightly considered all these aspects and had considered the disability at 14%, and no interference is called for. It is submitted that when he was in hospital for 40 days.
Not exactly. That's it.
When he was in hospital for 40 days, under the head of transportation and attendant charges, court had granted 25,000, 50,000, which is on the higher side than in his submissions. under the head of loss of earning during the later period, the amount that is awarded is not reasonable. Next para, having heard the counsels on either side, there is some material on record. First, coming to the liability, in the light of the law laid down in Mukund Devgan's case, insurance company is liable to pay, and this court finds no reasons to interfere. Next, coming to the quantum under the head of pain and suffering, considering the head injury, this court is granting 70,000. Medical expenses, no interference is called for. Coming to the loss of earning during the later period, considering the 40 days of hospitalization, 12,500 into 5, 62,500. Incidental expenses, as rightly argued by the land counsel for the insurance company, as he was in hospital for 40 days, this court is granting 40,000. Coming to the loss of amenities, considering the disability and the injury to the head, this court is granting 50,000. Coming to the loss of future income, the court had rightly taken 12,500 as income. Coming to the disability, just because he is able to depose before the court, that itself cannot be a reason for the court to come to a conclusion that there is no disability. Considering the facts and the fact that though he was admitted in BAMS, because of the injury, he has again had to join in BCom, and the impact of the injury on his on the life of the petitioner, this court deems it appropriate to take 21% as a disability. As the income is taken at 12,500, 40% future prospects would come to 5,000, that is 17,500. Into 12 into 18 into 21 by 100 is 7,93,000. In the light of the law laid down in Mekala versus so-and-so, towards legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 10,49,100. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from an amount of rupees 7,14,500 to 10,49,100. Accordingly, and the enhanced amount shall carry 6% interest. Accordingly, the appeal of the claimant, MFA number 5718 of 2024, is partly allowed by enhancing the compensation from an amount of rupees 7,14,500 to 10,59,100. The appeal of the insurance company, MFA number 4090 of 2024, is dismissed. Yes, next.
15, Nayak Krishna.
Take this, keep it.
Claimant's appeal for enhancement, my lord. Case of injury, my lord. Lord, production of additional evidence, my lord.
Para 13 table.
Calculated in this?
No, my lord, he has produced additional document.
Additional document produced, my lord, medical bills, my lord.
Medical bills.
Now we will not see this matter. This is matter next week on 20th of November. Yes, 16.
16.
Yes.
Challenging tribunal order, my lords. Tribunal order challenging the owner and the driver, my lords. The appellants.
You are the owner of the vehicle.
Yes, please.
What is the finding of the court?
My lords, finding of the court is my lord dependence. I am challenging the dependence, my lord. She is the deceased person was 70.
You are on the quantum. Please come to that order.
73.
What is the age of the
73, my lord.
73-year-old.
73-year-old?
As per postmortem.
73 years.
Please.
Which year is the accident?
Plus 2020.
20, my lord.
Date 18/7/2020.
14,500.
Malas, the trial court has given the considered the findings, saying that Malas, she is 73 years of old. She was working as a maid. So my point is, my lord, because she is 73 years, my lord, she cannot work, and my lord, there is not such document produced before the tribunal saying that, my lord, she is working. She was working. My lord, now also, my lord, they have not given any evidence to show that the claimants are dependent on, my lord, the deceased person. It is the only point.
Who are the claimants?
Claimants are son and daughters. Plus 3 children, my lords. Son is 38 as on the date of 2021. My lords, daughters 41 and
38, 41, 36.
Please, my lords. That's the only.
How you people will be dependent upon this
My lord,
lady?
kindly see para 37 of the judgment, my lord. As per the Honorable Supreme Court judgment, my lord, the tribunal has awarded 50% of the income, my lord.
Loss of estate.
Loss of estate is awarded, my lord. My lord, as per New
Rightly
India.
granted, loss of estate.
Please, my lords.
And then what is wrong with this?
Dependency, my lords.
What dependency?
50%
Loss of
is
dependency
taken
is
by
also
the
granted.
Plus dependency 7,000. They have to consider as, my lords. Kindly see page para number 39, my lords.
14,500
As
is
per
taken
Manovaljan's case, what is the calculation? Yes, Mr. Pradeep?
50%.
50% is
25%? Towards loss of estate. So, if it is, which year is the accident? You said 2020.
2020.
So 14,500, we have to take 25% of it.
Yes.
Then, my lord.
1 minute. It comes to 3625.
Please.
Lord, one submission, my lord. Loss of consortium, my lord, only 48.
That we will see. So 3625 into 12 into
5.
It comes to 2,17,500. Then loss of consortium.
My lord, 48,400 is awarded, my
How
lord.
many are there? 3 in number.
3, my lord.
Then funeral expenses, how much will come in that?
Funeral expenses is
15
also
minutes. 1550.
18,100.
No, generally in other cases we are granting 36,000.
30,000.
Same will come in this all.
Lord, 60,500.
Escalation. It's coming to 3,85,500.
With interest rate. With interest rate 6.
No, interest part is anyhow will be there. Calculation is that. 3,85,000. No, it will be reduced from 5,19,700 to 3,85,000.
And 15% contributory negligence. 15% contributory negligence is there, my lords.
15%
Is held by, my lord. I have not filed the appeal, my lord.
You have not filed.
You have not challenged.
So, 3,85,000. You can sit here and also tell the people who are talking not to talk. How many times the court officer has to tell? $57,825. Comes to 3,27,675. Please come. Agreed with award passed in embassy number 1455 of 2021, dated 3rd May 2024, whereby the court had granted 5,19,700 as compensation. The owner of the vehicle is before this court. The tribunal has held that the owner is liable to pay the compensation. The deceased was aged 73 years as per the postmortem, and the claimants are the son and 2 daughters who were aged about 38 years. 41 years and also, and 36 years. The tribunal has granted loss of estate, consortium, and also loss of dependency. Land counsel appearing for the petitioner submits that the deceased is age 73 years, and these petitioners cannot be termed as dependents on the deceased. They submitted that they're not entitled for loss of dependency, and in the law, in the light of the law laid down in Manovalgan's case, they're only entitled for loss of estate. Land counsel appearing for the respondent submits that the tribunal has rightly considered and granted loss of dependence and no interference is called for. Having heard so and so, as rightly argued by the land counsel for the petitioner, the deceased is 73 years and the petitioners cannot, they cannot say that they are dependent upon the deceased. In the light of the law laid down in Manovalgan's case, they're entitled for compensation. The accident had taken place in the year on 2020, considering the income at 14,500, 25% of it would be 3,625 into 12 into 5, and at the head of loss of estate 2,17,500. Loss of consortium 3 into 44, 1,32,000. Funeral expenses 36,000. Altogether, the claimants are entitled, but the compensation is 3,85,500. As 15% was held to be the contributory negligence, it comes to 57,825. And the insurance company is liable to pay 3,27,675. Accordingly, the appeal of the insurance company.
Not insurance company.
The owner of the vehicle is partly allowed.
Plus amount in deposited.
The amount in deposit shall be forthwith transferred. The amount shall carry 6% interest.
17, Vijay Kumar TM.
Yes.
It's not because it is not complied with the order, my lord. 9/1/2025, this court ordered 50% deposit. It's not deposited, my lord. And also.
That is not deposited.
Not deposited. Short question is involved regarding ownership. About by this.
Pass over. Yes, 18. Yes, Shivanagoda.
Claimants of appeal, my lord.
Shivanagoda. Pass over. 19.
19.
This list I will take up after the 230 matters. Yes, 19.
19, Gopal Krishna.
I pay for appellate in this case, my lord. It's a case of contributory negligence. Kindly TCI is required, my lord.
Yes, admit final hearing
Much
TCR
obliged.
20.
ECR received, madam.
Received.
Yes,
This is matter for final hearing.
Much obliged.
Yes,
20.
20.
I appeal for the appellant.
Surely that.
The only dispute is the admitted liability is 12,000 per month. The admitted liability is of the insurance company is 12,000. The
other
tribunal has
thing.
considered
Yes,
50.
yes, we'll take the pass over. Yes, next 21.
21,
Pass over. 22.
22,
Yes, Pradeep, ready?
Jamraj.
Ready? Yes.
Sir,
Case of death or injury?
case of death, my lord, para 17.
Yes. What is the age?
18 years.
17, 17 years.
There is a calculation error for MACT.
Yes, 1 minute. Age?
I have corrected in the analysis. What it comes, my lord, dependency,
Age is
17 years.
17 years. Income is taken at?
15,000, sir, correctly taken. 2021 is accident.
He has taken MACT also.
15,000. Future prospects will come
40%,
to
40%, 6,000.
into 40 divided by 100. It comes to 6,000.
6,000,
That it becomes,
21,000,
half of it is 11,500.
11,000. Into 12 into 18,
11,000 into
12 into 18.
comes to 23 lakhs. And what is it? 22 lakhs?
22 lakhs.
No, no. 1 minute. $10,500.
10,500 into 12 into 18.
I have taken 11,000. 10,000.
22 lakh 68.
Into 12 into 18. It comes to 22 lakh 68,000.
I written
Yes. Then loss of estate 40 into,
44 into 3, 1,32,000 I mentioned.
but it, 1,32,000.
Yes, madam.
36,000. It comes to 24,36,000 plus 10,000.
Please.
It comes to 24,46,000.
Yes.
Yes, please come. Agreed with the order passed and MVC number is?
MEC 457 of 21.
Huh?
There is
457.
There is one injury and one death case.
457 of 2021. Dated 27 January 2025. The claimant is before this court, claimants are before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation
50
of
lakhs.
an
50
amount of
lakhs.
rupees
50 lakhs.
50 lakhs, and the tribunal has awarded the compensation as per the table given below. Where is that?
Table, my lord, para 17.
17. 17. Then counsel appearing for the claimant submits that. What is the calculation wrong that is done?
That, my lord, 10,000 has taken, 12 into 18 multiplied applied, 21,60,000 is mentioned. After that, again 50% deducted. After calculating the dependency, again 50% deducted.
It is submitted. Amount is taken as 15,000 only.
15,000 only.
It is submitted that there is a calculation mistake in the order. It is submitted that the court had taken 15,000 per month as the income.
Page
No,
24.
court had taken
Page
10,000.
24. Page 24.
No.
Page
Yes,
24.
I'm looking at it.
No, my
Court
lord.
had taken 10,000.
Before that, my lord,
10,000
the
has
accident
taken
in the
and
year of
added.
2021, middle, my lord, middle line.
Yes.
Middle line. Income issued the State Legal Service Authority 15,000 per month. However, deceased might not have earning 15,000 per month. Like this, my lord, has been
But
discussed.
ultimately it has taken
10,000.
10,000.
Yes.
It is submitted that the accident had taken place in the year 2021, but the court had taken the income at 10,000, having observed that as per the chart, it is 15,000. It is submitted that the compensation that is awarded under the loss of dependency and also on other conventional heads is not just and reasonable. Then counsel say, appearing by the respondent insurance company, that the court has granted a just and reasonable compensation. It's having heard so and so, considering the fact that their age is 17 years and the accident had taken place in the year 2021, this court is taking the income at 15,000. Future prospects at 40% will come to 6,000, that is 21,000. As he's a bachelor, 50% has to be deducted towards personal expenses. Then it comes to 10,500 into 12 into 18. Towards loss of dependence, it comes to 22,68,000. 4 are the dependents. Three are the dependents. 3 into 44, 1,32,000. 36,000 towards the funeral expenses. 10,000 towards legal expenses. Altogether, the claimant is entitled for an amount of rupees 24,46,000. Accordingly, the appeal of the claimant is partly allowed, financing the compensation from 11,80,000 to 24,46,000. The enhanced amount shall carry 6% interest. Yes, next matter.
23, Shantraj.
This case,
Yes.
he was
Yes.
income has taken instead of 33,000. 30,000 has been taken and it has added 25%. He was deceased, it was aged about 40 years.
He is 40 years.
40 years. Instead of 50%.
What is his income?
Income 33,000.
Was taken.
Not taken. Average has taken. There is no question of taking average.
We'll continue this after lunch. Yes. I will continue this list after 2:30 matters. There are very few matters. After that, again, we'll take up this list.
Serial number 21.
Oh, what 21 now?
It's been passed over, and
Oh.
it will take up.
Taken up?
Next week.
Why?
Finally, today we have filed wakalat in that.
21 next week.
This 517, application at 3 o'clock. Difficulty today. I don't have an intermodal.
What is that?
This 5 is number 17. It's just a fresh matter. I lost my habit about 2 weeks or a week. Today I have an application at 3 o'clock. This 517. Fresh matter.
I should not adjourn your matter for continuously disturbing the court by continuously talking in the
I'm
court.
sorry, Manoj. I realized it was me that my lodge is
Yes. Which is serial number?
17. Just 5.
Inform the other side.
I'll inform. There's no
It is
intermodal.
submitted that there is no interim order and the petition has some inconvenience, and he'll inform the same to the counsel for the respondent. This is matter after 2 weeks. Yes.
ನಾನು ಬರ್ಕೊಂಡೇ ಇಲ್ಲ, ಮತ್ತೆ ಕೇಳ್ಬೇಕು. ಯಾವ್ದು ಅಡ್ಜನ್ ಆಗಿದ್ದು? 21 ಯಾವತ್ತು ಹೋಯ್ತು? 21 21 2 weeks
ಹೌದು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇದು ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಅಲ್ಲ 17 ಲಿಸ್ಟ್ 517 2 weeks
21 ನೆಕ್ಸ್ಟ್
next
ವೀಕ್.
week.
ಲಿಸ್ಟ್ 3 ಕಂಟಿನ್ಯೂ ಆಯ್ತಲ್ಲ, ಲಿಸ್ಟ್ 3 ಆಗ್ಬೇಕಲ್ಲ.
2 weeks ಅಲ್ಲ 17. ನಾನು ಡೇಟ್ ಕೊಡಂಗಿಲ್ಲ, ಮೇಡಮೇ ಕೊಡೋದಿಲ್ಲ. ನೀವು ಇವಾಗ ಬಂದಿದ್ದೀರಾ, ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು ನೀವು. ಹ್ಮ್ 21 ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್. ಸಂಜೆ ಜಾಸ್ತಿ ಮ್ಯಾಟ್ರ್ ಇದೆಯೋ ತಗೊಳ್ಳೋದು ಕಷ್ಟ ನೋಡಿ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನೀವು. ನೋಡಿ ಇದು 5ನೇ ಲಿಸ್ಟ್ 2:30 ಇದೆ, ರೀಚ್ ಆಗೋದೇ ಡೌಟ್. ಆಫ್ಟರ್ ಲಿಸ್ಟ್ 5 ಆದ್ಮೇಲೆ ತಗೋತಾರಂತೆ. 2:30 ಲಿಸ್ಟ್ ಇದೆ ಸಪರೇಟ್. ಲಿಸ್ಟ್ ನಂಬರ್ 5 ಲಿಸ್ಟ್ ಇಸ್ ದೇರ್. ಹೌದೌದು. ರಿಪೋರ್ಟ್ ಅವ್ರು ಯಾರು ಸರ್ವ್ ಮಾಡಿ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಫೈಲ್ ಹೋಯ್ತು ಅದು. ಅವ್ರು ಟೈಪಿಸ್ಟ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ ಟೈಪ್ ಮಾಡಿ. ಫೈಲ್ ಇಲ್ಲಿ ಹೆಂಗಿರುತ್ತಪ್ಪ? ಫೈಲ್ ಒಂದೂ ಇಲ್ಲ ಇಲ್ಲಿ.
ನಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 33 LCR ಬಂದಿಲ್ಲ ಬರೋದಿಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್. ನೋ ನಮ್ಮ ಕೇಸಲ್ಲಿ ಬಂದಿಲ್ಲ ಇದು. ಹಾಂ ಓಕೆ ಓಕೆ ಬಟ್ ಇನ್ ಮೈ ಕೇಸ್ ವಿ ನೀಡ್.
ಯಾರು ಅವರೇ ಬರ್ತಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಗುರುಳೆ ನನ್ನೊಂದು ಕ್ವಾರ್ಟರ್ 9 ಅಲ್ಲಿ ಅದು ಕರೆಕ್ಟ್. ನಾನು ಹಂಗೆ ಹೇಳಲ್ಲ ಬಿಡಿ, ನಿಮ್ಮ ನಾನು ಕನ್ವೀನಿಯಂಟ್ ಮಾಡ್ಕೊಳಕ್ ನಿಮ್ಮ ಮೇಲೆ ಯಾಕೆ ಹೇಳಕ್ ಹೋಗ್ಲಿ ಸರ್, ಅದು ನಾವು ಹೇಳಕ್ಕೆ ಹೋಗಲ್ಲ ಹಂಗೆ. ಬೇಕಾದ್ರೆ ನಮ್ಮ ಮೇಲೆ ಹಾಕಂತೀವಿ ಹೊರ್ತು ನಿಮ್ಮ ಮೇಲೆ ಹೇಳಕ್ ಹೋಗಲ್ಲ. ಕೆಲವರು ಮಾಡ್ತಾರೆ ಹಂಗೆ, ಅವ್ರು ಕೋರ್ಟ್ ಹೇಳಿದ್ರು ಅಂತ.
230 list.
List number 5, serial number 1 urgent, serial number 2 Jagdish, serial number 2, list number 5.
Yes. Yes, Mr. Shantras, I'll take up these matters after 230 list. Yes. I will take up after that. Yes. Yes, 2.
Serial number 2, list number 5 Jagdish.
This matter came up on 3/11/2025. As there is no representation on behalf of the petitioner, the matter is directed to be listed today under the caption for dismissal. Today also there is no representation. Dismissed
3
for non-prosecution.
Abhinav Ramanand.
Yes. This same, this also same. 3/11/2025. No representation. Posted for dismissal today also there is no representation.
Serial number 4 Somshekhar.
In this
Yes.
case, pleadings respondents has to file objections, my lord. Respondent 1 to 4, they have not yet filed objections. Their
Hearing
pleadings
for
are not
respondent number 1
completed.
and 2.
Let us see what is the petition about.
My lord, it will post it for hearing, my lord. I'm not.
Let's see what is the petition.
My lord, in this case, my lord,
Yes.
the respondent, your lordship, when the
What is the
MSME
impugned order?
has released, written letter to the bank for restructuring the loan account, my lord. Your lordship
No,
can return to.
let us look at your prayer.
Yes, my lord.
Please come to the prayer.
Annexure A6, I am seeking quashing of the order passed by the, in SA 8 of 21. On the ground, my lord, it is covered by the judgment of the Supreme Court. When the MSME scheme is under process, the bank has no power to hold the account as NPA, my lord. That is the covered by judgment, my lord. Your lordship can return to the letter written by the bank.
No, no.
Dated.
First come to the impugned order.
My lord, your lordship, that matter, that is not addressed by the DRT, my lord. Because, my lord, it
No,
is
no.
constitutional validity
First
of
of
the.
all, you have to question it. Whether what have you done? Let us see.
Please, my lord.
Come to the impugned order.
Since I am not fully ready with the matter, my lord.
Other side has moved a memo. Why will
Other
they
side,
move a
might
memo?
but contesting respondents, they have not filed any objections, my lord.
If they are not filed, they are not filed. They will be not
Please,
be
my lord,
filing
you
at their
can
cost.
fix a date, my lord. I will get ready and.
There is no fixing the date. It will come. This
next
is
week, my
matter.
lord.
This is matter on 10th of November.
Please.
No further adjournments will be
Please,
granted. Yes, next 5.
5 Tesh Kumar.
My lords, I appear for petitioner. I seek for a short accommodation
Why?
of time, my lords. I have to comply with one office objection, my lords. I may be.
Without office objection, this matter is going on from 2024. We will give you time. No, no. Even if you don't comply with also, we can hear. Any interim order in this?
No, no,
Huh?
no, my lords. My lords.
Then why is it pending from 24? I'm requesting the advocates, no adjournments will be granted just like that without a reasonable cause. Now, you are apart from non-complying with the office objection, please come to the order.
My
Order
lords,
impugned.
maybe matter may be passed over, my lords. Senior will.
Yes, please ask your senior to come. No, not pass over, list this matter on November 10th. No further adjournments. Yes, next.
Grateful, my lords. Same, my lords.
This also.
November
No,
10th,
no
my-
further adjournments. Yes, 7.
7 Siddhanur Vishwanath.
Here for petitioner. Withdrawal memo.
Huh?
Withdrawal memo. They already approached DRT.
Take that. The memo is filed stating that the petition is filed questioning the possession notice. Thereafter, questioning the order under section 14 of the Surface Act, they have filed a essay before the Debt Recovery Tribunal, that is essay number 37 of 2025. Hence, the petitioner wants to withdraw this writ petition. Memo is taken on record and the writ petition is dismissed as withdrawn. Yes, next.
8, Akash or Rao?
I appear for the petitioner in this case, my lord. My lord, I
Yes.
seek a week's accommodation in this matter. I'll have to seek certain instructions from the client. There was an interim order, my lord, with respect to payment of 30%. In fact, I've gone ahead and paid 50% of the total loan amount, my lord. Now the bank has come up with a state. No, I have not moved the memo, my lord.
Who moved the memo? Huh?
No,
You moved the
the
memo?
memos.
Which matter is this?
Listed.
It's a date given matter. Yes.
Lordship, one small submission. In a previous date, the court has given direction to clear all the balance. Otherwise, dismiss the petition.
No, my lord, there was no such direction as such. It was only the direction was they gave us a bank statement. My lord, the total loan amount was 60 lakhs. And in virtue of the interim order, my lord, I have paid 30 lakhs, which is in
No,
fact
the
more.
last order dated 2025 is to list this matter on 17/9 to dispose of the matter on the merits of it.
Please, I seek for week's accommodation. I'll have to seek certain instructions from the client.
Yes.
It may be taken up any day next week, my lord.
List this matter on 11th of November. No further adjournments will be
Can
granted.
it be on 12th, my lord? Can it be on 12th, my lord? 11th, there's some inconvenience.
From next week, all these matters will come only on Monday and Tuesday. Yes, 8th.
My lord, can it be a week after next, my lord? 11th, I have some inconvenience. That's the whole concern.
Then for you, I will take it up on 12th. Yes,
Grateful,
12th.
man. Grateful.
Yes, call the list.
Number 9.
In this case, appearing for
Samir.
respondent bank, my lordship.
Further, petition interim order already
Huh?
interim order complied.
We will hear the main matter coming up for vacate stay. Yes.
Lordship, they are challenging the section 14 order, my lordship, from since
Let
2020.
him say, let him say. Yes. Where is the notice?
Earlier paid 1,05,000 already paid. After
What is the outstanding amount?
7,57,000.
Huh?
7,57,000.
So 7,50,000. How much you paid?
2.5 plus 3.5.
Huh?
2.5 plus 1 lakh, total 3.5 lakh.
3.5. So what is the outstanding now?
Lordship,
3.75 is the outstanding.
For
Huh?
3.5.
So when are you going to pay this amount? I will list this matter on 11th of November. By that time, you should come up with an undertaking. When are you going to pay the remaining amount? Then that's the only ground on which this court can consider. Otherwise, any of 14 notice, you can't come before the court.
One submission, my lordship. As of now, present outstanding balance is 9,50,000, my lordship.
9,50,000. Out of which how much he has paid?
Right, the interim order was complied by
16/7/24 interim order complied.
on 2024. He complied the interim order. From 1 year, he
Whatever
enjoyed-
is outstanding, you please give the particulars to him today itself. What is outstanding? Let them come up with an undertaking on 11th. If they come up with an undertaking, otherwise I will pass orders on the merits of it.
Grateful, my lordship.
The writ petition is filed, questioning the possession notice issued under section 34 of the Surface Act. When this matter, a coordinate bench of this court has passed an interim order on 7/6/2024. Subject to the condition that the petitioner shall deposit an amount of 1 lakh on or before 18/7/2024. Land counsel for the petition submits that he has paid the amount as per the interim order, and according to him, he has paid a total amount of rupees 3,25,000. 3,25,000. According to him, the outstanding is 7,50,000, and according to the land counsel for the bank, the outstanding is 9,50,000. Whatever is the outstanding as on today, the bank shall furnish the same to the counsel appearing for the petitioner. The petitioner, by the next date of hearing, shall file an undertaking, shall file an uh, undertaking like with regard to the time frame and when he is going to pay the remaining, the outstanding amount. If no such affidavit is filed by the next date of hearing, this matter would be heard on the merits of it. Yes, this matter on 11th of November. Yes, next.
Number 10, Venkatesh Murthy.
10 and 10.1, my lords, are both pertaining to the same matter. My lords, I believe on the last occasion, my esteemed friends indicated that the writ is not maintainable, my lords, as if giving it a color that it's under surfacey. I'll demonstrate to your lordships that it's not. My lords, before your lordships looks at the paper, please give me, my lords, 30 seconds. I'll put the factual matrix before my lords. United Breweries Holding, my lords, was a holding company here, UB, my lords. It was a rather famous beer company. There were Kingfisher Airlines, my lords, which defaulted in certain loans. Vijay Mallya, one of the petitioners here, my lords, was a guarantor to that loan. That was about 800 crores in terms of loan. In addition to he being a personal guarantor, United Breweries Holdings Limited, my lords, which is the upstream holding company, also stood as a guarantor. Those proceedings, my lords, went before the DRT. The DRT, my lords, finally issued a recovery certificate. That recovery certificate approximately, my lords, is for 6,200 crores and 11% interest. My lords, therefore, because the company, which is also my lords company by its erstwhile director, is a petitioner, we were all guarantors, everybody got sucked into that recovery. The recovery proceedings continues and the recovery officer, my lords, under Rule 33 maintains a statement of accounts of monies coming into the kitty. Now, various assets, my lords, belonging to Vijay Mallya, belonging to United Brewers Holding and other assets were all either, my lords, attached because of certain PMLA proceedings or, my lords, brought to fruition in terms of sale or handing over to the company, to the banks. That resulted, my lords, in multiple recoveries, leading to, my lords, one dichotomy. And why the writ petition is because of that dichotomy. The recovery officer's certificate, my lords, demonstrates that something like 10,000 crores has been recovered. The primary debt, my lords, your lordships will remember, is 6,200 crores plus 11% interest. We, my lords, indicated that that's not correct. A lot more of our assets have been taken and sold and money is recovered. My lords, this correspondence between the banks, between, my lords, the bank solicitors, etc., my lords, went on and there was no fruition. We apply for a certified copy, my lords, before the recovery officer. The recovery officer issues, my lords, a complete order sheet in certified copy to us, which also, my lords, does not demonstrate that a larger amount is taken, only 10,000 crores is in. Fortunately, my lords, for us, the finance minister on the floor of the house then makes a statement. And that statement today is buttressed, my lords, by the annual report of the Ministry of Finance, which is, my lords, the bosses for all these banks. That an amount, my lords, fully recovered is 14,131 crores. A dichotomy, my lords, about 4,000 crores. We, my lords, file a writ petition, my lords, on two counts. One, there are three proceedings. One is PMLA proceedings, of which I, as a company, I am not concerned, my lords, in 10.1. But yes, in 10, my lords, the petitioner is concerned because PMLA proceedings are against him. There are multiple proceedings in PMLA courts. Second, there is a recovery proceedings and a recovery officer, my lords, who is initiating action. Third, there is a winding up proceedings and, my lords, the official liquidator of this honorable court also, my lords, looking into the matter. And the official liquidator also places on affidavit that far more than what is owed, my lords, is today recovered. But this dichotomy of these three indications, which is not coming into fruition, we file a writ petition, my lords, seeking upon the banks. We have nothing against the recovery officer. He's just an officer, my lords. I can't seek a mandamus on him. Not that I can't seek, my lords. I could, at my lord's threshold, seek that mandamus, but I get nothing from it. I seek a mandamus against the bank that the banks must now provide the entire statement of accounts of what is recovered, whatever it may be. If it is less, more, if I'm continuing to be liable, I am. But if I'm not liable, my lords, I am entitled under 466 of the Companies Act to then go before the company's court and revive the company. My lords, the individual Vijay Mallya may not, my lords, whatever proceedings against him is one thing. But the company which has valuable assets needs to be revived. It was one of the flagship companies. The objection that my friends raise is these prayers are in as if it's in the form of an RTI and therefore the writ is not maintainable. Lords, I will make good that case. Would your lordships permit me to show 3 or 4 documents, my lords, and then I'll come straight away to my prayers.
Yes.
My lords, I must indicate to my lord today, my lords, before your lordships permits me to start. The matter today, my lords, is listed only for orders on two IAs, my lords, which is on my side and possibly, my lords,
We'll hear the
rectification.
matter. Let's
Yes,
not
my
go
lords.
into those
This
orders.
could be ignored, my lords. Sir. My respect to submission. My lords, may I request your lordships to look at item number 10?
Yes.
Yeah. The papers are common, my lord. Just one or two aspects in 10.1. I'll come later on. My lords, I have also taken the liberty, subject to my lord's leave, of a detailed list of dates, my lords. I will request my lord to keep it by the side if there is a need, my lords, for the date, but I'll just straight away take your lordship to the documents.
Yes.
My lords, please straight away come to page number 210, my lords, annexure B of the writ petition. This is, my lords, the recovery certificate, the the debt recovery tribunal's order, my lords, and then a consequent recovery certificate. My lords, 210. Would your lordships permit me? Yes, sir. If my lord is 210, please, my lords.
Yes.
May I request my lord to come to 215, the operative part of the recovery certificate?
Yes.
My lords, on 215, on the top quadrant itself, recovery certificate for on the very top, 620335, etc. Approximately, my lord, 6,203 crores. Please see, my lords, in two paragraphs down in A.
Yes.
Defendant 1 jointly and 1 to 4 jointly and severally, the guarantors are included, to pay a sum of 6,203 crores. Please ignore two lines, with further interest at 11.50 per annum at yearly rests. So, my lords, two things are crystallized: 6.6203 crores plus 11.5% interest and annual rests.
Yes.
My lords, please see certificate debtor 1 is Kingfisher. I don't stand to plead for Kingfisher, my lords. It's under liquidation. That's the primary debtor. My lords, certificate debtor 2 is United Breweries Holdings, my lords, for which the erstwhile director has filed 10.1. That was the guarantor. Vijay Mallya, my lords, one of the guarantors. Finvest, my lords, is the other company. I stand only, my lords, for 2 and 3. Would your lordships now, my lords, straight away come to volume number 3, page number 1270. I'll request the court master to place that volume. I'm sorry, my lords, for the voluminous papers.
Yes.
1270, my lords. That's the press release, my lords, by the Enforcement Directorate in terms of what they have recovered.
Page number
My lords,
1270.
page number 1270, please.
Yes.
My lords, if my lords would permit me to invite my lord's attention to the very top, press release 16/7/21. My lords, kindly see the recovery certificate was issued in 2017. Now we are, my lords, in 2021. My lords, please see the language, my lords. Today, the SBI-led consortium, they are the banks as respondents before your lordships. Respondents 2 onwards, my lords, are the banks. Respondent 1 is the recovery officer. Today, the SBI-led consortium realized, and these are words used by authorities, 792.11 crores by sale of shares in Kingfisher Airlines Vijay Mallya cases. These shares were handed over by the Enforcement Directorate to the consortium. Earlier, SBI-led consortium had realized 7,181 crores by liquidating assets handed over to the SBI-led consortium by the Enforcement Directorate. My lords, I won't trouble your lordships with the rest of it, etc. My lords, at the least, therefore, it is 7181 crores. It's actually 7181 plus 792. Please ignore, my lord, 792 for the time being. My lords, that now takes us to the recovery proceedings. Please see, my lords, on page number, my lords, 1197. Volume 3. My lords, if your lordships has that sheet.
Yes, sir.
My lords, please see, my lord, this is the RO, that's the recovery officer's proceedings. This is, my lords, dated 29th of August 2022, if my lord has that.
Yeah.
My lord, this is now 1 year after the ED's proceedings. Let's kindly see proceedings before the recovery officer 2, 29th, etc. So and so for CHB, etc. None present for third party. But order in IA number so and so TRC, etc., etc. Please ignore that paragraph and please come to, my lords, the paragraph which is following the larger paragraph which says it is noticed.
Yes.
I read that with my lord's leave. It is noticed that the total of 10040, that is, my lords, 10,040 crores has been recovered, and these are, my lords, again words of some legal aptitude, have been recovered against the recovery certificate amount of 6,203 crores, which includes the amount recovered out of the sale of movable properties transferred by the Honorable PMLA Court to the consortium of banks, etc., through recovery officer 2. Now, this crystallizes 10,000 crores. Not just two other documents. Please now see, my lords, the official liquidator submissions before this honorable court. Your lordships will find that, my lords, in the writ petition itself. 1198, my lords, in the same.
Yes.
My lords, in 1198, please see again just two lines. Your lordships will find this is company petition 57 of 2012. My lords, one tangential submission, my lords, on this. The reason why this company, my lords, this is one of those cases where, my lords, going before the IBC, my lords, this company missed, because the notification came in, my lords, that matters admitted by the company court will remain with the company court, others will go under IBC. If that had gone to the IBC, my lords, given the benefit of IBC, this would have, my lords, been resolved fully. Banks would have possibly taken a haircut, and, my lords, the resolution professional would have closed the matter one way or the other. Because this got stuck, my lords, in the company proceedings in the High Court, and there was a recovery certificate. Every penny, my lords, which is in the recovery certificate is sought to be recovered. Be that as it may, my lords, 6,200 crores plus interest is what I should pay. And I don't contest it, my lords, today. Please see, my lords, in 1198. Kindly see in the next page, your lordships will find at 1199. I'm just reading 4 lines of that affidavit. My lords, during the course of the submission, learned senior counsel appearing for the official liquidator, that's the liquidator of the company, submits that the consortium of banks has already recovered the amount due in excess of what is adjudicated. The learned senior counsel seeks a short accommodation to place records, etc. Therefore, my lords, in a judicial forum before this honorable court, the statement is, at least from the OL's perspective, the banks have been given more than what is due to them. My lords, this takes us, my lords, to just 2 more submissions. Please permit me to come to, my lords, volume 1, my lords, I'm coming back to volume 1, just 2 pages in that, 307, my lords, annexure E1. Where is annual report? Yes. My lords, at 307, if your lordships has E1, before I read, my lords, the relevant part, on the very top, my lords, it's a fine print. Your lordships will see, my lords, it says uncorrected / not for publication. On the very top, my lords, which is the header. My lords, the reason why this was filed is this was filed as soon as it was put up on the website. We have thereafter, my lords, with a memo, filed, my lords, the corrected version, because, my lords, all statements made on the floor of the house, first the uncorrected version comes out. If there is a correction, corrections are made. The corrected version is in the form of a memo, and there is no, my lords, there is no discrepancy, my lords, between the uncorrected and corrected version. My lords, please permit me to just read, my lords, 2 lines. My lord, this is the statement by the Honorable Minister for Finance on the floor of the House. These are resorted to properties worth of 22,000 crores in major cases, and this 22,000 does not pertain to me, my lords, it pertains to a multiple case. And I would like to list the number of cases, full stop. In Vijay Mallya case, the attached properties worth 14,131.6 crores have been restored to the public sector bank. My lords, kindly note the word restored. Your lordships have held in multiple judgments that restoration means they are being brought back to the economic position on where they should be. And restoration in law, my lords, does not mean anything less than that. And your lordships have held in GMR, Varora, etc., my lords, multiple scenarios, both this honorable court, my lords, and the other southern courts on the electricity side, which the Supreme Court has upheld. So there is no way on which I can go on listening to many members who without facts are going on to saying so and so, full stop. No haircut has happened. Big people are allowed to take the money and small people are punished. No way, we have not let that anyone. Even if they have fled the country, we have gone after them. The Enforcement Directorate has collected this money and given it back to the public sector bank. Kindly under that money. Given back to public sector bank, the amount of 14,131.6 crores has been restored from Vijay Mallya only. Therefore, restoration of 14,000 crores. Please permit me to just buttress this with the Finance Minister's annual report, my lords. I have, my lords, filed the annual report at, my lords, page number 127 of a rejoinder. This is the last document, my lords, I'll trouble. This is, my lords, the rejoinder in 10.1, the petitioner's rejoinder. Item number 10, rejoinder, page number, my lords. at 101, my lords, your lord, it starts, my lords, at 79. My lords, your lordships, just glance 79. 79 says, this is my lords.
Because there are only,
I'm
there
so
are any
sorry.
other, when it says rejoinder.
How does the rejoinder look?
So this volume 1, 2 and 3, apart from that, there is a rejoinder.
Yeah, apart to that, my lords, there is a rejoinder volume, which we have filed, my lords, on 27/10/2025. Show me the rejoinder volume.
Yes.
My lords, if your lordships has that rejoinder volume, please permit me to invite my lord to 79, my lords.
Page 70.
79, please, my lords. Annexure A, my lords, it's AH, my lords. It's not A11, I'm sorry, it's AH, my lords.
Yes.
My lords, on 79, your lordships will see, my lords, this is the report of the Ministry of Finance. Again, my lords, the nodal ministry and the ministry which controls the public sector banks. Please permit me straight away to come to 101, my lords, in this report. This is the annual report of 24-25. I will trouble my lords just with 3 lines, my lords, at 101.
Yes.
My lords, please see on the right hand quadrant of this page, there is, my lords, 4.2.14. Lords, on the very top right hand quadrant, my lords, if your lordships has 101. With my lord's leave, I read, my lords, about 5 lines there. 4.2.14, restitution of properties to victims of money laundering / legitimate claimants. ED is not only actively pursuing economic offenders and unravel money laundering, etc., etc., but at the same time, it is making efforts for the restitution of assets to banks and others who have been defrauded by the offenders. The ED has successfully restored, kindly note that, restored properties valued approximately at 22,280 crores to victims or legitimate claimants. The details of the restitution / restoration done by the EG is given below. Kindly see item number 1, Vijay Mallya case, quantum of monies 14,131.6 crores. Please see, my lords, the rendition there, details of restoration. Complete amount of attached properties have been successfully restored to the public sector banks. My lord, in this light, the banks now file a statement of objections before your lordships. I have taken the liberty of putting it in one sheet because there are detailed objections, my lords. Please permit me to place this. And this is what, my lords, this is what the banks ultimately indicate. And this gap, my lords, is the gap that is troubling me. Either there is a payment or there is no payment, my lords, but 4,000 crores can't fall within the cracks. My lords, please see what I have indicated. This is, my lords, amount received by the consortium, etc., etc. Please come to serial number 1. Your lordships will find I have put, my lords, first column serial numbers, case number references, courts in which it is pending. Next is the date of undertaking. This is the bond undertaking which the bank issues, and I'll come to that in a minute, my lords. The bank issues to the enforcement directorate when, my lords, they receive the properties. Then, according to the banks, a temporary amount that is received. Thereafter, my lords, what is indicated is whether the recovery officer's orders records this or not. My lords, please see item number 1. Please come to the last 2 columns itself. The 1,006 crores, that is 1,006.61 crores. This is not recorded in the recovery officer's daily order sheet, and which I have, my lords, but it is restored to the banks. Please see, my lords, item number 2. Again, High Court proceedings pending here. 651 crores restored to the banks, temporarily received by the banks, not recorded. My lords, item number 3 is recorded. Item number 4 is not recorded, 39 crores. Item number 5, my lords, is in 2 proceedings, 6,203 crores, not recorded in the recovery certificate.
No, what this 2-1, this page number 210, volume 1.
Your lordships are asking for page number 210.
In the first volume, it is mentioned 6203 in the recovery proceedings.
No, my lords, I'll show
what
the
you are
recovery.
mentioning at 5.
Yes,
with
please,
regard
my
to this 6203 crores.
No, my lords. Kindly see on the extreme right, my lords, while 6303 crores in the proceedings in the PMLA court, they say it has been given to the banks. The recovery officer does not record it. And your lordships know, my lords, in a DRT proceedings, until the recovery officer gives me an accord and satisfaction, my interest continues to run and I continue to be a debtor. How do I revive the company, my lords? And my lords, the whole reason for a writ is there are multiple adjudicating authorities and the recovery officer has no information. My lords, I have the certified copy of the recovery officer's entire order sheet. This amount, my lords, of 6203 crores, there is no mention. My lords, please see the last two, my lords. I'll conclude with that in terms of papers.
Yes.
My lords, item number 6 is 5,824 crores. That is recorded, my lords, in the recovery officer's record as well. I have put the dates on 25/6, my lords, at page number so and so it's recorded. Finally, my lords, there is another 700 crores which has come in. That is also, my lords, recorded. My lords, the cumulative value of this, what is temporarily received by the banks, is, my lords, 14,426 crores, which broadly, my lords, corresponds to what the learned finance minister indicated, 14,131 crores.
Yes.
Lords, therefore, two submissions, my lords, in law, with utmost respect, I will place at my lord's threshold. In paragraph, please see, my lords, the objections of the banks now in 1 minute, and I'll come to the law. Please see just two paragraphs of the objections where the banks indicate that they have not received these monies and there is still an amount which is, my lords, due. I will take your lordship straight away to the statement of objections of the banks.
Objections of the bank. Take it.
Filed by R2, please.
Just tell me.
Page number what?
Yes.
My lords, please come to page number 30, my lords, paragraph number 7. And I would request my lord, my lords, with a kind leave of your lordships, to keep that one-page document that I have placed. I have extracted these details, my lords, from page 30, the table after para 7. My lords, kindly see 7. Undertakings given by the respondent number 2 to 12, the banks, before this honorable court, PMLA court Mumbai, and also the DRT, while receiving amount as conditional recovery with an undertaking that the amount will be returned as and when demanded by the court. Few of such undertakings are below. I'll come to that return basis, my lords. Your lordships will see item number 1, 2, 3, 4, 5, 6. Please turn 2 sheets, my lords, the whole thing. And please come to 32. 1 minute. And none of these undertaking copies are produced, but be that as it may. 32. All the above cases are pending for adjudication and it is not yet reached finality. Under the circumstances, kindly note this, the recovery made through court cannot be construed as recovery in the legal sense as on date unless all cases are finally adjudicated. You receive the money, you put it into your accounts, the minister says that it is fully restored to the banks, you keep the money with you. That money is not sitting idle, my lords. The bank is using that money for their purposes. If they don't want to give me an accord and satisfaction, my interest meter should stop ticking. My primary liability was 6,500 crores with 11% interest. 14,000 crores is recovered. According to them, there is another 5,000 crores which should be recovered. And until these proceedings go on, my lords, this 5,000 crores due will become 25,000 crores. There is no light at the end of the tunnel for me, my lords. And if I can't file a writ petition under those counts, and my friends, my lords, belittle it by saying it's an RTI application, then why a writ remedy at all, my lords? Where else do I go? Only a constitutional court can direct them, saying either you don't receive the money, let the money sit with the ED, I will fight that battle. You receive the money and put it into your coffers. Then you can't say, no, it is temporary. Money is money. It has gone into your pocket. Yes, if you have to return the money back, by all means, I could still be, my lords, held responsible for it. But nobody knows whether the victory is in my favor or their favor. Now, this sentence, my lords, that is, all the above cases are pending adjudication and it is not yet reached finality under the circumstances. The recovery made through court cannot be construed as recovery in the legal sense. Respectfully, it is beyond the bank's paycheck to say it, because the bank's nodal ministry in its annual report says it is fully recovered and restored. Finance minister on the floor of the house says fully recovered and restored to the banks. Of course, my lords, your lordships will say if the clock has to be set back, it has to be set back. The assets are available. I would well give an undertaking as a company that not one of my assets, if my company is revived, I will sell. Those assets could be available for them. But it can't be that the interest meter runs. In that light, please see the last paragraph, my lords, of this, which is, my lords, in paragraph page number 33. Your lordships will find at 32 bottom, my lords.
Yes.
My lords, they say, I certify that pursuant to the issuance of a recovery certificate, State Bank of India, and I'm reading, I'm sorry, my lords, 31 bottom, I should have indicated, 32 bottom, my lords, Roman, it says small 3. I state that pursuant to the issue of the recovery certificate, State Bank of India and the consortium of bank members are entitled to recover the following amount. They put those amounts, etc., etc. Kindly see, my lords, down in the next page 33 on top. Total amount, my lords, is according to them 6,848 crores, which is the recovery certificate, and a 10,000 crores, that is 10,623 crores, which is the interest, which is 11% per interest, which is annual, which comes to 17,000 crores. My lords, now please see the next paragraph. I state that under the above circumstances, following amounts will have to be temporarily recovered and restored temporarily to the consortium of banks under the DRT. Serial number 1, particulars of temporary recovery 10,814 crores, whereas the ministry statement is 14,000 crores, and balance to be recovered is 6,656 crores. By this logic, therefore, my lords, it comes to about 17,000 crores. My lords, it is in this light, my lords. There are only two things that could happen. Now, please see this last sheet of paper which I gave, my lords. Please see illustratively, my lords, item number 1. My lords, in item number 1, your lordships will find that there is 1,006 crores which is recovered as on 28/3/2019. I stand at my lord's threshold to plead in 2025. My lords, the interest on this 1,000 crores cannot continue to accrue from then to now. If they have received 1,000 crores, the 1,000 crores is attributed, and it is only on the balance amount that interest can apply. None of that calculation is made. A statement of accounts in which what is the interest that is attributed is not given. What do? I go to the DRT. I make an application before the recovery officer. Recovery officer issues his daily orders. It demonstrates to me that the balance of about 4,000 crores is not even shown in the recovery officer certificate. And my lords, in fact, the restoration order, which was made by the PMLA bank, and that's the last document I will show, specifically indicated that the PMLA court is restoring these assets to the bank through the recovery officer. They have no direct privity to simply take the property, attribute it, and not tell the recovery officer. Please see, my lords, one page in the writ petition. Volume 1, Annexure C. The order starts, my lords, at 232. 232, please. Order starts, my lords, at 232. I'll straight away invite my lord to 251, which is, my lords, the relevant portion of the order.
Yes.
My lords, at 232, please, for a minute, glance through it, my lord. This is the court of the special judge for CBI, etc., Greater Mumbai, etc., PMLA special case, so and so, so and so. And the banks admit in their affidavit that two courts, my lords, the Bombay court and the Greater Bombay court in PMLA had the assets, and those assets have been restored. Of course, under the PMLA Act, the banks have to give a bond saying that if the assets get attached by the PMLA court and it becomes the property of the central government, the banks will return the property to them or return the monies to them, as the case may be, my lords. My lords, please come to, my lords, page number 251.
Yes.
My lords, at the bottom quadrant of 251 is, my lords, orders of the court. With my lord's leave, I read. The application so and so is hereby allowed. The properties described in Schedule A, B, and C of the application Annexure 5, Exhibit 5, are hereby restored to the appellant banks through the recovery officer. Kindly note that means. Holding certificate of recovery dated 14/10/4/2007, issued by the DRT Bangalore by the decree passed in so and so, so and so. Para 3, the recovery officer and the appellant's bank are directed to submit bond or undertaking so and so, so and so. My lord, and all other proceedings of restoration, similar orders. So if the restoration is through the recovery officer, attributable to the recovery certificate of 2017, which recovery certificate, my lords, is 6,000 crores plus interest, then every penny that they receive, my lords, must be attributed to my recovery certificate. It is in that light, my lords. I pray that this honorable court, I am not, my lords, I must be candid, my lords. I can't, as an officer of court, stand up and ask clemency in this matter, saying there are multiple proceedings on Vijay Mallya, my lords, they will go on. But there are no proceedings on United Breweries Holdings Limited, my lords, which is 10.1. The erstwhile director has filed the petition. There is neither a PMLA proceedings on UBHL, because UBHL was not the conspirator on it. UBHL was a guarantor to a loan. If, my lords, the recovery officer, my lords, unfortunately files no affidavit before this. He is a party, my lords, respondent number 1. I seek no reliefs against him, but he does not swear on affidavit on what, according to him, is the recovery. My lords, in the absence of that, my prayer is, my lords, that the banks must come clean on releasing a statement of accounts, my lords, and that's all I can seek in this writ petition. If it accrues to my favor, I will then go and knock on the doors, of course, of this honorable court, but on the company side, to at least revive the company. That's my prayer, my lords. And I'm very grateful, my lords, for that.
Yes. For the respondents.
Or the banks, my lords.
I appear for the official liquidator, my lords.
1 minute.
Was before the learned advocate for the OL submits, my lords, now who I assume represents UBHL and not the petitioners. Can I just make a few submissions, my lords, as I was submitting on the last date regarding maintainability.
And State Bank of India.
Yes, and the consortium. There are about 12, I think 11 or 12 banks, my lords. Respondent number 2 to 12.
Yes.
It's a consortium led by the State Bank of India. No, it's a couple of submissions.
Other respondents.
My lords, I represent respondent number 13, the official
So you're
liquidator.
representing from 1 to 12.
2 to 12. One is the recovery officer.
Oh, yes.
Just one housekeeping submission, my lords. Respondent.
Where is the OL party?
My lords, OL is a party only in 10.1 because 10.1 is by the erstwhile director of UBHL, my lords. UBHL's records, my lords, it's not because UBHL, my lords, apart to the recovery officer, it is the OL who should keep records because it's in liquidation. And he's on affidavit before your lordship that there is more than what is due to the banks that has been recovered. Therefore, he has been made.
Yes.
Can just submit, I'll address even the merits of the case, but before that, I just respectfully submit make two submissions, my lords, regarding the maintainability of this writ petition itself. If my lords were to see the prayers, I'll just take my lords through the prayers again, page number 62. I won't read them out. All of them, my lords, are seeking a writ of mandamus.
Yes.
One is to, all of them are to the banks, in fact. First one is to provide a statement of account. And in fact, that is caveated by taking into account the interest accrued periodically. That is the prayer number 1. That is prayer A, sorry. Prayer B, Roman 1 says, statement of accounts realized in their favor and details of the original owners of the assets utilized for realizing the amounts. Then the second part is not yet realized. I won't trouble my lords reading the entire thing. Then prayer C, my lords, I'll read the entire thing in entirety for lordship's permits. That's an interesting prayer. What they ask for, my lords, is a writ of mandamus to apply the recoveries made by the sale of all assets restored to respondent 2 to 12 under the order dated 24/5/21 by the special judge for CBI for Greater Bombay in PMLA case number so and so, passed by the special judge in PMLA case without treating them as conditional recoveries. So therefore, all of these prayers are specific prayers for a writ of mandamus, directing the banks to do something. Now, the first question I ask myself is, can a writ of mandamus even be sought unless they first show that there was a duty, a public duty that was cast upon me to do A, B, C, D? 2, I have failed to do it, or I was statutorily mandated to do it, or by contract, or by any other means, and I have failed to do it, which is why they approached your lordships under 226, mandating me to perform my public duty. Well, from what I heard, the learned senior counsel of the petition was, there was a detailed narration of the facts, but my lords, where is the public duty by which they can enforce, or rather request your lordships to force me to perform all of these duties? That was not submitted. Point number 1. That applies for 10.1 and 10. Now, my lords, as far as 10 is concerned, there is another submission. Now, my lords, your lordships is well aware, writ jurisdiction is an extraordinary jurisdiction. It is, more importantly, a discretionary jurisdiction. Enough number of cases, I'll just submit one judgment to that effect, which goes to the effect of stating that anyone with unclean hands, anyone with who is not forthright before the court, they are not entitled to any discretionary exercise of jurisdiction under Article 226. Now, let's kindly see the conduct of the petitioner in serial number 10. If my lords were to take the objections filed by the banks first, and I'll summarize what I would intend to submit, my lords. This petitioner, my lords, is declared as a fugitive offender under the Fugitive Offenders Act. There are not one but numerous proceedings requiring him to appear before the various authorities, including judicial fora and courts, including as high as the Honorable Supreme Court. He wishes not to participate in any of those proceedings. And it's brazen. It's well known, my lord. It's a brazen violation of all these court orders. Now, my lord, somebody like that, is he entitled to knock the doors, choose when to approach the courts of this country, and then request your lordships to exercise 226 jurisdiction and force and direct the respondents to do A, B, or C, D? It simply is not possible, my lords, which is why it is hit straight away, my lords, by the doctrine of of unclean hands. He has come to this court picking and choosing when to come to this honorable court. Just one judgment I'd like to place on record, my lord. This is a judgment in not Bharat Force, the other one. KD Sharma, my lord. I'll just read the relevant paragraphs. Kindly come to paragraph 34 directly. The 2008 judgment, paragraph 34, which is at SCC page 492.
Yes.
I'll just read, my lord. The jurisdiction of the Supreme Court under Article, your lordship has it? The jurisdiction of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merits of the claim. I'll just pause here for a moment. I'm not submitting for a moment that in this petition, he may have misled the court or made any I'm not alleging that. But my lords, the doctrine would equally apply to a person who chooses not to appear before, as I was submitting, not just one forum, several fora, including the Honorable Supreme Court. And I'll point out where he is completely brazenly not submitted himself to the jurisdiction of the courts. My lords, whether he is entitled for a discretionary jurisdiction is what I would like to submit. Kindly come then, my lords, to paragraph 36. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material fact or attempts to mislead the court may dismiss the action on that ground alone and may refuse to enter into the merits of the case by stating, we will not listen to your application because of what you have done. The rule has been evolved in the larger public interest to deter unscrupulous litigants from abusing the process of the court by deceiving it. I'll just read one last para 38 minutes. The above principles have been accepted in our legal system also. They've cited a British judgment. As per settled law, the party who invokes the extraordinary jurisdiction of this court under Article 32 or of a High Court under Article 226 is supposed to be truthful, frank, and open. He must disclose all material facts and without any reservation if they are against him. He cannot be allowed to play hide and seek or to pick and choose. This squarely applies. In fact, hide and seek squarely applies. Although it was not in the facts of this case, when in today's case, this is a classic case of hide and seek, and I'll demonstrate that. If my lords were to kindly come back to my objections. This is only illustrative, my lords. There are several fora where he has refused to submit himself to the jurisdiction. Volume.
Yes.
My lords, may kindly turn to page 97 of the objections.
Yes.
This is the special court, my lords. I won't trouble my lords reading the entire. Kindly come, sorry, page 96,
Yes.
paragraph 75. The material produced by the Enforcement Directorate and countered by so-and-so has to be tested on preponderance of probability. The court has to strike a balance from the material to ascertain for finding out which way the truth lies rather than to play a minor contradiction between this.
Paragraph number 75.
75, I'm sorry. The last sentence was on testing the material on the principle of preponderance of probability. The fact which emerges that the NA number 1, that's the petitioner, had left India to evade prosecution and he is staying out of India to avoid criminal prosecution. There are as many as 3 warrants of arrest in schedule offense. The requirement of section 21F are fulfilled and therefore the ED has made out a case for declaring NA number 1 as a fugitive economic offender. Hence, I answered the point number 1 in the affirmative. NA number 1, Dr. Vijay Vittal Mallya, is declared fugitive economic offender under section 212(1) of the Fugitive Economic Offenders Act. So this is just to show, Malas, he has not submitted himself to the authorities under the Enforcement Directorate. Pardon me, Malas, I'll just deviate for a moment. In fact, Malas, my learned friend read out a part of our objections. One last paragraph, we also clarify that if he even today why all of this is being held up as a temporary recovery? Why is the necessity for giving a bond undertaking? The answer is very simple, Manas. He is not submitting himself to the jurisdiction. If he is innocent, if he is sure of proving his innocence, come back to India, prove your innocence. After that, Malas, if he proves his innocence, all the properties have to be restored. But right now, Malas, he chooses to stay outside India. And then Malod says, please give me all this information. And Malod, I'll take Malod through the provisions of the PMLA as well as the rules, which mandate me to make it to show it as a temporary. I have to give a bond undertaking. I can't show it as a permanent recovery. I'll come to that later. But I only wanted to point out, Malod, at this stage, he stays away, Malod, and then he says, which is why I'm saying the banks are open. If he comes back, Malod, I'm sure the ED. In fact, ED is not even a party. ED may have been a necessary party to clarify whether I can. I needed to give a bond undertaking or not. But anyway, I'll come to that. Then, my lords, may kindly come to page 200 of the objections. This is a contempt proceeding, my lord. Again, I won't trouble my lords regarding the merits of the contempt. The order starts, or order the Honorable Supreme Court starts at page 200. Kindly come to, my lords, page 215. Paragraph 14, Malas, I'll read. In its judgment and order dated so and so, this court had found that the action on part of the contemner in disbursing the amount of $40 million was against the text and tenor of the orders passed by the High Court of Karnataka, and that the contemner was guilty of contempt. In the circumstances, in order to maintain the majesty of law, we must impose adequate punishment upon the contemner and must also pass necessary directions whether the advantages secured by the contemner or anyone claiming under him are set at naught, and the amounts in question are available in execution of the decrees passed in the concerned recovery proceedings. Considering the so-and-so, then I'll skip paragraph 16, except, my lords, the sub-para, just about 5 lines below the bottom of the page. We direct the Ministry of Home Affairs, Government of India, New Delhi, to secure the presence of the contemner, to undergo imprisonment imposed upon him. Needless to say, Government of India, including the Minister of External Affairs and all other agencies and instrumentality, shall carry out the directions issued by this court with due diligence and utmost expedience. Once again, only to demonstrate, even the Honorable Supreme Court is not able to secure his presence. But he has the time to knock on the doors of this Honorable Court asking for all these relief. Therefore, my submission in a nutshell is this. Insofar as the petitioner in serial number 10 is concerned, he is simply not entitled to any discretionary relief at the hands of your lordships in view of his conduct. Otherwise, my lords, it will be a classic case of him picking and choosing when to submit himself to the jurisdiction of this Honorable Court. Therefore, 10 may be, serial number 10, my lords, I would request be rejected at the threshold on these grounds itself. Now, coming to the merits, my lords, as far as the merits are concerned, of course, my learned friend already took your lordship, so I won't repeat what he said. There are various PMLA proceedings. There are orders of attachment as early as 2016 and June 2016 and September 2016. Then, Malas, may kindly take the PMLA. I'll just point out one provision, Malas, the Prevention of Money Laundering Act.
Yes.
Kindly see section 8, subsection 8, Malas. The procedure, Malas, is that there will be a provisional attachment. The provisional attachment has to be sent for confirmation under section 8. And then, my lords, section 5, subsection 5, then subsection 8. Yes. Subsection 8, I'll read, my lords. Where a property stands confiscated with the central government under subsection 5, then the property...
I would request my friend to read 5.
Of course, I'll read 5. So, where on conclusion of a trial, that in fact helps me, my lords. If he stands for trial, we can conclude the trial, not we, the ED can conclude the trial. Where on conclusion of a trial of an offense.
On a lighter note, my friend should realize that he's the bank. If the bank becomes the ED, we know what the ED is doing in the country. If the bank becomes the ED,
maybe that's why on a lighter note,
I correct myself.
Benjamin Cardoso's inarticulate major premise. You think you are the ED, you behave like the ED, but then correct yourself.
Maybe that's why we know why he didn't make the ED a party. Maybe he thought I'll speak.
I have nothing against the ED.
Yes.
So, subsection 5, I'll read, where on conclusion of a trial of an offense under this act, the special court finds that the offense of money laundering has been committed. It shall order that such property involved in the money laundering or which has been used for commission of the offense of money laundering shall stand confiscated to the central government. That's subsection 5. Subsection 8, where a property stands confiscated to the central government under subsection 5, The special court in such manner as may be prescribed may also direct the central government to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offense of money laundering, provided that the special court shall not consider such claim unless it is satisfied that the claimant has acted in good faith and has suffered the loss despite having taken all reasonable precautions and is not involved in the offense of money laundering. Kindly see the second proviso, provided further that the special court may, if it thinks fit, consider the claim of the claimant for the purposes of restoration of such properties during the trial of the case in such manner as may be prescribed. Now, my lord, that second proviso was inserted in 2018. So therefore, my lord, even while the proceedings are pending, it can be temporarily restored. Now, pursuant to this, my lord, in 2019, the rules, that is the prevention of money laundering, restoration of confiscated property rules were amended.
Yes.
Do we have those rules? I'm sorry, I assume the court may have a copy. I apologize. Can I just, I'll read it out slowly so that your lordships.
Yes.
Now, my lords, rule 3A.
We may have copies, but that's 1 minute, please. I'm assuming you'll read 3A. 3A is on the second page, madam.
Yes.
Kindly see 3A sub-rule 1, my lord, and then I'll read it, sub-rule 2 also. The special court, after framing of the charge, my lords, has it? Under section 4 of the Act, on the basis of an application moved for restoration of a property attached under subsection 1 of section 5, or seized or frozen under section 17 or section 18 of the Act prior to confiscation, if it thinks fit, may for the purpose of the second proviso to subsection 8 of section 8 of the Act, cause to be published a notice in 2 daily newspapers, one in English language and one in vernacular language, having sufficient circulation in the locality where such property is situated, calling upon the claimants who claim to have a legitimate interest in such property or part thereof to submit and establish their claims, if any, for obtaining restoration of such property or part thereof. Sub-rule 2, when the property referred to in sub-rule 1 is insufficient to meet the loss suffered by the claimant as a result of the offense of money laundering, the special court, as it thinks fit, may pass an order of restoration of property, directing the central government, if necessary, to auction such property and disperse on a pro rata basis in accordance with the share of loss suffered by each claimant, and may give custody thereof to such claimant on his, kindly mark this, on his executing a bond undertaking to produce such restored property before the special court as and when required for the purposes of subsection 5 or subsection 6 or subsection 7 of section 8 of the Act. Then sub-rule 3, no claimant shall be entitled to claim restoration of the property in sub-rule 1 before the special court, so on. So then there's the time limits. So therefore, the requirement for me to give a bond undertaking is ingrained in the statute itself. A statute read with the rule. The statute was amended in 2018. The rule was amended in 2019. I am statutorily required, mandated to give such a bond undertaking to restore the properties as and when the ED may require me to do so. So therefore, I was asked, in such circumstances, even though the words used by all those authorities are restoration, restoration, even here the word is restoration, but subject to the bond undertaking that I shall restore it as and when. And when then the question of restoration, when will it come, my lords? As and when the trial concludes. Now, my lords, if the petitioner in serial number 10 refuses to subject himself to the jurisdiction of Indian courts, now, my lords, he can't direct me to treat it as a permanent recovery, but not stand for trial over here. Once again, this pick and choose doctrine will apply. He can't say treat it as a permanent recovery, but I will not subject myself to the trial. Whereas the ED, the special court, in their wisdom, have directed the central government to restore it in my favor, subject to a bond undertaking. I have given the bond undertaking. Bond undertaking is with the central government. Therefore, Manoj, I have no option but to treat it as a temporary recovery. It's not a permanent recovery. So therefore, Manoj, and again, I come back to the threshold submission itself. All of this, Manoj, is subject matter of, in fact, that order restoring is under challenge, not by him, but by some other people. Now, Manoj, any orders passed here will have a ripple effect or a cascading effect in other matters. Now, therefore, Manoj, to seek such a wide prayer in the light of all of what has happened in the last 10-15 years, Manoj, would simply be It's more, I would say, Manoj, with great respect, it's probably more like a fishing inquiry where your lordships may direct me to do something. The banks will give some information. That information will be used somewhere else. Some information will be given there. That will be used here. Clearly, Manoj, it's not as simple as my learned friend made it out to be. Of course, he simplified it in his usual lucid language, but I don't think it's as simple as that, Manoj. There is a statutory scheme which I am bound to follow. I can't give a complete go by.
Poetry, my lords, I'm reminded. Lack of simplicity is the fear of the unknown. They don't know which proceedings I will use.
So therefore, my lords, as far as even the merits are concerned, well, these prayers are simply not maintainable, I would respect to submit. And insofar, I think the petitioner, the second petition is concerned, Malas, I heard repeatedly that they are representing the company or an erstwhile director. Malas, I think the OL would be in a better position to speak for the company because he's in the shoes of the company right now. So therefore, Malas, I would respectfully submit that both the petitions may be rejected simply on the ground of maintainability, on the grounds I submit.
Well, I'm appearing for respondent number 13 and serial number 10.
Next petition.
10.1.
10. 10.1 is Malya in the cause.
Then I'm sorry, Malas. I have to inverse everything else. I think 10.1 is Dr. Malya's.
No, 10 is
that's not correct. 10 is Malya. My friend is a little confused.
10 is.
My friend Vikram was right. 10 is Malya. 10.1 is Daljit Mahal.
Writ petition number 3356.
Yes.
The petitioner is Miss Daljit Mahal.
10.1.
On the list it's still.
3356 is 10.1.
Please, my lords, in any event, I'm appearing for the official liquidator in 3356. I also have an objection on maintainability, but that is in terms of section 446 of the Companies Act 1956. May I just read it out to your lordships?
No, what do you say about 10.1? You don't appear in 10.1.
No, I do, Manoj. I have.
You
In fact,
argue 10.1.
I can argue 10.1 right away before
you
my
can-
friend responds.
Please, my lords. May I just read, my lords? 446.
Let him argue.
Very good.
Finish 10.
Yes,
Manoj, please see 10.1
yes.
in terms of maintainability of 10.1. Fortunately, banks are not raising that objection. The OL is.
I think he wants to rejoin to my submission. Let us finish.
No, I finish both. Then I can rejoin in common.
But I haven't made my submissions on the maintainability.
No, I have plead my case in 10.1.
Because
My
this
friend
is
should
this
rest
is
and let me.
To the company in liquidation, that's
Very
before
well.
the court. So how this writ is maintainable?
Very well.
Maintainable, I should make a case, Manoj.
Yes.
Well, let's please come to 10.1.
Let's look at the prayer for in this.
Yes, please, my lords. The prayers, my lords, are broadly identical. We have asked for, my lords, statements of accounts demonstrating, my lords, as to what is the recovery that is made. Would your lordship straight away, my lords, indicate?
In this writ petition, who is the writ petitioner?
Yes, my lords. I'll for a minute before your
Daljit
lordship
Mahal.
looks at. Daljit Mahal, my lords, was a director on the board of United Breweries Holdings Limited. Continued to officiate as a director, and thereafter, my lords, the company went into liquidation on the passing of an order by this honorable court, and the High Court operating as the company court. The company, my lords, moves into the hands of the liquidator. The only objection that can be raised is to say, how is Daljit Mahal, my lords, initiating this writ petition? First submission, this entirety of indicating that there is a pick and choose, I have a fugitive economic offender, etc., may or may not bite to Malya, my lords. I will reserve my rejoinder arguments, but none of that, my lords, relates to Daljit Mahal. There is not a single proceedings against Daljit Mahal. There is no order by court, nor, my lords, is Daljit Mahal an accused in any of the matter. When a company moves into liquidation, why? Because it has been unable to pay its debts. And why is it unable to pay its debts? Because this company stood as a guarantor to its subsidiary, which is Kingfisher Airlines, which borrowed initially 800 crores. A stitch in time saves 9. 800 crores has become 17,000 crores today. But good or bad, this company stood as a guarantor, and therefore the company is in liquidation. Your lordships have repeatedly considered the fact that when a company goes into liquidation and the company believes that certain monies have been recovered, at least to the extent of company's liability in the debt, then an application, my lords, can be filed under the old act, which is section 466, which is the new section 289. In fact, 289 accrues to my favor even more than 466, my lords, in 289 for revival of the company. For me to file an application under section 289 of the Companies Act 2013 to say, irrespective of, you may hang Malya, but please revive the company, I need to have, my lords, a prima facie demonstration to say the company has discharged its liability. Whosoever other liabilities apart, please revive my company. That certainly, my lords, I should go before the company court. I can't come. Not that I cannot come, my lords. But this is public law remedy. We are one of the most robust public remedies, my lords, in the world. I can still come in a writ petition. Your lordships may choose not to exercise jurisdiction on the basis that you have an alternate remedy. Please go there. That's a different matter. But yes, I could go before the company court. I come here because, my lords, that repeated letters to the banks, etc., which I have put in the writ petition, I'll not trouble your lordships, I elicits no information on how much money is recovered in terms of liability. Now, if the liability is, my lords, 12,000 crores and 13,000 crores even is temporarily recovered, the company, my lords, may be discharged at least to say, please revive the company, continue to attach whatever assets, but let the company go on and do its business. Now, to do that, who should file the application? The official liquidator is not going to file that application because the official liquidator's job is to liquidate the company. I can file the application, although I'm an erstwhile director, because the Honorable Supreme Court, my lords, when confronted with this question, specifically holds that a director of a company which has been ordered into liquidation continues to have certain responsibilities and rights. One of the rights is that director can ask for revival of the company. Please permit me to place, my lords, in Rishabh Agro. I will, my lords, trouble your lordships with just one paragraph.
Yes.
My lords, in Rishabh Agro, please come to my lords, paragraph 10. My lords, Rishabh Agro is, my lords, 2000 Supreme Court.
Yes.
It's 2005 SEC 515. I'm straight away, my lords, coming on to paragraph number 10. If your lordship permits me, my lords, I will read just that paragraph.
Yes. Yes.
It has been further suggested on behalf of the respondent bank that the action of the appellant is mala fide in as much as it has sought time from the court to make payment of the amount due, and after seeking the indulgence mala fidely made reference to BIFR and so and so, the old BIFR, my lord, now IBC. It is contended that after the order of winding up and appointment of liquidator, the board of directors has no jurisdiction to move BIFR by passing a resolution. In this case, I'm not before BIFR, I'm before a writ court. Such a submission cannot be accepted. In a winding up petition, the liquidator is appointed to protect the assets of a company for the benefit of its creditor, secured and unsecured and others. It is not the function of the official liquidator to start the process of rehabilitation of the company as is aimed under the Act. Despite the appointment of an official liquidator, the board of directors continue to hold all residuary powers for the benefit of the company, which includes the power to take steps for its rehabilitation. Let's I stop here. I go forward. The board of directors in the instant case were not in any way, in any judicial order, debarred from taking recourse of the provisions of the Act. Please ignore that. Well, it's the power which includes the power to take steps for rehabilitation. Rehabilitation is only made, my lords, under the Companies Act by virtue, my lords, of the old Act 466, the new Act 289. So my first step towards rehabilitation is, my lords, the banks indicating as to what is the liability of UBHL, and to the extent if the principal liability, my lords, I'll of course tangentially touch upon my esteemed friend's argument. Nobody, my lords, is seeking, as I said, I'm not seeking clemency. If there is a conviction in, my lords, the PMLA proceedings ultimately, and these properties are to be restored, my lords, to the, by escheat, my lords, to the union government, because they become the property of government, then the banks may have to reverse account. But it is at that point of time that the liability completely comes back to be cast on, my lords, Malya or whoever it is. The only case that the company can make today is, if you have recovered certain monies, 5,000 crores is principal, you have recovered certain monies till now. How is that you are accruing the interest on that 5,000 crores to continue to apply in the interregnum until you restore? Well, until it is restored, the asset is not in a vacuum, it is with the bank. The bank uses the word temporary to mean it is transient, my lords. There are two different things. This is not a transient movement to the bank. The bank today has, my lords, in situs and control of the property. The property is today the property with the bank. That's monies. If a reversal occurs in a future date, from that date of reversal, interest could continue. There is no problem. But the principal and interest can't continue in the interregnum until trial happens, because one man attends or another man does not attend trial. And in the process, my lord, the company can't revive. Lord, there are two things, and I'll, my lords, in all candor place this. Whether I'm entitled to relief at my lord's hands is a different matter altogether. It's on merits. But whether I'm entitled to maintain this writ petition, invoke my lord's jurisdiction, I am. I am an erstwhile director. Supreme Court says the power to revive the company is only mine and not of the liquidator. And therefore, I'm surprised that the liquidator says I can't file a writ petition. My lords. Banks rightly say, don't say that I cannot. And therefore, my lords, that's my on maintainability, my lords. The rest of it, my lords, on the arguments, my lords, I adopt the first argument. But please see, my lords, one statement of the official liquidator. The official liquidator who stands before your lordships today. Please see the submission made by the official liquidator in my lords page number. I read it in the previous case. Please see my lords page number 1171 annexure S, my lords, in this writ petition. Annexure S, my lords, would be in volume number 3.
Volume number 3, what is the page?
My lords, volume number 3, please, my lords, 1171. My lords. My lords, by the time the courtmaster places the paper before your lordships, the same official liquidator, my lords, who today contests my right to come in.
Yes, yes, you have read already this.
Yes, my lords, just one line. Would your lordships please permit me? I'm glad, my lords, your lordships immediately noticed that. Please permit me, my lords, to come to page number 1172.
Yes.
During the course of the submission, senior counsel so-and-so submits that the consortium of banks has already recovered the amount due in excess of what is adjudicated. My lords, that apart, the same official liquidator issues notices to me as the erstwhile director of this company to hand over the books, etc., my lords, and I put it in my list of dates. Please see that list of dates which I gave, my lords, as a compilation. Please see, my lords, in that item number 14.
List of dates are there.
My lords, sorry, your lordship, no, that's in Malya, my lords.
Yes, sir, it is.
No, I'll trouble you.
No,
lords.
the other one.
My lords, no, that may be in Malya, my lords.
Yes.
I have the list, my lords. In
Take that.
Some of it are common, my lords, but these are because I'm a director, my lords.
Yes.
My lords, please see, this is in Daljit Mahal that I filed. Please straight away come to entry number 14, my lords.
Yes.
My lords, DRT passes an order, etc., etc. That is the DRT order for 6203. Please see 15. And kindly see the time. In January, DRT says recover 6,000 crores. In February, my lords, item number 15, this honorable court says in February 17 that so-and-so, the company, my lords, is wound up. That is, honorable court in a common order and company petition so-and-so and connected matters directed the winding up of UBHL, which is United Breweries Holdings Limited, of whom I am a director. Now, please see 16, my lords. The liquidator issues notices under 456 and 468 of the Companies Act to me, I'm the petitioner, Daljit Mahal, and other directors of UBHL seeking to hand over the property, effects, books, etc. If I don't comply, my lords, there is prosecution and penalty, my lords, under 338. Therefore, they recognize the fact that I'm a director, I'm in charge of the company. They ask me to hand over the books to them, which I do. They take charge of the company. Today, my lords, after 8 years, I come back to court saying there is substantial recovery. I need to have the opportunity to revive the company under 466. And therefore, for that revival, I need a statement of accounts. And they say, no, this writ is not maintained.
Why can't you seek the same relief by filing an application before the company court?
Well, I can file an application before the company court.
And because it is companies under liquidation and it is now in view of the bar under the Companies Act, why should anything pertaining to that company, why should this court seek any information from them about?
I understand.
You can as well go before that application.
I understand.
By filing an application.
I completely bow down, my lords. Please sit down. If, my lords, this was a simpliciter case of a debt being due, and my lords, and the official liquidator.
Banks were also before the court.
No, my lord, not all these banks in this form as a consortium before court. Some banks are creditors, some are not, etc. But I'll take it, my lord, that the banks will be there. I'll take it.
Please, my lords. In fact, on the last occasion, I submitted that I filed company application number 162 of 2021, where I have sought for identical reliefs. I am not reneging from my stand. I have sought a disclosure from the banks. All I'm saying is, if you want a similar disclosure, come to the company court. This is a question on priorities. Company court has adequate powers. They look into the matter. How would this be a writ remedy, my lords? And what I'll of course let the learned senior counsel finish.
My lords, I'll just answer that straight away. If this was a simpliciter scenario where a company has not been able to pay certain debts and therefore is winding up, and therefore I need to go before the liquidator, I could well make an application before the company court. But for an application to be made under the erstwhile 466 or the present 289, I have to prima facie demonstrate that the liabilities of the company have been discharged and there are assets in excess of the liabilities that are available for a revival. Only upon that threshold being met, my lords, a 289 application or the 466 application erstwhile will be considered by the company court. The company court has, my lords, powers only under the Companies Act and not overarching power as a writ court. The problem for me, my lords, is one step prior to it. There are two authorities, actually three authorities. The PMLA, at least here I am not claiming any rights
PMLA
against
is
them.
not a
I am
party
not
to-
claiming
yes.
them because their orders are there. I have appealed those orders. The fact is, my lords, there are directions.
So consortium of banks or the.
Consortium of banks, the recovery officer in the DRT and the liquidator. Therefore, my lords, the recovery officer of the DRT, my lords, he is not session to the company court, my lords, as a liquidator appointed by the company court. It is the liquidator who reports to the company court, whereas the recovery officer reports, my lords, to the DRT. And therefore, the only way I can do, my lords, is to come and of course, the DRT is an authority subordinate and within the jurisdiction of this honorable court. The only way I can do is either come under 227 for, my lords, a certiorierized mandamus to the recovery officer saying do something. I have no grievance against him, therefore I don't come under 227. I file a 226, right? Writ saying there are two separate authorities, one within the jurisdiction of the company court, one not within the jurisdiction of the company court. They speak different languages because the recovery officer certificate demonstrates something else. Whereas the official liquidator on affidavit says banks have recovered more than due. Therefore, I say, please give me the account so that if the accounts support me, I will move up 289 application. If the accounts don't support me, I will not move up 289 application. Therefore, my lords, the penultimate step would be only to come in a writ. Different matter that if the official liquidator were to contest it on merits, but to say I can't file a writ, takes away the whole scenario saying I have run the best company in this country at some point in time. UBHL was touted to be the best in the company. It was the market leader, my lords, on spirits worldwide. Now I am a director of that. My capacity as a director is not questioned. My status as a director is accepted by the OL. And today OL says, no, I want to file. Of course they can file. I'll support that application when they file. But
They have already filed.
I do not have notice to that, my lords. Unfortunately, that's what happens.
Which is why I'm giving the company application number. If the petitioner would like to participate in those proceedings, there's nothing that's stopping her from coming.
But that does not take my writ away. Your lordships may not or may give me relief is a different matter. But me participating in those proceedings where the official liquidator says money is recovered does not take away. Not filing a 226 writ is as much a fundamental right that I have, my lords, and Daljit Mahal as being a director in this company and not being session to any of the proceedings that my friend ever to. That right is there.
What is your response to the senior counsel's argument that in a pick and choose manner, the petitioner how is approaching the courts and why should the court entertain such a petition?
My lords, I will of course, my lords. In this court, my lords, this is my first appearance before your lordships, my lords, although in Telangana I had the opportunity. Lords, I am not for one as a counsel to turn up and sugarcoat anyone. On the count, therefore, my lord, there are two petitions before your lordships. One is by the company, one is by Vijay Mallya. I am not for one indicating, my lords, that anybody for that matter, my lords, whether I stand for that petitioner or not, can pick and choose judicial proceedings in this country and not comply with something and seek, my lords, an extraordinary remedy in a writ. The reason why he has filed a writ, my lords, quite apart to 10.1, and even, my lords, arguendo if 10 were to fail, 10.1 stands. But why is 10 filed? Under the Fugitive Economic Offenders Act, which is a special legislation brought, my lords, for only people who are now out of the country. The consequences of that act is that if you are declared a fugitive economic offender, then you shall not participate or initiate or not file or receive the benefits of a civil proceedings. That is, my lords, that I can't file a suit for recovery of monies, keep it in my pocket, etc., or defend, my lords, a claim against me. The Fugitive Economic Offenders Act, Section 14, my lords, cannot and does not, my lords, certainly does not, cannot take away writ remedies that are available, my lords, for a person, because, my lords, writ remedies are constitutional and public law remedies.
We are not on that point. Supreme Court has passed an order. You have placed a contempt. And you are not appearing, you are not in India, you are not appearing before any of the courts where you are required to be. True. But still, you want a remedy from a court.
Correct, my lords. May I make this submission on that, my lords? One, my not appearance, my lords, of course, banks find it very, very handy, my lords, to throw that stone at me in every proceedings that are going on. My not appearing before the Indian courts is because I am, my lords, today subject to an order of committee courts in the UK, of an UK court, to say that I will not leave England, not even, my lords, England and Wales, not even the UK. I cannot leave England and Wales until my proceedings before that court are going on. The same banks have gone, my lords, to the London courts and received, my lords, an attachment in a bankruptcy proceedings and got me declared as an adjunct bankrupt and attached, my lords, worldwide assets, etc. So in that proceedings, separately, my lords, in terms of my right to reside in that country, I've initiated proceedings, my lords, statutorily, which is now pending, my lords. It has landed up, my lords, in the Supreme Court because the Court of Appeal, my lords, rejected it. The condition of me being in that country is by a judicial order that I will not leave that country. That factum was brought to the notice of the Supreme Court. Rightly, the Supreme Court said, I'm not bothered about it. There is contempt, you come and face contempt. Have I faced contempt? I have faced those penalties. I have not. Therefore, my lords, it is not a threshold of maintainability. Do I deserve relief at my lord's hands? Your lordships will consider that. But my lords,
unless and until you face the trial, all these proceedings, as the provision that is, reading,
yes,
it can't attain finality.
It
and
will
what is
not.
the purpose of you seeking all these reliefs?
Two things.
All this information.
Yes, ma'am. Two submissions, ma'am. So at least in 10.1 for the company, and I'll come to Malya as well. No doubt, my lords, that until the trial in the PMLA proceedings ultimately land up either in an acquittal or a conviction. If it is an acquittal, I go home dry. I am not, my lords, troubled by the weather, and therefore these assets must come back to me. Corollary, if there is a conviction, these assets, my lords, will then vest with the central government, and therefore the banks, because of their bond undertaking, must restore the assets to the bank. But for there is collection, banks admit. There is a recovery certificate and interest accruing on it, banks admit. But from the time of that collection of money, which the money now is appropriated onto the accounts of the bank, they are not kept in a trust account outside. It has gone into the bank's coffers. Bank uses the money thereafter to lend, etc. Then, my lords, in the interregnum, from the time they have received the money till the time when the trial may go in my favor or in favor of the prosecutor, interest cannot continue to accrue, my lords. If the interest continues to accrue, the recovery certificate will never get discharged. How will I discharge a recovery certificate now as a company? I'll come to 10.1. How does the company as a guarantor ever discharge this recovery certificate? Because the assets of the company have been taken. The assets of the primary debtor have been taken. That has been appropriated by the banks. But the banks say, no, I will continue to accrue interest on 6,000 crores. Interest of 12,000 crores I will accrue and make it 17,000 crores. Why? Because asset has come to me, but the trial is not over. That interregnum window, I am entitled to the benefit of not being burdened with interest. The least I can do is, after I get this account, to see how the accounts have been tabulated in terms of interest, to at least make that claim. Even to make that claim back, my lords, before the recovery officer saying that you please issue a discharge certificate, I cannot make it without the account. Therefore, my lords, I have approached this honorable court. I'm grateful.
Yes.
If my lords would just have section 446.
Yes. Yes.
May I please read, my lords? When a winding up order has been made or the official liquidator has been appointed as provisional liquidator, no suit or other legal proceedings shall be commenced, or if pending at the date of the winding up, shall be proceeded with against the company, except by leave of the tribunal, and subject to such terms as the tribunal may impose. The tribunal shall, notwithstanding anything contained in any other law for the time being in force, have jurisdiction to entertain or dispose of. My lords, may straight come to subclause D. Any question of priorities or any other question whatsoever, whether of law or fact, which may relate to or arise in course of winding up of the company. This information that's now being sought, my lords, is directly falling within the ambit of this particular provision. They are seeking a disclosure. Now, in page 20, para 10, they explain why they're seeking this disclosure. May I request your lordships to have page 20 of their petition?
Yes. Yes.
Would my lords have para 10? May I read? Although all directors of UVHL stood discharged as of the date of winding up under section 445(3) of the Companies Act 1956. As an erstwhile director of UBHL, the petitioner is under a continuing obligation to cooperate with the respondent number 13 in relation to winding up of UBHL. In addition, the petitioner is subject to certain rights and liabilities in relation to the winding up of UBHL, including but not limited to assisting with. They set out all the provisions of the Companies Act. Now, I've already initiated proceedings against them for non-filing of statement of affairs under 454. Non-furnishing of books and, please, my lords.
When was that?
Before the company court, my lords.
When was that? Which year?
I'll provide all the dates, my lords, the dates and the
Can you
case
show
numbers.
in your objections?
I've not yet filed objections, my lords, but I will furnish details of all these pending litigations where I have instituted in terms of the 1956 Act. I've sought for statement of affairs. I filed a misfeasance case against the ex-directors to the tune of nearly 17,000 crores. I filed a complaint under 468 for non-filing of books and records. Till date, not one of them have cooperated with me. Now, today, they're filing this writ petition under the guise of saying, I have a persisting obligation. I'm supposed to comply with all of these provisions, but none of them appear before the company court. Can this be a reason? And they say, okay, there's a possibility of reviving the company. Very well. Have you approached the official liquidator? Have you come to the company court? This company was wound up in 2017. This writ is filed now. Where have they demonstrated their bona fides to come before your lordships in a writ petition without availing the remedy under 446? No efforts have been made by them. And even in the writ petition, they do not state, so what is the legal right that is being affected here today? They only want a disclosure. How much has the bank recovered? Seek the same before the company court. I already have disclosed on the last occasion that in fact they're aware of it. The CA 340 of 2022, which the Learned Senior Counsel was referring to, in that we have made a categoric submission that I have also filed an application, CA 162 of 2021. I've sought for the same disclosures from the bank because I also want to know what inures to the benefit of all the creditors of the company for distribution. That's information sought by me. No attempt for revival, no communication to the official liquidator. Out of the blue, they filed this writ petition today, seeking a disclosure. And they have not mentioned why they've not availed the alternate remedy or why this is more efficacious than coming to the company court. And as I read out, my lords, any question of law priority, it would be completely incorrect to state that the recovery officer cannot be summoned there by the company court. That's incorrect. They can be. All they have to do is file an application and that application will be considered. Therefore, this writ is not maintainable.
Well, my friend could indicate, of course, when they file their objections or if they're filing a written submission, to give me a copy of it, because I'm not aware. As Daljit Mahal, I'm not aware because there's so many directors, whether proceedings are against me. Because if there are,
Please file your written documents.
because I must
Very
meet
well.
it.
And I will make a complete disclosure of all the pending proceedings before the company court against all the ex-directors.
Yes.
We'll file our brief written synopsis.
Yes. Unless if they file it, your lordships may then, I would only request that your lordships may not reserve it for others. If they file it, give me a day's time to meet it and then my
When
lords.
will you file?
My lords, I'll need a week's time.
So what we do is, we'll take up this matter on 11th of November. And in the meantime, you serve the copy on.
Very well.
11th is fine with you?
11th of November, madam. They want 1 week for, yes, please.
Before the
It will
date,
be on
please serve the
12th,
copy on the
my,
council.
subject to
No.
if it comes from Delhi, 12th.
No, no, my lords, I'll only, of course, I wanted to make that prayer. I'll request permission to do the matter online, my lords.
11th, there are some matters, so along.
No, but my lords had said only Monday and Tuesday they're taking it. Then it could be the, if 12th is, 11th is not convenient, it could be 17th, my lords, the week after.
I'm in your lordship, son. At my request, my lords, 11th, only 11th I have some difficulty.
And we'll have it 12th.
12th minutes.
Great.
Wednesday. I'm grateful.
Court has to remember what all the senior councils have submitted today to pass the order.
Well, that's that I am privy to. Your lordships have an elephant memory. I don't know whether your lordships will remember, my lords. We had in those courts, we had a matter of all those contempt against all the intermediaries, my lords, the Googles of the world.
And that order is really working.
Yes, my lords, it did. It cleansed the situation.
Yes.
I'm very grateful, my lords, for the patience.
This is matter on 12th. By 10th, the official liquidator should file the objections of the written arguments and in advance.
Written synopsis, my lords. Synopsis of written submissions.
Synopsis of the written submissions and shall serve it on the counsel for the petitioner as well as the counsel for the respondent.
Yes, grateful.
I'm very grateful.
Bye.
What opposite? Keep it in the file. Yes.
Till number 11. Maitri.
I appear for the petitioner.
Thanks,
My lords has heard this matter substantially, so I will not take up much time of my lords.
Yes, yes.
I only want to point.
Appearing
My
for
lords had-
respondent 4 in this matter, my lord.
Huh?
Appearing for respondent 4,
Yes,
my
yes.
lord. We are filing the objections as well, my lord.
Yes.
Lord, I'll just have a look at it. In any event, I'll make my submission. My lords would recall this matter in respect of the workman.
Solely, I wanted you to
Yes.
argue on the legal point.
Yes.
How it is maintainable.
Please.
The employee, can he stop this or interfere with the surfacer proceeding?
My lord, previously I also had pointed out to my lords the prayer that I have sought for. Because the prayer that I have sought for is not only in respect of the sale notice. My lords may just recall, one, I have challenged that sale notice. Apart from that, I have also sought for action to be taken by the fifth respondent, who is a deputy commissioner, to act to ensure the recovery of amounts that have been directed.
If that's the case.
Yes.
You can't club both the reliefs for the
Please.
reason where this code is not having the roster as far as that relief is concerned.
My lord, in both my reliefs.
That can't go together. Those,
May I
both the
submit?
reliefs can't
Yes.
go together. It has to be a separated petition.
My lord, my respectful submission would be that given that it arises out of the same set of facts, it arises out of the same cause. What has happened in this case? 2021, the company stops working. It does. It calls for a lockout.
Yes.
After that, no payments are made. PF contributions are not made. It is in those circumstances that I have sought for both of these prayers. On the last occasion, my lord had asked me what steps I have taken after the orders had been passed. I only want to produce that memo. I want to just take my lords to that memo to show the man. To show the various steps that have been taken in order to ensure the rights of the workers. Previously, I have already pointed out to an order that has been passed under the Payment of Wages Act for an amount for the period from March 2022 to November 2022, where an amount of rupees 77,81,000 has been ordered.
That is pending. The suit
Please.
that is pending between
Yes.
you and the management.
Please.
In that suit, when these proceedings are going ahead.
Please.
And the property is put to auction, whatever is the excess amount, in that you can file an application, you make the bank or you make, already they're a party and IEA restraining them from giving that amounts or from, a direction to them, to attach that whatever amounts that are given back to the employee. That's a relief. Now what happens is, because of this writ petition, now because of the interim order, the entire auction proceedings are stayed. It is not good for the workman.
My lord, on the last occasion also I had submitted. While my prayer is to seek for a stay while I have challenged that sale notice, ultimately what would accrue to the benefit of the workman is if the amounts that are payable to them would be recovered and paid to them. Ultimately, my lord, that's the submission I had made even previously. While I have sought for a challenge and I had also submitted, I don't stand on the same footing as other creditors. The workman cannot be placed on the same footing as other creditors. Ultimately, my lord, I have orders in my favor which say that there are certain amounts that are payable to
Only
me.
for 89 lakhs or 88 lakhs?
Yes, please, my lord. That's the reason I also wanted to produce this memo.
Not lakhs, it's 1,000.
No, my lord, it's lakhs.
Lakhs.
The amount due is around 8 crores to the bank. The amount that has been adjudicated insofar as 8 months is concerned is 77,81,000. In respect of the other amounts, that is for the subsequent
Pending
periods, those are all pending. It's not to say that they are not pending. It's not that everything went back to hunky-dory after that. I have also produced this memo only to bring to the attention of my lords the various amounts that are due to me and the steps that have been, the various matters that are pending before the courts. My lords, I'll only request my lords to look at one document in this. I have produced, because my lords had asked me on the previous occasion what I have done to seek enforcement of that amount. I have approached the deputy commissioner. That's the another, I had already produced that in Annexure K. In my memo, the first document is the subsequent communication that I've again written to the deputy commissioner saying, please recover this amount that is due to me and ensure that that's done. Still no steps have been taken. My lords may just see insofar as the PF contributions are concerned. Page 13, if my lords could kindly see.
Page 13.
Please, of my memo.
Yes.
This is the communication issued by the Provident Fund organization to the management of the company in 2022. With reference to the subject cited, a complaint has been received for the employees. A unit of sewing stating that employer has deducted the PF contribution and not remitted contribution to their PF account from December 2020. They have debited my account, my contribution from my salary. They have not deposited it from 2020. Then if my lords could...
Apart from that, the penal proceedings will also follow for not...
It should, my lord. And my lords may just see the next page. On the next page at page 14, I won't trouble my lords with the entire notice. Further, it is also noticed that the establishment, Mr. Ganesh Spinners, has not paid the statutory... I'm reading the third paragraph, please. Has not paid the statutory contribution since October 2020, which is also an offence under various provisions of the EPF Act. They deduct my salary. They deduct the PF contribution from my salary. They don't deposit the amount that they have deducted. They are supposed to put in their own share. They don't make that payment. On the last occasion, I had pointed out to section 11 of the Provident Fund Act. May I just request my lords to only see that?
Please understand this.
Yes.
I understand
please
the plight of this work.
Please.
And what you're trying to submit. But and in this repetition, under the surface area proceedings, this court cannot grant you any kind of relief. You have to go before the appropriate court. Court is already you have initiated the proceedings before the civil court. That's a forum. And if any action on the part of the deputy commissioner or anything is lacking in execution of that order, that's a separate petition for that.
But my respectful submission is insofar as my second prayer is concerned, where I have sought for a direction to the deputy commissioner.
What is that? What is that direction?
May I, my lord?
What is the direction?
Please. Page 13 of my writ petition. Issue an appropriate writ or direction order to the fifth respondent, that's a deputy commissioner, to act on the communication dated 27th August 2024. Places Annexure K.
What are your instructions on this?
Your Lordship, since the matter is pending before civil court and also...
No, not about the civil court. There is an order passed with the deputy commissioner labor.
As per the instruction...
Counsel for the petitioner.
Yes, my lord.
Or order passed for the deputy commissioner labor.
Yes, my lord, sir. The assistant labor, the deputy labor commissioner.
Representation regarding the issue, and the matter is also pending before civil court, and also industrial dispute tribunal. There is one more reference is also pending, that is 34.
No, you are not concerned with all
I don't
that.
have any authority to decide when the matter is pending.
You've already decided and passed an order. He's seeking execution of it.
Annexure J, my lord.
But as per my instructions, they have forwarded to their higher authorities for further consideration, Your Lordship.
You passed an order.
Yes, Your
Why
Lordship.
should you send it to the higher authorities? Once an
Because
order.
the instruction I received by the concerned
That's not the instruction. Please get instructions. What are you going to do with the, what are the actions that are taken after order dated 27/8/2024? It is for the employer to go, but not for the authorities.
Yes,
You have to implement this order dated 27/8/2024.
Yes, sir.
And what are the
It is-
steps taken? To that limited extent, please get instructions.
Yes, sir.
This is matter on,
Exactly.
that as far as the first relief is concerned, we can't grant any relief.
I understand what my lords is saying. My lords is also, my lord, I understand what my lords is saying. My request is only this.
Yes.
The amount, insofar as my second prayer is concerned, I'm not speaking to the first prayer at the moment. Insofar as the second prayer is concerned, my lord, what would happen is this. This total, this is admittedly, even as per the respondent number 4, who's the company, this is the only property that they own. Once respondent number 5, once the bank takes it over, sells it, the amount that they have themselves shown, which I showed on to my lords on the previous occasion, the reserve fund amount that they have put is 15 crores. Their loan is around 8 crores something. The total remaining amount will be around 7 crores. That amount gets liquidated, it goes back to the employer, my lord. I will never realize any of my dues.
And going before the respondents, the best course, the best legal advice to your client is go before the civil court.
My lord, we have,
Yes.
my lord, my only concern is this. Ultimately, if I do, if if the amount is returned, whatever balance amount may be, I'm not coming in the way of them recovering, my lord.
Can't
That's
be
not
done.
my,
It
that's not
can't
my
be
issue.
done. It is not legally permissible to do.
That's not my issue.
Lord's necessary application, so far as adjudication of claims is not permitted, so far as workman, but for sale proceeds, that claim can be filed before DRT once the sale proceeds.
That's what I'm telling you.
My lords, in this connection, my lords, I have two issues to bring before your lordships, my lords. I'm appearing before of the company, my lords. I'm placing my objections before your lordships. It can be taken as objections for
As far as
response.
the interim order is concerned, we'll take it.
My lord, may I make one request? Only one request. Even if they proceed with the sale, the amount that is in excess, my lords may please consider.
No.
This is the, my lord, I'll just finish my sentence, my lord, before my lords rejects my submission. Only to say.
I heard you.
I'm sorry, my lord.
I have
Only,
only
my
one
lord,
small-
my lord may consider.
No, my lord, I have-
156 workmen.
I'm repeating the same.
My lord, I have a new issue to be
156
brought before your
workmen, my
lordships.
lord.
May
Have
kindly
they
hear.
challenged that order? They don't
That's
challenge
what I
it.
told you. We understand the difficulties, but within the legal framework, we
Yes.
can only give them the relief. This is not where we can give the relief. Your client will get the relief. The interim order. dated
Lordships,
so-and-so,
before you dictate my
vacated,
lordships, can
and
I
the
point out one
respondent-
provision of law under Surface Act, my lord? It is section 13(8), my lord, a proviso, which says that even if they realize under 529A, the workman should be given priority and their amount should be paid, my lord. If your lordship pleases,
My lord,
kindly
then I
look into
have
the
a
provision of that law, my lord.
My lord, if they are making.
I
a
request
submission in
your
favor of
lordship,
the
my lord.
workman,
I request your lordship to kindly go into this provision of law.
Who
And
you're appearing?
my lord, I'm appearing for the petitioner. I'm saying that I'm working out a settlement with the bank, my lord. In my objections, which I'm placing before your lordships, I'm saying that I'm working out with a settlement. I'm looking out for new investors and I have already identified some investors and I'll be settling with the bank, my lord. At the same time, my lord, these workers, as an officer of the court, it is my duty to bring before your lordships, my
I will
lord.
hear you on the next day. The interim order dated so-and-so is vacated. The bank is at liberty to proceed with the auction. The list is matter on 18th of November. By the date, the garment trader shall get specific instructions. Yes,
My lords,
May I
can my
only-
objections be taken on record, my lord?
file in the registry.
Lord, I
Yes.
think they appear on respondent 4, not on behalf of the petitioner.
No, my lord, I appear
I
for the
appear
petitioner.
no respondent 4. That's why I'm saying,
Petitioner,
No,
that is.
just now you said petition.
no, respondent 4, my lord. Only thing is
You
that
understand, understand what is the benefit you derive? from,
I actually don't derive
no,
anything
madam.
anything out of this, my
From
lord.
Not you.
Please.
What is the benefit she'll get from supporting the petitioner is she can stall the auction.
It appears.
Which
My lord,
is
there
not
is-
beneficial.
No,
for the
I'm not going to
petitioner.
stall the auction, my lord. My
We'll
only
see,
intention
we'll
see.
is
Only-
that
Next matter.
My lord, only one submission, madam. I'm sorry to interrupt. What my learned friend was saying, I think she only said it in terms of bringing the law, which I have also brought to the attention of this court. In terms of 529, the preferential payments in regard to the balance amount, the workers have preferential right over those payments, my lord. That may please be considered. If my lords could consider
on the
that,
next
that's all. I
occasion.
think that if
I
I've
guess exactly,
understood
that is
correctly,
what I-
that's
that's
what
what
she
my
has said.
intention.
On the next issue, we'll see.
I'm sorry, my
Yes.
lords.
When the matter comes up on the next date, we will see. Yes,
Because my lord, if it goes back to them, I will be placed
no,
without
again,
any
they
remedy.
have to issue the auction notification.
Please.
For all that, it requires some time. Yes, next matter.
Seal number 12, NR 9.
For petitioner method, I have sought for one-time settlement. They are not obliged. 53 lakhs is due, your lords. I am
Supreme
ready
Court
to pay
judgment-
now 30 lakhs rupees.
Supreme Court judgment that the High Court cannot pass a direction to
No,
the
no.
bank for
Now,
one-time
what happened,
settlement.
your lordship, they have put the lock and seized the house. We have separated because our belongings in the house, your lordship. I am ready to pay. I have offered on that day 25 lakhs, but they have not accepted. So therefore, your lordship, I am ready to deposit 30 lakhs and the remaining amount within 1 month I will pay clear. Because my children are unable to study, your lordship. All
Auction is
the,
conducted? Auction is conducted?
no, not yet.
Who appears for the respondent, Mr. Patil?
Bank is served, your lordship, but they have not.
Which bank is this?
This is a private bank, your lordship,
Divan
Divan
Housing
Housing
Finance
Finance Corporation. Because the annexure B kindly may be looked.
Presentation for the respondent. This is matter on,
Your lordship kindly may permit me to deposit the amount and
how can I, what is the
open-
right, why this court should pass
open the
such
lock, your
direction?
lordship, because I have sought for one-time settlement. They are not obliging for that.
Then I'll record that this court has no power to direct them to. So you please wait. When you have no legal right, you shouldn't argue.
Because my
Yes.
house is under lock.
That's
Your
what I'm
Lordship.
saying. You have no legal right. So you have to wait till the other side comes. This is matter on 6. No representation for the respondent.
Please.
Counsel for the petition is present. Yes, 13.
13.
I have filed an application for seeking
Continue,
extension.
Wilson.
I have filed an application for seeking extension of the time to, my lord, comply with the court order. And my learned friend made submission that, my lord, he is filing, he put his appearance in R3. And, my lord, my lordship has adjourned the matter yesterday's today. My lord,
Lord, there was another matter in which.
That is not, I think,
that is posted, my lord. That is
because there was an order.
Please,
There was
that has not been complied.
Time filed by advocate so and so.
That has not been complied with.
GMRES, that is.
Please, my lord. It was classified as GMRES, but
But
the
why it
challenge
is
was.
not listed? No, why can't we, I mean, dispose of this matter independently? Why should
Very
it be there? Why
That
why
is
should
there,
that
Lord.
also be there? Well,
Absolutely.
yes,
Petition is not pending.
yes. What is this?
my lord,
But the challenge is only to section 14 order.
Yes,
The section 14 order, my lord, where the petitioner is a co-applicant along with the respondent number 3. So
about the disputes between the wife and
they
husband.
have some disputes, but the account has become NPA in the month of 2024, July. Thereafter, all the proceedings under Surface Act was initiated, and the Honorable Magistrate has also passed an order, which is under challenge before this court.
no, my lord, I have made an application, my lord, admittedly, my lord, I have also obtained my lord, order under DB Act, not to evict me. Now, my lord,
then they will not be
I'm
evicted.
requesting this honorable court, I am being the co-applicant, my lord, now, my lord, I cannot even, my lord, exercise that order also, because I am being a co-applicant here with. Now, my lord, my husband with intentionally, my lord, has stopped, my lord, paying EMI. It is not that as if he is not, my lord, eligible to pay or all those. I do admit it is not the scope of this honorable court. Now, my lord, my submission before this honorable court is that somehow, my lord, R3 is also here. Now, I moved an application for, my lord, extension of the time. If
What
any,
time?
my lord, another, my lord, 1 month or 2 months if grants me, I will work out with my husband. If he's come out, my lord, to pay half of the amount and I'll pay half and we can transfer that because I'm having.
No, you are divorced or you're.
No, my lord, matter is going
So
this
we will do one thing till your MC, whatever you're going to file in the future, till it decided, we'll ask the bank not to do anything. I think that would serve the purpose.
He'll be more happy with that, definitely.
I do admit,
They'll be
my
more
lord,
happy
I'm
with
not-
that.
Probably that's what ultimately
No,
has
my
to be
lord, I'm
done.
not asking that, my lord. It's too much. I do admit, my lord.
No.
I'm residing there with my daughter.
We are this
May I
expanding
request-
the scope of the writ petition.
I do it. May I
It's not
request-
right.
I may
Not
request
right.
one more
The
thing,
thing
my
is
lord.
that
I
there
may-
is no auction proceedings or anything.
Yes.
I may request one more relief. My lord, let me, my lord, move an application to the bank for, my lord, removing me as a co-applicant. Let them consider that within, my lord, stipulated time, so that, my lord, I can, my lord,
What
I'll
kind of
vacate.
submissions
my lord,
are made?
my lord, I'll
Innovative, I
vacate the
must say.
premises. I'll vacate the premises.
I can't. Please come.
May I request that at least, my lord?
No. How can the bank say, no, please remove so and so as guarantor, so and so as co-applicant?
My lord, thing is that the husband, respondent number 3 is not very much well, my lord. He is having a salary.
Understand, madam, what is the power, what are the powers of the court?
My lord, I'm just seeking direction in my lordship.
You shouldn't seek something which is practically not possible to do.
Let them consider, if not, my lord, that
I will
also.
not, I cannot pass those kind of orders, yes. The present writ petition is filed, seeking the following prayer. The facts of the case are, the petitioner, the respondent number 3, or the wife and husband. Both of them have availed the housing loan from the respondent bank. The petitioner, along with her husband, daughter and mother-in-law, have been residing in the said flat since its purchase. In view of the disputes between the parties, both the husband and the wife are living separately. It is stated that the first respondent, at the behest of respondent number 3, issued a notice dated 25/20/24, calling upon the petitioner to vacate the flat. Then the petitioner has filed criminal miscellaneous number 85 of 2024 and obtained an order restraining them, obtained an order of protection on 12/7/2024. Thereafter, as the husband has failed to pay the amounts, the EMI, the respondents have classified the account as non-performing asset in July 2024 and issued a demand notice under section 13(2) of the Surface Act on 5/9/2024, claiming an outstanding of 1,21,17,951. Then counsel for thereafter, the possession notice on section 14 of the Surface Act was issued. Then counsel appearing for the petitioner submits that in view of the disputes between the wife and the husband is not paying the EMI, though he is in a position to pay the same. She has obtained an order in the DVC proceedings. Now, if the auction is conducted and if the petitioner is dispossessed from the property, it would cause a lot of hardship to the petitioner. It is also submitted that the petitioner is ready to pay. You said so. Petitioner is ready to pay the entire loan amount, and the property has to be. The documents have to be given to you. That's what you said the other day.
No, my lords.
That's not your case.
That was
Lord,
the submission
I said,
yesterday.
So the other day.
Yes,
I
that
said,
was the
Lord, I
submission.
said that we'll settle the dispute if 50-50 we can make out because we are having a daughter.
If it is submitted that if the time is given, reasonable time is given, she will settle the disputes with the husband, and whatever is the outstanding amount, they would be paying the bank. Hence, it is submitted that the bank will be restrained from taking any steps pursuant to the possession notification dated 13/4. Next paragraph. When counsel appearing for the bank submits that the writ petition is not maintainable, and if the petitioner has any grievance against the 13/4 notice, he has a remedy of approaching the DRT. It is submitted that the bank has nothing to do with the disputes between the husband and the wife. Next paragraph. Who appear for the husband?
I'm for the husband.
What do you say?
Well, Lord, I'm the owner of the property and she has no rights to seek such kind of relief from this honorable
So you
court.
say that let them take the property, you have no problem. That's what is his submission.
My Lord, I have given so many offers to her. I said that we'll give you 40 lakhs.
Then counsel appearing for the respondent husband. Your respondent number 2.
Yes, respondent number 3.
Respondent number
Three, my Lord.
Respondent number 3, husband submits that as the respondent has not paid the amount, paid the EMI, the account has been declared as a non-performing asset. And thereafter, he has not challenged any of the proceedings initiated by the bank.
Yes.
In fact, he has given several offers to the wife and they could not settle the disputes. Next part. Having heard the counsels on either side, but submission non-record. The petitioner, who also a co-borrower applicant, has come before this court questioning a notice issued under section 14. No legal grounds, no legal grounds are raised in support in seeking why the petitioner has come before this court, questioning the possession notice. Is it a possession notice?
It's a 14 order.
Order,
14
questioning
order.
the 13/4 order. What is the legality with the said order?
I'm sorry, my lord, it's section 14 order.
Section 14 order. What is the legality with the said order? Nothing has been stated. And under section 17(4) of, as for section 17, there is a remedy available to the party to approach the DRT if they are aggrieved by an order passed under section 14 of the Surface Act. The submission that the disputes between the wife and husband, and what are all the submissions that are made on behalf of the wife, this court cannot go into those aspects, and it is for the petitioner and the husband to settle their disputes before the appropriate forum. In these circumstances, this court cannot direct the respondent bank as prayed for by the petitioner. This court do not find any grounds to interfere with the with this order and accordingly dismissed. Next.
14. Narendra Gowda.
Made a submission, my lord, I will clear the entire loan within 3 months. Therefore, Lord should ask me to file affidavit.
Where is the counsel for the respondent?
I have
My lords, I appear for
copy.
the respondent in this case, my lords.
Have you seen the copy?
Yes, my lords,
That
we have seen the
affidavit?
affidavit, but the submission last time what was made was that 5 lakhs they are going to deposit forthwith. But in this affidavit, they are stating that 2 lakhs they will pay from 15 days from today, from the date of this filing this affidavit, which is not agreeable for the bank. So,
I said EMI I am ready to pay within 2 weeks. That is EMI due is according to them only 2 lakhs and odd.
no,
ready
it's
to
more
pay
than
that
5 lakhs,
amount
my lords.
within
It's more than 5
weeks.
lakhs, my lords.
And
Section
remaining
14 not is
amount,
under challenge.
within the entire amount within 3 months.
Let them pay this 5
Entire
lakhs and
due
let them move this matter, my lords. Thereafter, this matter can be taken up for this
When I am ready to pay
computation of
the
this
entire
45.
amount,
Let
my
them
lord,
pay
I
this
don't
5
know
lakhs
why,
first.
how the bank is going to oppose. Ultimately, they are interested about the recovery of the amount. According to the action notice, my lord, 51,000 rupees is the amount to be fixed, 51 lakh. I am ready to pay the entire amount. Rashma, can is the action notice at page 5 of the application. How can they demand 5 lakhs, my lord? EMI, according to them only, it is 2 lakhs and odd.
No, entire amount at the stretch, why? 46 lakhs.
Within 3 months, I will pay.
No, you should have like something like end of 1 month, 2nd month, 3rd month. It should have been like that.
I'm ready to split also. Rashmi, can you divide that by 3 installments?
Yes.
My lords, let him pay 5 lakhs first, my lords. That is the amount which is required for regularization. Thereafter, balance, let him pay within 3 months. We don't have enough, but let him pay first 5 lakhs because physical portion is with the respondent. As on today, we are taking the order is executed.
An undertaking is filed before the court stating that they're ready to pay 2 lakhs within 15 days. And the outstanding amount of rupees 46 lakhs, 36,004, the outer limit
That is,
of payments.
my lords, outstanding amount is what they have stated. We have different outstanding amount. Let there be outstanding amount which will communicate to them, my lords. That is as per their statement.
Now, with an outer limit of 3 months from today, then counsel appearing for the respondent bank submits that to regularize the portion is taken and to regularize some account, they need to pay 5 lakhs. If they pay 5 lakhs immediately, 5 lakhs and clear the remaining outstanding within 3 months, the bank has no objection. It is submitted that what is the outstanding as on today, they will be communicating the same to the petitioner. The petitioner, in the light of the submissions made by the respondent bank, the petitioner shall pay 5 lakh rupees and also the remaining outstanding after the communication received from the bank, whatever is the remaining outstanding, it shall be paid in 3 months. And in that regard, an affidavit shall be filed. This matter on 11th or 17th? 11th or 17th?
17th.
On 17th November, Mr. Lokesh,
My lords,
communicate it within 2 days.
Oh,
The
bless.
counsel for the bank communicate the.
Meanwhile, may I request, my lord, they have locked the premises. Let them open the
To pay
premises.
5 lakhs, we would have ordered it. That's why I will take it up on 11th. No, I will take it up on 11th. In the meantime, you pay, that day I will pass the order. Yes, 11th. This is the matter on 11th. Communicate to them within 2 days.
Obliged.
Yes, next.
15, Karan Gupta.
Well, this matter was heard at some length yesterday. I sought for time till today. KPID attachment. 3 short submissions and words. First is in the writ petition, another statutory violation ground which has been raised, apart from the alternate remedy, is that they were required to publish the Gazette notification. That was not done. Second, yesterday, my lords, for the first time, 2 case numbers were submitted before the court to say that these are the 5-2 applications which have been filed in a court in Udupi. We have done an entire case search. There is no such case before Udupi. I have gone and met the competent authority herself and asked for the case details. Both cases, my lords, are filed in the Bangalore Special Court, Court Hall 92. In relation to my specific property, the attachment order concerns a number of properties. Mine is only one of them. The competent authority has affirmed, my lords, that both 5-2 applications which have been filed are not in relation to my property, and that 5-2 application has not yet been filed. My submission is this, my lords. My lords may consider making it part heard. I want time to examine those documents. I will file an application to pull out those documents, my lords. I will examine in both of those numbers which were submitted by the advocate yesterday. If my property is in fact included in that, then my lords, I do have an alternate remedy. If it is not, then it is only the writ court that I can approach in this regard, my
What
lords.
is the relief that you're seeking? Please come to the relief. Notification dated, issued by the respondent number 2. Who is respondent number 2?
The government, my lords.
I'm for respondent number 1, 2, and 6, your lordship.
My ground, my lords, is when this notification is the one.
How this petition will come before this court?
My lords,
Yes.
classification, I am not aware as to how it's been classified as DRT, my
For
lords.
matters pertaining to securitization only will come before the court.
I-
Not the other matters.
I bow down, my lords. I have come on record just yesterday for the first time as an NOC counsel.
The registrar judicial shall verify. As this matter shall go before the court having GMRES.
My understanding is that this should have been classified as RES and gone before the roster bench.
It's
my
already
lords.
GMRES only described.
It's RES only, my lords. It's been listed before this court.
This is before the court having jurisdiction, no judicial disturbance. Listed before the court having jurisdiction. Yes, next.
I bow down, my lords.
Having roster of GMRES.
I bow down, my lords.
Yes, next.
16. Neeladhar.
Lord, it is a surprising matter. And for the respondent in this matter,
The amount they have issued notification, your lordship, it is internal page.
interim order has not
18.
been complied in this
I will
matter.
shell down entire amount which is issued under Annexure A. Tomorrow itself I will pay the amount. They are not receiving the amount.
Writ petition directed them to provide the writ petition copy in this matter.
They are not
Not
receiving
served
the
the
amount.
copy also.
First of all, give him a copy, then they will take the money.
Copy law.
Copy of the
Hotel.
petition, please serve on the council.
Copy, in the earlier, some advocates are
No,
appearing,
no.
they are appearing.
I am the
appeared
advocate,
also.
my lord, in this.
Huh?
I am the advocate. I only appeared in this matter.
And copy is also served.
Serve him the copy.
Yes, yeah, previous
This is
date you
matter.
were asked.
The petition is directed to serve the copy of the writ petition on the council for the respondent.
And it,
The respondent shall get instructions.
And-
This is matter on 10th of November.
Much okay.
Yes, next.
17th acquisition. 17th.
Yes, 17th.
In the meanwhile, you will serve the copy.
There is no interim order, my lord.
I will not grant any interim order, don't worry.
There's already existed interim order.
Next.
17 Arjan. 18. Putrabhushan.
So I pray for the respondent, like I pray for short accommodation, my lords, in this case.
In this case, my lords, this honorable court had directed the bank to state whether the limitation starts from.
Sir Lokesh, why are you seeking time? This is on
My lord, sir.
second or third occasion. On your request, the matter is being adjourned. Why
Yes,
should
yes.
we hear it repeatedly?
My lords, the paucity of time, my lords, I'll come there in person, my lords, short accommodation will be granted.
This matter as parted on 10th of November. No further adjournments will be granted. Already the matter is adjourned at the request of the bank on 2 occasions. Yes,
That's interim order.
interim order granted, earlier is extended till then. Yes, next.
19. Chetan.
I'm for petition of this case. So I'm for petition of this case. Already ordered for WP 722524. Notice has been passed. Notice has been passed the order 7225 WP 7225 for 24. So one more matter is there, madam. The golden
So first of
property.
all, what is this matter?
This is a property, but I need time, madam. 1 week time.
No time. We'll see what is that writ petition is coming up for the hearing. You should argue it. What is the time?
2 days time. I will
Direct the second respondent not to auction and to hand over position of the property and declare that the petitioner continues to be the owner of the scheduled property. What are these reliefs? High Court will declare that you are the owner of the property.
Kindly notice.
Declare that the entire business of the second respondent, HDFC Limited, was illegal and void in the state of Karnataka till 19/11/2019, since the second respondent is not registered in the Karnataka Money Lenders Act. What is this? This is matter on 10th, no further adjournment. What is the connected number?
WP
Write on a paper and give list along with so and so. Yes, 20.
20. Gubbi Swami.
Petition on this case.
Yes.
Lordship, I have served copy to the respondent.
Copy is served. The thing is, Lordship, they are
Let him say, what is it?
That's why I seek adjournment, Lordship. 1 week time and
My lord, the order of the OA passed in 800 of 2022 in DRT 1 had been challenged before Lordship.
What is the date of order?
31/7/2025. They have to go before the DRT. Instead of they approach this one.
What is the order of the DRT?
DRT's order at the page.
page number 18.
Order dated?
31/7/2025.
Page number 80.
31/7/2025.
In page number 18.
What is the order? The office is directed to
Order for the recovery of 25,42,000.
applicant bank shall file latest memo of calculation of OA amount together with interest to be paid by the defendant duly taking into account the amounts if any paid. So and so.
Lord, as per my
Issue
instructions,
recovery certificate as sought by the
my lord, page,
applicant bank in the OA and do the needful as required under the law forthwith.
my lord, page number 16 may kindly be seen. There is a number also been mentioned. There's recovery of 25,42,693.
Let's look at the grounds. Why they are before this court.
For them, the written statement filed by them, it is not been considered.
Order and the challenge. Then counsel for the petitioner seeks time. Then counsel for the respondent submits that this order is the order passed for the DRT is questioned and he has to go before the DRAT. This is matter on 10th. No further time will be granted. Yes, 21.
KV Lokesh.
Here for the petitioner in this case, Lords. Lords, I had filed a memo of withdrawal in this case.
In 21.
In 21 minutes. Lords, only I am seeking liberty for this reason, that the petition is filed seeking directions to police to assist me for taking physical possession of the property under section 14 of the SARFAESI Act. After filing of this writ petition, Milords, borrower has obtained a stay in DRAT. Now the matter is stayed by DRAT, Milords. So that's the reason I am seeking liberty to file a fresh writ petition. I will withdraw.
I'm not able to find your memo. Where is it?
When you are filed, sir?
Last date of hearing, it was given in open court. I'll file one more, Milords.
Have that.
Copy also.
Take that.
30th 10 your Lordship. I saw the copy.
Memo is filed seeking permission to withdraw the writ petition with the liberty to approach DRAT. Then counsel for the petitioner submits that the writ petition is filed seeking a direction to the respondent police to give necessary assistance to execute the order passed in criminal miscellaneous number 238 of 2022. The petition submits that the proceedings are challenged and the same is pending before the DRAT. Hence, the petitioner seeks to withdraw this writ petition with the liberty to approach DRAT.
No, with the liberty to approach this with the liberty to approach this court, Milords. In future, if DRAT dismisses the borrower's case, I'll have to come back before, if police does not assist me again, I'll have to come back before this court.
What kind of relief is that? You
Lord,
want to go before
yes.
DRAT? Go. Yes, dismissed.
22. Chaitra Nirmala.
Yes.
My lords, for the petitioner, my lords. My lords, I am a small scrap dealer, my lords. I had taken around 67 lakhs from this cooperative company, my lord, for bidding in a tender floated by MESCOM, my lord. But however, the tender didn't go through, my lord. It's in the tender didn't get completed, my lord. But my EMD of 50 lakhs got caught in MESCOM, my lord. It is to be released, my lord. And they are making necessary processes in MESCOM. Meanwhile, my lord, since I was not able to pay the same amount, my lord, with the bank, my lord. They have proceeded with the surface proceedings, my lords. And when this, this demand notice and possession notice, I voluntarily went and took it from the bank. It was not served to me. Anyway, I have received it. And to them, I have already given an OTS also, my lord, for 60 lakhs. I had increased my OTS to 70 lakhs also, my lord.
Who is the respondent?
My lords, in this, the bank, Mahalakshmi City Cooperative Bank is the respondent.
Mr. Vignesh is directed to take notice.
Lord,
And counsel the petition,
may
serve the
permitted to make
copy
one
of the
submission.
writ petition on the council. List this matter on
My lord,
17th
interim
of-
stay may kindly be granted, my lord. I have given 3 OTS up to 75 lakhs I have given, my lord. Let them consider it before proceeding, my lord.
There can't be a direction to the bank to consider your.
My lord, 87 lakhs is the outstanding, my lord. I have come up to 75 lakhs, my lords.
Him come up with instructions.
My lord, I am ready to make payment also. I am ready to make payment.
They came before this honorable court in earlier rounds.
What has happened to that?
This honorable court dismissed the writ petition, relegated the matter to TRT.
Was it stated in the affidavit now?
No, it is in the order only, my lord. My lord, the copy of the writ petition.
Give him a copy of the writ affidavit. Give that. Give that to the writ petition.
No, I'll give you. I'll give it.
My lord,
Where is the earlier writ petition mentioned? In the affidavit, in the petition? Dated 9th June 2025.
Yes, my lord, it's not mentioned here.
Why?
My lord, in that petition also, my lord, we had undertaken to settle the matter, my lord. There was no adverse order against us, my lord. We were only permitted to settle.
Necessary to, no, not necessary to mention it in this writ petition.
It should have been, my lord, but it has been missed. My lord, our only intention is that we have to settle, my lord, against 87 lakhs, we are ready to pay 75, my lords.
The writ petition is filed. Sing the following prayer. The learned counsel for the petitioner submits that.
My lords, we are ready to pay 10% in another 10 days, my lords.
That the petitioner had obtained the credit facility from the respondent bank for the purpose of applying for tender in MESCOM and paid a sum of rupees 50 lakhs towards the EMD for the tender floated by MESCOM. However, the tender process could not be completed. The huge EMD of rupees 50 lakhs, which had been paid out of the credit facilities obtained with the petitioner from the respondent bank, was held up with MESCOM. Thereafter, the bank has issued a demand notice dated 13/12/2024 that this was only given to the petitioner when they had contacted the respondent bank in its usual course. Meanwhile, the petitioner suffered from acute exculpation asthma viral pneumonia and was admitted in hospital due to this reason. Petitioner suffered a lot, both personally and also financially. And the petitioner could not maintain the business. The petitioner has made request to the bank and the petitioner bank, without considering the request of the petitioner, had proceeded with issuance of question notice dated 7/4/2025. The petitioner, subsequent to availing the loan, has repaid to the bank, which is not properly adjusted towards the principal loan amount. The bank went on adding interest on calculating interest on the entire loan amount without deducting the repayment from the total outstanding amount, and now arrived at a wrong figure of 78,72,169 and issued a question notice dated 7/4/2025. He stated that they were also, they wanted, they requested the bank for a OTS settlement and gave a settlement letter on 12/7/2025. Hence, a proposal is under consideration.
And even after that, we have increased the proposal to 75,
Which I am
my lords.
disputing, my lord. There is no OTS pending. before the bank.
Earlier, it is, land council submits that, there may be a direction to the bank. Land council appearing for the bank submits that. Earlier, the writ petition has filed, WP number 13686 of 2025. Questioning this position notice dated 13/4. Notice under section, for notice dated 7/4/2025. And it is, a submission is made before the court that 20% of the outstanding amount would be paid.
Which is not paid.
No, we'll
within a
pay. We
period
are ready
of,
to pay.
4 weeks. The court has observed that, taking note the Surface Act contains a statutory scheme and any right of the petitioner must be by taking reports of remedy available under the Surface Act. Petitioner has to invoke the provisions of the Act for appropriate decision. Accordingly, the court has granted 4 weeks' time until such time as directed the respondents not to take any coercive steps, and all contentions of the petitions are kept open. Liberty is reserved to the petition to take appropriate action against the impugned action in terms of the procedure prescribed under the Surface Act. This order is dated 9 June 2025. Now again, this writ petition is filed, where except the OTS proposal, there is nothing, no new facts are stated. When the earlier writ petition was disposed of, giving liberty to approach the DRT, and the court has passed an order directing the bank not to take coercive steps till 4 weeks. The petitioner has come before this court by filing this writ petition, by suppressing the facts. A person who has come to the court with suppression of facts is not entitled for any relief from this court. That apart, the earlier writ petition has been disposed of, directing the petitioner to avail the appropriate remedy. On these counts, this court do not find any reasons to interfere. Accordingly, dismissed.
My lord, it is my only residential property that is involved, my lords. I am ready to make payment with 20% within 4 weeks, my lords.
This 20% this is what you have been saying.
No, my lords, now I have found out an investor
I would
to
have-
dispose
I
my
would
property,
have-
my lords.
I would have at least considered about your proposals, provided you would have come, you would have been, if you have fair to the court.
My lords, there has been no suppression as such. My lord, I have not mentioned it here, but there was no adverse order against me, my lord, which
You
my,
have an order, it is
which
not
my
about
council
adver-
will also agree, my lord.
There is a favorable order to you. The court has directed the respondents not to take coercive steps till 4 weeks.
Yes, my lords.
Permitting you to go to the DRT. No, you don't raise no other new grounds.
No, my lords,
With
I
the
don't want to
same
go to,
grounds,
my lords,
you
I
come
don't want
here.
to contest them, my lord. I want to make payment. I don't want to contest all their measures, my lords.
If they're interested, you please pay the payment.
Yes, my lords. Until then, my lords, until just
I will
4
not
weeks,
grant
my
that
lord.
kind
That is
of
all we
order.
are
Yes, can you
praying,
go?
my lords.
Next matter.
And which the bank will also be readily to accept, my lords.
Not to the petitioner like this. The court will exercise the discretion. Yes.
23, Abhishek.
For the petitioner, my lords. My lords, petitioner was successful bidder, my lords. She had purchased the property e-auction, my lord. She had made a payment of 25% also, my lords, of 52 lakhs. The bid amount was 2 crore 8 lakhs and she had made a payment of 25%. Thereafter, my lords, there was, kindly, my lords, the schedule may be looked into, my lords. That is at page number
Crashing the
13, my
con-
lords.
Yes.
There they mentioned
One-
south by road.
Communicating quashing the endorsement dated 17/9/2025 issued by respondent number 2.
Please.
What is that communication?
Communication, my lords, I made a communication and they issue me an endorsement saying that amount has been forfeited. My lords, my problem was, my lords, I had made 25%, substantial amount was paid, my lords. Thereafter, my lords, there was no roadway to the property.
25% is not the substantial amount.
But thereafter, my lords, there was no roadway to the property, my lords. Kindly look into the photographs, my lords, 24 and 25, page number. When I went to the property, that roadway itself is not there, my lords.
When will you verify the property?
My lords, initially there was, my lords, initially, this, kindly look into the picture, my lords, 25. That looks like a temporary structure, my lords. It was put thereafter, my lords.
We cannot decide all this.
My lords, I'm even ready to make the entire payment tomorrow, my lords, if the respondent bank comes and says that they will clear the roadway. I'm ready with the DD, my lords. I'm making the submission, my lords. In case if they,
Will be purchasing the property as and where condition.
please, my lords.
Then that's your responsibility to verify what is happening there.
My lords, this is e-auction, my lords. Initially there was.
Officer and State Bank of India, who appears? Mr. So-and-so, what's your name?
Malini Vinay. Malini Vinay.
So-and-so is directed to take notice on behalf of the bank. Learned counsel for the petition says the copy of the writ petition. And the counsel for the respondent shall get instructions. This is matter on 17th of November.
Please.
Yes, next.
24 to the petition. Lord, I question the sale for notice and my lord, I sought for mandamus to consider my representation for OTS. Lord, the loan amount is my lord 1.25 crores. I've paid my lord almost.
That cannot be granted, number one. OTS, we will not direct the bank.
And my lord,
It's
understand.
between you and the bank. Then what is the other relief?
I question my lord the sale notice. My lord, I'm ready to pay the amount, my lord, the loan amount is 1.25 crores. Admittedly, my lord, I have paid 90 lakhs and I'm ready to pay 1.25 crores.
Consider the representation dated 18/9/2025, that's gone. What is the next one?
That
Issue
is
a
the sale
request
notice.
Why should we quash the sale
My lord,
notice?
what I have a right to, my lord, they redeem the mortgage and I have given my representation that this is the amount
What is
I'm
the
ready
sale?
to pay.
When is the sale?
Auction notice is not issued yet, my lord. This is the sale for now. They will issue within a couple of days. I am ready, my lord. I have given them. I have submitted my representation requesting them to give a counter offer. Admittedly, my lord, I have paid 90 lakhs. The loan amount is 1.25 crores. I'm ready to pay one.
What is for this respondents?
It's an asset restructuring company. Notice me.
Hand summons or a notice? I'll not grant interim order. That's why I'm asking you to take out hand summons so
I'll
that
take
I give
out
a
hand summons.
short date. Yes, the petition is permitted to take out hand summons on the hand summons on the respondent 1 and 2 and file a memo. If the memo is filed, list this matter on 18th of November.
These.
Yes, next.
25, Manasara.
My lord, in this matter, my lord, the scheduled property, my lord, belonged to husband and wife. My lord, husband died.
Yes.
The children of the husband, children of the parties executed a release deed in favor of the mother. I purchased this property, my lord, under a registered sale deed as per Annexure B at page 27. Subsequently, after I purchased this property in 2006, my lord, bank issues a proclamation for sale of this property and attachment, my lord. I challenge the attachment. That comes to be dismissed. I file an application for the proceedings before the DRT. That is also rejected. Your lordship may kindly see last time's order that was passed on 22/7. The DRT has said, as per the impugned order, my lord, that I have purchased 50% of the property.
This
50%
petition is of
stands
the year
attached to the banks.
2021.
Yes, my lord. No. The thing is this: I am willing to pay money
there
from
any
the banks and
order?
purchase the remaining.
What has happened?
No.
Annexure L, my lord, the order was according to me.
Where is the impugned order?
But I'm only.
The annexure L,
If your
page number
lordship
88.
looks at the order that was passed last time on 22/7, I'm willing to pay the money to the banks and purchase the remaining 50% to regularize my title. Please look at last time's order, my lord, 22/7/25.
Annexure L, my lord, page number 88.
No, he's saying
Paragraph
about
number
some
4.
order of.
Paragraph 4 of the order dated 22/7. They will get money. I'm willing to pay the money and purchase the remaining 50%.
First, let me look at this order. What is the order?
The impugned order, my lord. The impugned order is rejecting my application to implead myself in the DRT proceedings.
AOR, I filed a, my lord, appeal against the order of the recovery officer before the learned presiding officer DRT at Bangalore. In that, my lord, my senior counsel client, my lord, petition filed a, my lord, interlocutory application. That got rejected, stating that my attachment is before their sale. If I'm wrong, my lord. Therefore, my lord, that learned, my lord, the honorable DRT rejected their application. That is, my lord, assailed before this honorable court. The issue is, my lord, whether my attachment is prior or, my lord, their sale deed is, my lord, which is, my lord, according to, my lord, DRT order, their sale deed is subsequent to the attachment which made in favor of me. Therefore, my respective submission before this. However, my lord, if they wanted to settle it, my lord, I'll inform to my client. I'll try to arrange a meeting. That is one aspect. My lord, in view of my lord order.
Last time, the order was passed. It is for you to submit before the court today. Is there any scope for any, as per the proposal set down before the court?
Last date, my lord,
My lord, in fact, I
I
even made a request to my learned friend saying that you please tell me who is the person in the bank, and my clients will go and meet them directly and try to see and sit down and negotiate. My friend did not give any name or any contact.
No, if they, can they settle now?
My lord, definitely, my lord. Ultimately, I have to recover from the borrower. If somebody, my lord, if my lord direct, definitely
I
will
have
settle
stepped
and we
into
can-
the
we
shoes
can
of the
recover
borrower,
property.
my lord.
Either I have to sell the property, I have to recover the money. Or my lord, the petition is paying, I can accept it.
You
It's
have not issued, no sale notice, nothing
No,
of
my lord,
issue.
it's an attachment made by the recovery officer. The recovery officer has to sell it because it is not for my lord surface. It's a
Sale proclamation
Whatever
is after the date of my
No,
sale.
we'll pass orders on the merits of it. If you're not, if there's any proposal from the bank or anything, any settlement is possible, tell the court or else I'll pass.
Have it
orders.
after a week's time, any date may be fixed.
This
I'll try
matter
to
on
take.
18th of November. By the time the learned counsel for the bank shall come up with specific instruction.
Grateful.
26.
Shivaram Bhatt.
Grateful.
Great.
Not appearing for the petitioner, my lord. Kindly, this matter may be taken up on 17th, my lord. Senior is not.
My lords, I appear for the
present here
respondent, my lords.
Yes, interim order.
Interim order.
Interim order
My
is
lords,
complied with.
as per the interim order, they have complied, my lords, and thereafter there's no payments been made by the petitioners, my lord.
We'll seek instruction, my lord. It may be taken up on 17th, my lord.
No, please tell the senior on 17th, we'll finally hear it.
Please,
My
my
lords,
This is
let them
matter on
serve the,
17th. No,
my lords, let
no
them
further,
serve the
huh?
petition. Let them serve the petitioner copy, my lord.
So you don't have papers from 24.
My lord, we
No, my
already
lords,
served the
they
proposition.
have not served, my lord.
This is matter on 18th. No further adjournments will be granted. Then counsel for the petition shall serve the set of papers on the counsel for the respondent 27.
27.
Interim order may kindly be extended, my lord.
Interim order earlier granted is extended. Isn't
Much
it? Yes, 26.
Appear for the respondent bank in this case.
The directed the respondent bank to seek instructions from last time. My lord, it is the petition by one of the LR, my lord, not by the principal borrower. She died, my lord, or guarantor also died. She is only the legal heir. My lord, 45 lakhs 50,000 is the loan. The loan has discharged 63 lakhs rupees out of this. My lord, according to their notice, is due is 40 lakhs rupees now, as of now. My lord, she made a representation. Annexure D, your lordship kindly look into in page number 50. In page number, running page number 50, please. Annexure D. She voluntarily made a representation, my lord, on 30/12/2024, asking the bank, my lord, to give some concessions and take the one-time settlement, and she is ready to settle the property, the loan outstanding. My lord, after 4 months, she made in the 31/12/24, they have not taken any decision. Thereafter, my lord, they have issued a notice under section 13(2). That also she is submitted because she is not only legal heir. There are other legals also remain there, my lord. The property is under litigation. My lord, there was an interim order by the civil court, my lord. The suit is prior to the loan, my lord. There is an interim order. Against the interim order, they granted the loan. Interim order is enforced, my lord. Annexure A, I produced, my lord. Annexure A. Annexure B, my lord, please. There was a suit pending prior to the loan. Interim order is granted. Thereafter, my lord, the deceased borrower has she mortgaged.
Yes.
My lord, after 4 months from the date of representation, my lord, they have not taken any action. Then, my lord, they have issued a notice under 13(2) that has been opposed by her. Again, she make a representation to consider my request and then take an action. That despite of this, all these facts, my lord, they have issued the notice under 13(4). Therefore, we are before the court, my lord, considering the annexure D is concerned.
Yes. Yes, Mr.
My lords, reply has been given to our order notices. She has given last annexure pagination dated reply dated 16/7/2025. My lords, in your position notice issued, alternative remedies available. Let them address all these grievance before DRT. My lords.
Reply is given after 6 months. It is not 13(3)(a) notice. We have issued the objection under 13(3)(a). That has not been complied within 15 days. They issued the reply on 16/7/2018, 25.
Say, for a 13-2 notice,
Yes, my
when
lords.
was the reply? 13-3A, reply, when was it given? Please
15
give
days.
only
13.
those 2 dates.
Lords,
When is 13-2 notice?
13-2, my lord, on annexure F, my lord, please.
Date.
That is dated, my lord, 16/4/2025.
16/4/2025, my lords.
My subjections are raised on 5/5/2025.
5/5.
My lord, please. That has been replied on 16/7, my lord, after lapse of 6 months. After 13/4 notice is issued, and thereafter they replied.
Yes.
My lords, this 13/2 notice is dated 5/5/20. Reply given by them is dated 5/5/2025. But kindly come to last page, last reply notice given by me, my lords.
When is it date? When is the date?
The date is 16/7/2025. But this
What time
this
you are supposed to give?
my lords, this notice was not this notice which is attached dated 5/5/2025 was never issued to me. There is no postal acknowledgement also provided before this honorable court. And kindly come to 16/7/2025. I replied to the other communications given by the borrower dated 31/12/2024, 6/5/2025, and 10/7/2025. For this demand notice, this
My lord, they have received the notice also. My lord, I have not produced the acknowledgement because they are not disputed. They are in the reply also. They are referred this in the letters. My letter
No,
on
we are not
31/12/24. My lord, please, your lordship taken in case
No,
annexure K.
why have you not filed your objections till now?
my lord, this is a fresh matter, my lords.
Hello, Bandi,
This
one
fresh
second.
matter.
Last occasion, my lord,
25/10.
they are directed instructions from the bank.
No, I have not been
Come on.
directed, my lords. Direct.
File your that acknowledgement.
Yes, I will produce it.
The respondent bank.
My lord, till then, my lord, my apprehension, my lord, they may take any course steps, my lord. They are not supposed to
Then
take.
counsel for the respondent, then counsel for the petitioner submits a notice is issued under 13/2 and 16/4/2025 under section 13(3)(a). A reply was given on 5/5/2025. For that, the bank's reply is dated 16/7/2025. It is submitted that, then counsel for the respondent submits that the 13(3) notice, there is no acknowledgement filed and they have not, it is a submission that they have not received the same. Then counsel for the petition submits that he has the acknowledgement and he filed the same before this court. This is matter on 24th of November. Till such time, the bank shall not take any coercive
My lords, the
steps.
interim order was declined by this court, my lords. Wide ordered 17/9/2025. Interim order was not granted by this court. Again, at this stage, my lords, let some committee condition may be
No,
imposed,
no,
my
my
lords.
lord.
Interim order
Notice
suspended.
ಮಾಡಿದ್ದಾರೆ. Notice has been issued.
Kindly look into 17/9/2025 order, my lords. Interim order was not.
The respondent shall file their objections by then. Yes, next.
28, Gopala, if
Yes.
Appearing for the respondent,
Submission,
my
Your
lord, they were
Honor.
supposed to file an
In
affidavit
this,
as to how they will clear the
in
entire
this
dues.
case, Your Honor, today is to be filed an affidavit from the petitioner. Petition is present before the court, and I will seek to time for 7 days, say 6 to 7 days. As on that day itself, I filed the 5 lakh rupees and also additional affidavit to complete the close entire loan amount within 6 weeks, 6 months. Because I am on negotiate with my another property for the sale, Your Honor. That is not going on. Within the 6 days, 6 to 10 days, I am ready to pay the 5 lakh rupees to the bank, and I filed as on the same day.
My lord, let them pay, my lord, 5 lakhs because even they've come approached and they've not made any payment. Dues are 32 lakhs. My lord, 6 months timeline is too long, my lord. It's an overdraft. Let them go and make payment next week, my lord, and then file an affidavit. Bona fides are not displayed by simply making submissions. They have to make payment.
Only it is an overrun facilities, Your Honor. It is not a loan. Overrun facilities to improve the business. But due to the corona, the entire business is to be collapsed, Your Honor. I paid within 8 days for 5 lakh rupees, and also on the same day, I filed an affidavit. Within the 6 months, entire amount is to be within.
Court can't pass an order which is not acceptable to the bank. 6 months time is it has to be make it within 4 months. And make this
No, I putting
payment.
into the.
Once you pay the 5 lakhs payment, then you file the affidavit, will pass an order.
Any date may be.
This is a matter on
17.
17 November, by the time the 5 lakh amount, if the 5 lakh amount is paid to the bank and an undertaking that the remaining outstanding will be paid within 4 months, then this court will consider the case of the petitioner and pass appropriate orders. This is
And also
matter.
directed to receive that amount, Your Honor, because the banker is not to take the
They will
amount.
receive.
Yes, my lord.
Yes.
There is no harm.
29, Nagarajappa.
But appearing for the respondent bank.
I pray for a week's time in this, my lord. There is some negotiation
Happen
going
in
place,
this.
my lord. My lord, sale notice date was fixed for August,
Sale
30th
has not
August, my
taken
lord.
place.
Sale has not taken place.
Why you are seeking every time?
It may be disposed as infructuous, my lord, because the,
What is questioned in this?
my lord, in the
My lord,
first.
in the first
yes,
petition, my lord, sale notice was been
sale has
questioned,
not
my lord.
taken place.
Where is the prayer?
Annexure V, my lord, page 78.
Prayer. Writ of, say, quashing the notice, auction notice dated 10/10/2025. That's the only relief
Please,
you're seeking.
it's become infructuous, my lord.
Huh?
The first petition becomes infructuous, my lord.
The present writ petition is filed, seeking the following relief. Auction was not conducted on that day.
No, auction was held, but there's no bidders, my lord.
It is submitted, the land council for the respondent on instruction submits that. On the day, as no bidders have turned up, the auction could not be concluded. The relief that is sought by the petitioner now is only with regard to the sale notice dated at 10/10/2025. Nothing so as for consideration in this petition. Accordingly dismissed as infructuous. Yes, next, what about the next one?
Lord, this
In
is a
this, my lord, I
possession
pray
of
for a
this.
week's time in this, my lord.
Huh?
I pray for a week's time, my lord. After an interim prayer, my lord, I have made a payments, my lord.
You have an interim order on 10/9/2024.
No, my
After-
lord, they have not complied it within the time frame, my lord. In fact,
After
they were
that, my
supposed
lord, I
to.
have paid 7,50,000. Apart from that, I have paid 4,55,000.
We'll hear it. We'll hear it.
Yes.
This is matter.
Let them serve a copy of the writ petition.
This
That
is matter on 18th of November. Land council for the petitioner shall serve with a copy of the writ petition on the council for the respondent.
30, Girish Kumar.
For the petition in this case, my lords. So two counts, my lords. First issue, my lords, is regarding the classification of the accounts of the petitioner who is an MSME as a non-performing assets, whether it can be done in terms of the notification, my lords, which is at annexure W. But I had sought adjournment, my lords, because of the non-availability of the senior, my lords, due to his ill health. I request to my lords to have it tomorrow, my lords, because today he has recovered. He said tomorrow he is appearing in the courts. That indulgence, if my lords could grant, my lords.
No, every day the court is showing the indulgence.
Please, my
Morning
lords,
Passover,
I'm very
after-
grateful, but in fact, my lords had adjourned it for twice, my
afternoon
lords.
adjournment, again Passover, again adjournment, that's happening.
Please, I understand that, my lords.
4 times.
Only to,
This is matter on
My lord,
10th,
my lord, my
on
lord.
that day. Huh?
Tomorrow, my lord, 33 crores, my lord, outstanding.
I have given undertaking.
This is
What's
matter
it
on
as?
6. This is matter on 6. On that day, even a Passover will not be considered by the court.
Understand that.
Yes?
Please,
My
great.
lord, they post it for preliminary hearing or something like preliminary hearing so that it comes up in the list, my lord.
What do you want?
Let it be posted on a preliminary hearing list or something like that so that it comes up. Otherwise, it will come in the end of the list.
Yes.
Interim order may kindly be extended.
This interim order already granted the extension.
Very grateful.
Which one? 13. Where is that? Oh. Where is that? Oh. Oh. What happened? I think they were saying that some matter has to be listed along with this. We'll see next time. Yes, call the password matters.
First door cases. List number 1, serial number 12.
The
Jay
petitioner,
Shetty.
at the interim maintenance amount of rupees 20,000, 10,000 to the respondent
serial
and the
number?
child mother. Mother, the twelve mother.
Yes.
Yes, ma'am. But there is already an order against the respondent to, for restitution of conjugal rights, my lord. But that order is dated 9/11/2000.
What is the impugned order?
Impugned order is interim maintenance, my lord, of rupees 10,000 per month. That is at page number 33, my lord.
30?
33.
Yes.
The petitioner is hereby directed to pay rupees 10,000 per month each to the respondent and her minor daughter.
So 20,000 is awarded.
20,000. Not the petitioner is an auto driver and his monthly income is itself is 20,000.
What was,
and
have
the-
you filed your statement of assets and liabilities?
Yes, please, ma'am. We have mentioned and we have,
Was it stated before the court?
yes, please, ma'am. It is mentioned in the,
Petitioner is working as a,
he's an auto driver, ma'am. The respondent, ma'am, is working in the apartment and as a maid. And she is earning, ma'am, and the child, ma'am, it is in the custody of the respondent, ma'am. But he is only earning 25,000. I have produced the assets and liabilities and the contention of the respondent that she is having loan.
though he contends that his monthly income is 25,000, the bank statements depict that his income is more than that.
More than that, 35,000 it is mentioned, ma'am. But
The
the
total
thing
credit
is,
of the
ma'am,
amounts to the amount of the petition is around 35,000.
35,000, that is the contention, ma'am. Ma'am, my submission is, the son is also with the petitioner, ma'am. He is also having auto. And in view of the fact that he should not misuse the amount and that amount also, auto amount also, the business amount also coming to his account, that is also mentioned in the of the petition and this one.
No. The maintenance is granted to the wife and
Wife and daughter, mother.
daughter is aged about?
Daughter is, now it is 17 years, mother. The daughter is
So
aged.
referring to some son,
Mother,
just so you said son,
son, one is one son and one daughter, mother.
son is with you.
Son is with me and daughter with the respondent. Mother, the daughter is minor, 17 years. Son is mother major and he is having an auto, mother. His income is also coming to my account. Mother, my submission is the respondent is earning, mother. Mother, child, mother, I am liable to pay, mother. Order maybe I am agreeable. Mother, the respondent is earning and she says that the 18,000 she is having a loan for buying for the loan of the housing loan. Mother, that much capacity she is having and I am only an auto.
Petitioner submits that the court has granted 10,000 to the wife and 10,000 to the daughter. 20,000 is granted. He's working as an auto driver and his earning is 25,000 per month. It is submitted that the wife is earning and all these aspects were not considered by the court. Considering the submission of the petition, they should be stay of all further proceedings on the condition that he shall pay 10,000 by 5th of every succeeding month and the arrears also at 10,000 within 8 weeks. The petitioner shall take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 27th of November. If he fails to pay the file the memo, the stay granted by this court stands vacated.
Please.
Yes, next.
List number 3, seal number 17. Vijay Kumar.
Yes, where is he, Mr. Vijay Kumar?
From last two occasions, yes,
Hmm?
from last two occasions, he has not turned up, my lord. And also.
What is this order?
It's owner's liability, my lord.
And
Owner's.
with the petition on the Motor Vehicles Act is hereby partly allowed. Again, respondent
My
is
lord.
entitled for compensation of
9/1/25, my lord, 50% amount is deposited, directed to deposit, not yet deposited, my lord. And also kindly see 27/2/2025 order, my lord, kindly.
Oh, there is no. There are no proceedings. What is this?
Yes.
Oh.
27/2, kindly. 27/2/25.
On the last occasion, and even today also, there is no representation on behalf of the petitioner. Tomorrow, list this matter on the top of the list as part heard. Yes. Next.
By 18, Ashwath.
Appearing for the petitioner. Case of the injury, my lord.
Where is the table?
Para 20, table 44,
44.
40?
4.
The petitioner has suffered 5 grievous injury, my lord.
So
So I'm challenging
how
only
many
the towards pain and suffering.
What has happened in this
That
case?
is only
Milord?
25,000.
Yes.
Stiffness in the right shoulder.
To know what are the injuries?
That's what, Milord. Para 26.
Grievous injuries.
Grievous.
One fracture is there.
40,000 will grant.
But what has happened? 8% disability is taken. 40% future prospect was granted. Future prospect was already granted. Still, they have a private appeal.
Then no. If he wants it that way, we'll calculate. We'll
I
calculate
leave,
and
I
the
leave it to
calculation,
Lordship.
I'm okay, my lord.
I leave it to Lordship. Your Lordship.
we'll dismiss it.
Much obliged.
The agreed with the award passed in MSC number 813 of 2019, dated 16 January 2024. The claimant is before this court seeking enhancement of the compensation. The claim petition was filed seeking compensation of
10 lakh.
12 lakhs.
12 lakh rupees, and the tribunal has granted compensation as per the table given below. Extract the table at this 44. The land counsel appearing for the petitioner submits that the court has not granted a just and reasonable compensation under the head of pain and suffering, and even on the other heads also the compensation needs to be enhanced. Land counsel appearing for the respondent insurance company submits that when the disability is 8%, the court had granted 40% future prospects, and all of the counts, the amount of compensation that is awarded by the court is on the higher side, and no enhancement is called for. Next, having heard the counsels on either side plus the material on record, has rightly submitted with the land counsel for the insurance company for a disability of 8%, the court has already granted 40% future prospects. In these circumstances, the compensation, there cannot be any enhancement. Hence, the appeal filed with the claimant is dismissed.
Much
Next.
obliged.
Number 20, Muralidharan.
Respond 1 to 3 claimants. my lord.
Yes.
I prefer the appellant, my lord.
What do you say on that? Their liability is as per the, what is the?
I have arrived at the calculation.
They are claiming only as per the declared wages, 12,000, therefore, to that extent, we are liable. The trial court had that minimum wages, 15,000, the insurance company is liable to pay to the extent of 15,000 per month. The trial court has taken the income alert.
Your Lordship, as per the policy which has been produced and marked as.
No, it is not, it is about the policy.
Yes, ma'am.
It is
Liability,
true, ma'am.
as per the policy, the liability.
Only as submission, only what the trial court has taken, only answer.
No, do you agree on that?
As per declared, because conductor declared wages, their company is liable to the extent. But they have not adduced any evidence, therefore the court has taken that minimum, as per the minimum wages act, 15,000.
Policy has been produced, ma'am.
As per the liability under the policy of insurance. Wages agreed, rupees 12,000 per month. 12,000 into 50%, the factor is 13 lakh. It's a case of death.
Yes, my lord.
13 lakh 1,460. And how much is granted?
There was 16 lakhs 26,825, madam. The trial court has taken 15,000 income.
So
Relevant
that's the difference.
And also awarded interest, my lord. I am not liable to pay the.
Interest, insurance company is not liable to.
The remaining amount is owner is liable to pay, my lord.
That will pass.
Please.
Where is owner is served in this? This is serial number?
They have filed dispensation memo.
What is to be done now? You filed dispensation memo. The order dated 28/2/2025. The notice to, which is the respondent?
Respondent 4 and 5, my lord.
4 and 5.
4 and 5 is dispensed with. Learned counsel for the petitioner, respondent as well as the petitioner submits that the owner is a necessary party as the remaining amount needs to be paid by the owner. Hence, the order dated 28/2/2025 is recalled, and the petitioner shall take out, shall pay the process for issuance of notice to R4 to R5.
Please.
Keep it in this. Yes. Next.
23, Shantaraj.
Second response to insurance company. May I answer it? Council,
Is seeking enhancement.
Yes, Your Lordship.
Tomorrow, this is matter tomorrow.
May I request day after tomorrow, I have some inconvenience. Kindly
Day after tomorrow,
utilize.
yes.
24, B.S. Sumesh.
In this calculation to be made or calculation is already done?
No, my lord, calculation has to be done
Calculation.
and.
On the legal aspect, as far as your appeal is concerned, it is now, the submissions are made.
Yes, my lord. I have no liability in view of the Supreme Court order. My lord has also taken the view that my company is not liable. In one
Lakshmana
of
case, my lord, that
Pradeep's matter, my lord has taken notice, my lord, I cited the judgment, latest judgment of Supreme Court, where they say, my lord, if the owner has the knowledge of the cancellation of policy, it amounts to cancellation.
but in this case,
That judgment I have cited.
You are saying, but I have not accepted that day. What is
That
that?
of course,
You said, no, that day, if I remember,
yes,
some judgments which I have passed were also placed before me. And in
Yes.
the light of that, I said your appeal on that ground will not survive.
No.
I never said that you have no liability.
my lord, may I kindly see the Supreme Court.
No, before going into all that,
Yes.
only one question is that now you have cancelled the policy.
Yes.
Whether it is communicated.
Yes, ma'am.
Have you filed the acknowledgement?
Not the
No, my
acknowledgement, I filed the receipt, my lord, that
It
is,
is not sufficient.
in similar situations, Supreme Court has accepted it. That is what I am trying to say.
You have placed that judgment, I have seen it.
Yes,
Yes, there are I have also passed an order basing on a judgment of the Supreme Court,
yes.
which is the other way around.
My lord, Pradeep's matter, my lord has taken the view that that is.
Where is that?
My lord, I shall place it. My lord. I'll get, in fact, Pradeep also argued on my behalf the other day. Your lordship has taken that view, that notice, my lord. If the owner has the knowledge, it may.
Tomorrow.
My lord, day after.
Why there should be some amendment to everything?
tomorrow, please, my lord, day after no.
Yes, next.
Much obliged.
25, Ashok N. Patil.
Ready?
Very easy.
You're on what ground?
Liability, my lord.
Liability.
Yes, ma'am. My lord, this
Why
is
you are
the-
not liable?
My lord, this is the appeal filed by the insurance company. There is a 19 days delay in filing the complaint, my lord, before the jurisdictional police. And immediately after the accident, they are admitted to the Chamraj Nagar hospital, my lord, wherein it is clearly discloses that skid and fall from the two-wheeler, my lord.
Is this matter on 14th? Not 14th, this matter on 12th.
Much
November 12th. Yes.
26, Gurudev Prasad.
Three appeals by the rider and pillion riders.
So Gurudev Prasad, at least 15, 20 memos of yours every day. Why today you forgot? No memos are given?
All earlier part of the 2024 matters.
No, I have the roster of 24, 25, they will only come. Why to give the memos? Yes.
Rider and pillion riders have filed the claim petition. The trial court dismissed the claim petition saying that the involvement of the vehicle has not been proved. They were riding the motorcycle and the car.
Also on 19th. Yes, next. 27.
27,
Claimant appeal for enhancement, the case of death.
Case of death.
Case of death, my lord, the income.
Yes, Mr. Shivanagoda. Will consider. It's a case of death. Ravi Samprati is appearing.
Nobody is. Which case? Which company?
What is the age?
My lord, the age was, my lord, 30 years as on the date of accident.
Who is the advocate?
Ravi Samprati.
Please.
Yes.
My lord, age 30 years, my lord.
How much? 30 years.
30. My lord, the income taken by the tribunal 17,500, my lord.
Here is the accident.
My lord, the accident taken place in the year 2018, my lord. My lord, as per exhibit P 17 to 19, my lord, the earning, my lord, per month 34,000, my lord.
Then the council needs to be there. Respondent.
Please,
Yes, this on 12th of November.
please.
Yes, next, 28.
28.
Here for appellant, my lord. In this case, recent judgment of the upper court is to be referred. Negligence of the on the part of claimant who dashed against the parked lorry in the night. I want to go through this judgment.
What is it?
The 20% contributing.
Contributory negligence is to 100% contributory negligence is fixed by the apex court, my lord. Lorry was parked in the night, dashed against the car.
Not consumed alcohol.
No. Consumed, not that.
This on 19? Yes. 29?
29. Ravi Shankar Shastri.
Appearing for the appellant, my lord, on two grounds, my lord.
Singh is not here. This is matter on 19. Next, 30? Yes,
30. Kenchegoda.
Yes.
Case of death, my lord. Date of accident occurred in 2022, my lord.
20?
22, my lord. As per tribunal is considered that notional income, my lord, I have produced the 7 RTC, my lord, is own land, my lord, is cultivated, my lord, is that considered.
Also will do some other. On, this is matter on 20th. Yes, 31?
31. Pradeep.
It requires for hearing liability issue.
Yes. List on 26. Yes, 32.
32.
This is a paint recovery order we have challenged, Your Lordship, because the company at the time when these appeals were filed, was a division court, division bench of this honorable court had passed 2 orders wherein they have discussed about Swaran Singh's case and all, and they have held that insurance company is not liable to pay. So these 2 judgments may kindly be taken on record, and I leave it to the honorable court to pass.
This is a matter on 26th of November. Yes, 33.
33. Rosa Perumal.
This is for enhancement.
We have given the
This is
offer
for-
for 1 lakh.
No, the offer for 1,20,000 is too less because the doctor has said that he's got 56% disability. A full disability is 18%, but the court has only taken 12%. Further,
Why 18% should not be taken?
even the amounts which were given is 15,000 for loss of the.
That we, no, what we have given, considering that.
And
give that.
And
no. Let's go. Please come to the table. Now, head of pain and suffering, how many are the injuries?
15,000.
How many are the injuries?
The injuries are, my lord,
How many grievous injuries?
there are fracture to the.
You don't have file?
I have lost my file, man. Last
Huh?
appearing there.
You thought the case is disposed of?
No, my lord, I have lost my file.
Oh, that's what, because it disposed of, you have also.
My friend was not appeared, that's the reason it is misplaced in the court itself.
I'll give you want the
what
order
are the
copy?
injuries?
The injuries are, my lord, he had a tibia and fibia, my lord, both. He's had 5 hospitalizations for implant removal
Well,
application.
Only what are the injuries?
Injuries, my lord, he's had
One fracture or 2 fractures?
2, my lord. There is. I have produced, in this case, the court has held that I have not produced the discharge summary. In exhibit P21, all the discharge summaries are there. So the lower court records may be required.
How many days was in hospital
Almost
claimant?
in 5 tranches, I've been there for almost 20 days.
20 days.
Yes.
The incidental expenses already 15 is.
15,000 only. Here and every year I've had surgeries to remove the implant.
We are not concerned with all that. 20
Yes.
days, 20,000. Medical expenses as it is.
Medical expenses is 12 lakhs. In that, there was some expenses which were shown as advancement. But still, the court has only taken 6 lakhs, 6 lakhs
As far as medical
29,000.
expenses are concerned, we will not again look into it. If you want, I'll remand the matter.
The matter
Because
may be remanded. then,
All
my
those
lord.
slips and all, we can't
Because,
look into.
yes, the matter may be remanded because there were more than 209.
The settlement was not happened.
Please come. The appellant is before this court. Agreed with the orders passed in MVC number 4750 of 2020 dated 2nd November 2023, whereby the court had granted a compensation of an amount of ₹10,20,566. Then counsel submits that the court has failed to grant a reasonable compensation. He submitted that when the medical bills are amounting to 12 lakhs.
12 lakhs.
12 lakhs, the court has granted only an amount of rupees 6,38,239. Then counsel appearing with the respondent insurance company submits that the court has granted a reasonable compensation. The submission that is made by the counsel for the petition appellant about the medical expenses and the bills, this court cannot do that exercise. Looking at the bills worth rupees 12 lakhs and odd, and hence considering the said submission, the order, the award date so and so is set aside and the matter is remanded back to the trial court for fresh consideration on all the fresh consideration, and is open to the parties to raise all the issues are kept open, and is for the parties to make the submission before the court. Without further notice, the parties will appear before the court on 1st of December. Within 6 months from there on, the court shall dispose of the matter. Yes, next.
34, Pradeep.
Yes, Pradeep.
It's a liability issue, not fake policy. We have given complaint. There is no agent.
Yes, list on 18. 35.
For the respondent, my lord, case of death, ready, my lord,
Death case,
calculations
my
for
lord.
reference.
Date of the accident 2022. Age of the deceased, my lord.
Turn it to him.
Yes, ma'am. Agreed.
I'll pass an order then.
Please, my lord, court order, my lord.
So in this,
Only two aid, my lord. One is income.
income is taken how much by the court?
15,000.
As per chart,
15,000.
15,500 as per the chart. And consortium only for the
Future prospects 40%.
is already added.
Added, my lord.
Comes to 6,200. $21,700. How many are the dependents?
Four
members.
Huh?
4 members.
Four.
1/4.
Comes to 5,425. It comes to 16,275 into 12 into 16.
16.
3,12,000. 31 lakhs 24,800. Yes, and
Consortium.
it is it should be 36,000.
1 lakh.
1,76,000.
No, loss of estate. This
Yes,
all
yes.
it come to funeral expenses and all will come to 36,000, and 10,000 legal expenses. 31 lakh plus 1,76,000 plus 36,000.
33,000, my lord, 16,500.
10,000. No, we make it 10,000. It comes to 33 lakhs 46,800. The agreed with the award passed in MBC number 1118 of 2022 dated 9 January 2024. The claimant is before this court seeking, the claimants are before this court seeking enhancement of the compensation. The tribunal has granted the compensation as per the table given below. Where is the table? At,
Page number 23,
paragraph
ma'am.
at page number 29. When counsel appearing for the claimant submits that the accident had taken place in the year 2018. No, 2022. 22, and instead of taking 15,500, court had taken 15,000, and under the conventional heads also, the amount that is awarded by the tribunal is not just and reasonable. Next, for when counsel appearing for the respondent insurance company submits the amount of compensation that is awarded by the tribunal is just and reasonable. Next, for having heard this so and so, there is a material on record. As this accident had taken place in the year 2022, this court is taking the income at 15,500. 40% future prospects would come to 6,200. then his income is 21,700. As there are four dependents, 1/4 has to be deducted towards the personal expenses, that is 5,425. And his contribution to the family would be 16,275 into 12 into 16. Under the head of loss of dependency, it comes to 31,24,800. Loss of consortium, 4 into 44.
Yes, ma'am.
1,76,000, and funeral expenses 36,000, and in the light of the law laid down in Megla versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of 33,46,800. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 31,31,000 to 33,46,800.
One submission, my lord. I may be permitted to file wakalat, my lord.
The petition, the respondent is the counsel for insurance company. Shall file the wakalat within 1 week from the date of, from today. Yes, next.
Rajendra.
36,
Yes.
Sayyid Abdul.
Yes, third.
Appellant in this case, madam.
Respondent is not there.
I have
On
served
19th.
copy on him.
Huh?
I have served copy on him.
19th.
Yes, madam.
Next, third, 37.
37, Vijay Kumar.
That's on 20th. Other side is not there. Venkatesh.
Contributory negligence.
40%
40% contributory negligence.
That's true.
fixed.
They have to be there, the counsel for the respondent. 38.
38.
Yes,
Appellant in this case.
Appealing for that.
take that. Calculation is made.
No, my lord, the injured
Case
was,
of death?
the
Injury,
injury
my
case,
lord.
my lord. The
It's a
injured
head
was aged
injury.
about 80 years, my lord.
90% injury, 90% injury, head injury. Doctor has assessed.
Conservative treatment, there
But
is no
the
surgery and all, my lord.
tribunal has awarded only
It
glove.
requires hearing. List on 19. Yes, 39,
39.
19,
Shashidhara.
39, 19, 40.
40.
Appeal for the
19.
appellant, my lord.
Yes, 19.
41. Ravi Shankar Shastri.
Yes, Shivanagoda.
I'm for the appellant, my lord. It is a case of death.
Yes.
Why?
Huh?
It is a case
Case
of
of death claim is by, he is a pensioner. Pension amount was taken at 17,336 para 30. Accordingly, court has taken 50, wife alone with the 50% was deducted.
Yes, ma'am.
Granted the compensation as per the, all other head malad, the compensation granted. Only
12. This 42.
Case of death, my lord.
This also. That's what. This one 12. 43.
43, my lord. This matter has been negotiated, 28 lakhs 80,000 lump sum. My lordship could pass an order, consent order may be passed. The claimants also prepared an
You
appeal,
want a judicial order to be passed?
consent order.
It is submitted by both the parties.
One more,
It is submitted with the land counsel for the insurance company and also counsel for the respondent that they have agreed to receive an amount of rupees
28 lakhs 80,000 inclusive interest.
28 lakhs
80,000.
18 or
80.
80,000 inclusive of interest.
Interest.
Yes.
My lord,
Amount in deposit shall be 4.
claimant appeal number may be, claimants also prepared an appeal.
What is the number?
MFA 2763 of 24.
MFA?
2763 of 2024.
Along so and so, both the appeals are disposed of in the light of this. Yes, 44. What about this?
44 only regarding the future prospect. Consider that 10%, only 25%.
I have not received the wakalat. I have to get the permission. That's the reason. It may be avitan on that day.
12. This is matter on 12. 45.
For the respondent, can be disposed of death case.
Yes.
Lord, case of death. Lord, date of accident, my lord, the 5/9/2022.
Date of accident?
5/9/2022. Claimed by my lord, the wife.
Taken how much?
Lord, income considered my lord 14,500.
It should be 15,500.
15,500. My lord, he was
49
working
years.
as a driver. Lord, we have produced the driving license extract also.
No, even if it is, as per the minimum wages act for the skilled, it is 15,000.
Please, my lord. Income, my lord, consider, my
So
lord.
now here it is taken as 15,500. You are in a better position. What is the age?
Age, my lord, 49 years.
25% future prospect.
25% is to be
Already
added.
granted, my lord, 25%
Yes.
future prospects.
15,500 into 25.
1/4 has been deducted.
1 minute. 15,500 into 3875. Is 19,375. How many are the dependents?
4%.
4%, my lord, 1/4
1/4
has been deducted.
Comes to 4843.
22,66,000.
1 minute, 1 minute.
Further, my lord, there is a small mistake in the calculation of the tribunal.
What is the multiplier?
13.
It comes to 22 lakhs
66,992.
92. Consortium 4 into?
My lord, consortium, loss of spousal consortium 44,000.
Hmm.
Loss of parental consortium
No,
88,000.
we are doing
Yes,
a
madam.
fresh calculation.
Yes, madam.
It comes to 1 lakh
44 into 4, my lord.
44 into 4.
36. Okay.
1,62,000. Plus 16,500, 16,500.
36 multiplied. 36 multiplied.
It comes to 24 lakh 88,992.
Please.
Please come. Agreed with the award passed and this is number 5277 of 2022 dated 29th February 2024. The claimants are before this court seeking enhancement of the compensation. The tribunal has granted the compensation. Where is the table?
Table, my lord, the paragraph 19 of the
As
judgment.
per the table given below at page 19. When counsel appearing for the claimant submits that this accident has taken place in the year 2022, but the court had taken the income at 14,500. It is submitted that he is a driver and court ought to have taken 20,000 as income. It is submitted that even on the other conventional heads also, the compensation that is awarded by the tribunal is not just and reasonable. When counsel appearing for the insurance company submits that the court has granted a just and reasonable compensation. Next, having heard the counsel submit the side, here is the material on record. This accident had taken place in the year 2022. Hence, his court is taking the income at 15,500. His age is 49. 25% future prospects would come to 3875. Then his income is 19,375. As he has 4 dependents, 1/4 has been deducted to the personal expenses. That is 4843. Then his contribution to the family is 14,532 into 12 into 13. Loss of dependency would come to 22 lakhs 66,992. And towards loss of consortium 4 into 44, 1,76,000. Funeral expenses 36,000. In the light of the law laid down in Nicola, so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 24,83,992. Accordingly, the plea is partly allowed, enhancing the compensation from 23,29,664 to 24,88,992. Yes.
Interest, my lord, 6%. Enhanced compensation, not carries interest 6%.
6% already given.
Always there in
Already
what
there.
you specifically say. It is for the insurance company to say if it is high. Yes, 46.
46.
46. 46. Connected appeal 1837 of 24 that has not.
Is not listed. List along with so and so on 19th of November. Yes, 47.
1837 of 20.
Give the number.
47.
Yes.
Malada.
This also.
Death case, madam.
This also on 12th. This on 12th. 48.
48. Jagdish.
Appellant in this matter, my lord.
This on 19th. Yes, 49.
My lord, appeal memo is not given yet.
49.
49.
Uh,
So next week I will request him to.
This matter on 19th of November.
Public.
51.
51.
Appear for the appellant, my lord. Respondent, my
Yes.
lord.
They want permission. They filed an IA for release of the amount.
Let's,
Uh,
it's a quantum appeal.
Respondent
my lord.
claimant, my lord. Gita Raj is for appellant.
We can withdraw then.
No, my lord. The major amount is the medical expenses, my lord. We are claiming, we are challenging that itself, my lord. We cannot.
Yes, list this matter on on 26th of November. Yes, 52.
52.
Appellant,
Take Kumar.
case of injury for enhancement, claimant appeal.
Yes, Mr.
Mulkun, sir.
Mr. will take up on 12th. 53.
53.
But I am for
Paper
appellant
wishes.
claimant's appeal only for enhancement, any date, my lord, convenient. Convenient.
12, 54, 12, 55, 12.
My lord, 53 date, my lord, date.
12th. 56 also 12. 57, 12.
58.
1 minute, 50, 58, 19.
Please.
59th also 19th, 60, 61, 62,
Malad
63,
61,
90,
oriental is notice served, no, none representatives. Serial number 61, Malad.
till 63, 19. Which one is?
61, Malad.
Oriental Insurance Company. Who appears Oriental?
Rajendra, I appeal.
Mr.
Rajendra Agde.
Mr. Mulkan is directed to take notice on behalf of the respondents of the papers on him.
My lord, 60 is in case of death, my lord. Short
60?
point is in 60.
60 is the death. 60 on 12th. 60 on 12th.
12th, my lord.
Yes. Any death cases? I mean, in the next week. Next 60, 64.
63.
Huh?
63.
63.
Also death case. 63 also 12th.
One multiplier has to be applied. That's all.
63, 12th. Then 64,
Appeal for appellant, my lord.
case of death or injury.
Death, my lord.
This also on 13.
Yes, much obliged.
65,
65.
case of death or injury.
My lord, 64 insurance company.
65.
No, my lord, 64 insurance company none has appeared, my lord. Tata AG.
Who appears for Tata AG? Mr. Mulkan is directed to take notice on whether the respondent insurance company. 65.
Much obliged.
List the matter on 26. 66.
66. Lingaraj.
66 on 26. 67.
67. Mallikarjun.
On 25th. 68.
68.
My lord, I am for appellant, my lord.
Yes, 68 on 26. 69.
69. Rajendra S.
Next 69 to, in 69 to 72, any death cases? 69 to 72 on
72,
on
72,
third-
72 may be directed if court okay, well. Shankar Reddy may be directed. Please.
till 72 on 3rd of December. For R1 Insurance Company, Mr.
Shankar
Shankar Reddy is directed to take notice of the papers on him.
Please.
Yes, next. 74.
74 appealing.
74.
Injury.
Syed Abdul
Injury case. 74 to 78 on 20th.
76 death case.
Death case 76. 76 on 12th. Yes, from 79 to 84. 1 minute. 79 to 84 on 27th, which is the death case?
79. Both are death case.
79. 79 on 13th. Yes. Then all these parted matters list on 6th. Parted matters on 6th.
List number 4 is.
Shall I take up the list number 4 or some other day?
One dispensation.
Huh?
I had to file one dispensation.
1 minute.
Dispensation I had to file.
For what? In which
Serial number
case?
20.
No, this list as it is tomorrow.
Tomorrow.
Let's this.
List number 4, serial number 2. Take steps. That's all.
Which case? List number 4. Serial number?
Serial number 2.
You could have mentioned from morning you are waiting. The list is matter. It is submitted that the petitioner has to take steps. A list is matter after 2 weeks. Yes. This list as it is.
Number 4, number 13 and 13.
Huh?
We have
Again, now if we start, that's why I don't adjourn.
No, there is a calculation.
Which one?
Number
Serial number 30.
30. List number 4.
List number, this is coming tomorrow.
Okay.
He is not in this case.
Monday, 13 and 13.
Tomorrow we'll
Or I
examine.
will submit, my lord.
Huh? Yeah, you submit, you keep it and submit on that day.
Please.
Yes.
So,
Any signatures?
with the lady,
Submission.
Yes.
List number 5, serial number 2, madam.
All are over now, all
No,
those
no,
matters.
madam, it came to be dismissed because my colleague could not appear. That is the only submission, madam.
What
It
to
was
do?
a- No,
Now,
it was, came to be,
already dismissal is a red carpet welcome. And for that also you don't come, what to do?
I
That,
apologize, madam.
List
Serial
number 2.
Serial number 2, madam.
In dismissal matters, list number 5, serial number 2, list it on,
Tomorrow I can ask.
tomorrow not possible.
Day after
List-
tomorrow, madam.
List that matter on,
Not because there is an action sale, madam.
or everything you can't have. 10th November. That's what, no DNP, list it on 10th. Yes.
with your ladyship's most gracious permission, I'm so sorry. Your ladyship has got such a heavy board. I'm taking accommodation. I filed a fresh matter. Could it be listed tomorrow? I'm in station.
Tomorrow, not today is this much, tomorrow is 200, it will cross. So,
Then I will
some
appear,
other-
then I will appear online.
Let it come, whatever the matter
Then,
comes, you can
then
appear.
ladyship may give a, if it is possible to give a specific date, then next week, any date, any date, he is with me only. Could it be on 13th? If possible, I'll try to come.
From next week, this TRT matters on 10th and 11th. That is on Monday and Tuesday.
Or 10th, let it be on 10th.
Have on 18th.
No, maybe on 10th. 10th, I'll try to come. Try to come.
Recall ಮಾಡಿ. Restore ಮಾಡಿ.
Madam? Sorry, the list number.